Wait, okay, there. Now is my microphone on? Okay. Hello, everybody. Welcome to Grow the Info. We are going to be seeing day 8 today of the impeachment trials in the Senate. We are still going to be hearing from Mr. President Donald Trump's defense. I know you can hear my kids being crazy in the background. Sorry about that. That's kids for you. Okay, so we are going to be streaming this. Remember, the articles of impeachment are linked in the description box down below. There is a PDF from the actual government file that details exactly what the articles of impeachment are. And there is also a much longer PDF linked that details some of the arguments that have been made on both the Democratic and Republican sides and views on these kinds of things. Yesterday, we heard a lot about the historical precedent, I guess, in our country and the founding fathers a lot, which the Democrat side had also referred to the founding fathers a lot. It's very interesting to see how the two sides can take, similar historical events to be kind of two different ways. They're both using them to, try to prove their side. So, I'm not exactly sure what they're going to be talking about today. They have already addressed the Biden and Burisma thing. I believe that was the first day of the defense's retaliation to the prosecution. And all of the previous hearings and everything are linked in a playlist on our channel that you can find if you would like to view all of those. And if our stream goes out for any reason, or if you are wanting to stream these hearings and trials yourself, you can find them at senate.gov. You do not need to use clips from mainstream media. You can just go to senate.gov and you'll be able to see it. So, they are about to start. I hope you're all having a wonderful day. Thank you so much for joining us here. And doing the impeachment trials and streaming it is something that I am doing in addition to trying to cover some other things still and bring some other information out. So make sure that you're subscribed and turn on bell notifications. That way you can be notified when I do my morning news live streams. Usually they're in the morning. And be sure to follow us on Twitter and Instagram at GrowTheInfo is our handle. I just a few minutes before going live, put out a whole bunch of recalls on Twitter that have gone completely unnoticed, of course, by the mainstream media in all of this impeachment hullabaloo. So I try to put things out on there that is more timely, time-sensitive kind of information. And you can check out our website, growtheinfo.com, to find press releases that a lot of times I'm not able to cover and the mainstream media is just ignoring. So make sure you check out that. We also have like a members message forum and stuff and all kinds of good things on there. So check us out. And I'm going to go ahead and turn the volume on the impeachment trial. They will start, of course, with a prayer and the Pledge of Allegiance. I'm not sure how long the stream is going to be going for today, but I am going to be keeping this stream up the entire time, even though there are some other House hearings going on, because I need some peanut butter and jelly. Because I need to go make some peanut butter and jelly. So I'm going to be busy making peanut butter and jelly today. So thank you guys for watching, and let's turn on the volume for them. And remember, guys, you guys being here, commenting in the chat, watching the replays, sharing on social media and everything, that is how this channel is able to grow. It's because of you guys, not the algorithms. You guys are what's helping us out. So thank you so much for that. Oh my gosh, okay.
return to our desk.
The Senate will convene as a court of impeachment. The chaplain will lead us in prayer.
Let us pray. Divine Shepherd, honor, glory, and power belong to you. Refresh our senators as they enter a new phase of this impeachment trial. May they realize that you have appointed them for this great service, and they are accountable to you. Lord, empower them to labor today with the dominant purpose of pleasing you, knowing that it is never wrong to do right. Give them resiliency in their toil as they remember your promise that they will reap a bountiful harvest if they don't give up. Help them to follow the road of humility that leads to honor as they find their safety in trusting you. We pray in your majestic name. Amen.
Amen. Please join me in reciting the Pledge of Allegiance to the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If there is no objection, the journal of proceedings of the trial are approved to date. Without objection, so ordered. The Sergeant-at-Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment, while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The Majority Leader is recognized.
Today, the Senate will conduct up to 8 hours of questions to the parties delivered in writing to the Chief Justice. As a reminder, the two sides will alternate, and answers should be kept to 5 minutes or less. The majority side will lead off with a question from the senator from Maine.
Mr. Chief Justice,
The senator is recognized.
I send a question to the desk. On behalf of myself, Senator Murkowski, and Senator Romney.
This is a question for the counsel for the president. If President Trump had more than one motive for his alleged conduct, such as the pursuit of personal political advantage, rooting out corruption, and the promotion of national interests, how should the Senate consider more than one motive in its assessment of Article 1?
Mr. Chief Justice, Senators, in response to that question, there are really two layers to my answer, because I'd like to point out first that even if there was only one motive, the theory of abuse of power that the House managers have presented, that subjective motive alone can become the basis for an impeachable offense, we believe is constitutionally defective. It is not a permissible way to frame a claim of an impeachable offense under the Constitution. But I'll put that to one side and address the question of mixed motive. If there were a motive that was a public interest but also some personal interest, we think it follows even more clearly that that cannot possibly be the basis for an impeachable offense. And even the House managers, as they have framed their case, they have explained, and this is pointed out in our trial memorandum, that in the House Judiciary Committee report, they specify that the standard they have to meet is to show that this is a sham investigation. It's a bogus investigation. These investigations there's not any legitimate public purpose. That's the language, any legitimate public purpose. That's the standard they've set for themselves in being able to make this claim under their theory of what an abuse of power offense can be. So it's a very demanding standard that they've set for themselves to meet. And they've even said they came up and they talked a lot about the Bidens. They talked a lot about these issues in 2016 election interference, because they were saying there's not even a scintilla of any evidence of anything worth looking into there. And that's the standard that they would have to meet, showing that there's no possible public interest and the president couldn't have had any smidgen even of a public interest motive, because they recognize that once you get into a mixed motive situation, if there's both some personal motive but also a legitimate public interest motive, it can't possibly be an offense. Because it would be absurd to have the Senate trying to consider, well, was it 48% legitimate interest and 52% personal interest, or was it the other way? Was it 53% and 40%? You can't divide it that way. And that's why they recognize that to have even a remotely coherent theory, the standard they have to set for themselves is establishing there is no possible public interest at all for these investigations. And if there is any possibility, if there is something that shows a possible public interest, and the president could have that possible public interest motive, that destroys their case. So once you're into mixed motive land, it's clear that their case fails. There can't possibly be an impeachable offense at all. And think about it. All elected officials, to some extent, have in mind how their conduct, how their decisions, their policy decisions will affect the next election. There's always some personal interest in the electoral outcome of policy decisions. And there's nothing wrong with that. That's part of representative democracy. And to go start saying now that, well, if you've got a part motive that's for your personal electoral gain, that that's somehow going to become an offense, it doesn't make any sense. And it's totally unworkable. And it can't be a basis for removing a president from office. So the bottom line is, once you're into any mixed motive situation, once it is established that there is a legitimate public interest that could justify looking into something, just asking a question about something, the manager's case fails, and it fails under their own terms. They recognize that they have to show no possible public interest. There isn't any legitimate public interest. And they've totally failed to make that case. I think we've shown very clearly that both of the things that were mentioned, 2016 election interference and the Biden-Burisma situation, are things that raise at least some public interest. There's something worth looking at there. It's never been investigated in the Biden situation. Lots of their own witnesses from the State Department said that on its face, it appears to be a conflict of interest. It's at least worth raising a question about, asking a question about it. And there is that public interest, and that means their case absolutely fails. Thank you.
Thank you, counsel. The Democratic leader is recognized.
Mr. Chief Justice, I send the question to the desk.
The Democratic leader asks the House managers. John R. Bolton's forthcoming book states that the President wanted to continue withholding $391 million in military aid to Ukraine until Ukraine announced investigations into his top political rival and the debunked conspiracy theory about the 2016 election. Is there any way for the Senate to render a fully informed verdict in this case without hearing the testimony of Bolton, Mulvaney, and the other key eyewitnesses, or without seeing the relevant documentary evidence?
Thank you, Mr. Chief Justice. The short answer to that question is no. There's no way to have a fair trial without witnesses. And when you have a witness who is as plainly relevant as John Bolton, who goes to the heart of the most serious and egregious of the President's misconduct, who has volunteered to come and testify to turn him away, to look the other way, I think is deeply at odds with being an impartial juror. I would also add in response to the last question that if any part of the President's motivation was a corrupt motive, if it was a causal factor in the action to freeze the aid or withhold the meeting, that is enough to convict. It would be enough to convict under criminal law. But here there's no question about the President's motivation. And if you have any question about the President's motivation, it makes it all the more essential to call the man who spoke directly with the President, that the President confided in and said he was holding up this aid because he wanted Ukraine to conduct these political investigations that would help him in the next election. If you have any question about whether it was a factor, the factor, a quarter of the factor, all of the factor, there is a witness, a subpoena away who can answer that question. But the overwhelming body of the evidence makes it very clear. On July 26th, the day after that phone call, Donald Trump speaks to Gordon Sondland. That's that conversation at Ukraine restaurant. And what does Gordon Sondland, what is the President's question of Gordon Sondland the day after that call? Is he going to do the investigations? Now, counsel, the President would have you believe the President was concerned about burden sharing. Well, he may have had a generic concern about burden sharing in other contexts. But here, the motivation was abundantly clear. On that phone with Gordon Sondland, the only question he wanted an answer to was, is he going to do the investigation? Now, bear in mind, he's talking to the ambassador to the European Union. What better person to talk to if his real concern was about burden sharing than the guy responsible for Europe's burden sharing? But did the President raise this at all? Of course not. Of course not. And if you have any question about it at all, you need to hear from his former national security advisor. Don't wait for the book. Don't wait till March 17th when it is in black and white to find out the answer to your question. Was it all the motive, some of the motive, or none of the motive? Now, we think, as I mentioned, the case is overwhelmingly clear without John Bolton, but if you have any question about it, you can erase all doubt. Now, let me show you a video, underscore number 2, slide 2, how important this is.
As House managers, really, their goal should be to give you all of the facts, because they're asking you to do something very, very consequential. And ask yourself, given the facts you heard today that they didn't tell you, who doesn't want to talk about the facts? Who doesn't want to talk about the facts? Impeachment shouldn't be a shell game. They should give you the facts.
Last video, which is even more important and on point for Mr. Bolton. Number 3.
And once again, not a single witness in the House record that they compiled and developed under their procedures that we've discussed and will continue to discuss provided any firsthand evidence that the president ever linked a presidential meeting to any investigations. Anyone who spoke with the president said that the president made clear that there was no linkage between security assistance and investigations.
No, that's not correct, right? Because, of course, Mick Mulvaney said that the money was linked to these investigations. He said, in acknowledging a quid pro quo, they do it all the time and we should just get over it. Gordon Sondland also said, the president said, on the one hand, no quid pro quo, but also made it clear that Zelensky had to go to the mic and announce these investigations.
Thank you.
Thank you, Justice.
Mr. Chief Justice,
Senator Thune.
I have a question for the President's counsel.
To the President's counsel, would you please respond to the arguments or assertions the House managers just made in response to the previous question?
Mr. Chief Justice, Senators, a couple of points that I'd like to make. Manager Schiff suggested that there was no evidence the president was actually interested in burden sharing because he didn't apparently, according to David Hale, raise it in the telephone conversation that he had with Gordon Sondland that Hale claims to have overheard at a restaurant in Kiev. But let's look at the real evidence. As we explained, on June 24th, there is an email in the record showing, it's an email from one person at the Department of Defense to another with a subject line of POTUS follow-up, President of the United States follow-up, asking specifically about burden sharing. It says, quote, what do other NATO members spend to support Ukraine, end quote. That was what they were following up on for the president. And in the transcript itself, excuse me, in the transcript of the July 25th call itself, the president asked, he said, we spend a lot of effort and a lot of time for Ukraine, much more than the European countries are doing, and they should be helping you more than we are. Germany does almost nothing for you. All they do is talk, and I think it's something you should really ask them about. And he goes on to say that he talks to Angela Merkel about it, and that they're not really doing as much as the United States is doing. He's raising burden sharing, and President Zelensky agreed with him. Now, Manager Schiff also suggested that there is evidence of some connection between the military assistance and investigations into 2016 election interference because of a statement that Acting Chief of Staff Mulvaney made at a press conference. But it's been clear in the record since that press conference that what he was saying was garbled and or misunderstood, and he immediately clarified and said on that day, quote, the president never told me to withhold any money until the Ukrainians did anything related to the server, end quote. And similarly, he issued a statement just the other day making clear again that he said, this is from his counsel, so it's phrased in the third person, nor did Mr. Mulvaney ever have a conversation with the president or anyone else indicating that Ukrainian military aid was withheld in exchange for Ukrainian investigation of Burisma, the Bidens, or the 2016 election. That is Mr. Mulvaney's statement. Lastly, on to the point of whether this chamber should hear from Ambassador Bolton. And I think it's important to consider what that means, because it's not just a question of, well, should we just hear one witness? That's not what the real question is going to be. For this institution, the real question is, what is the precedent that is going to be set for what is an acceptable way for the House of Representatives to bring an impeachment of a President of the United States to this chamber? And can it be done in a hurried, half-baked, partisan fashion without, they didn't even subpoena John Bolton below. They didn't even try to get his testimony. And to insist now that this body will become the investigative body, that this body will have to do all the discovery, and that this institution will be effectively paralyzed for months on end because it has to sit as a court of impeachment, while now discovery is done because it would be Ambassador Bolton, and if there are going to be witnesses, then the president would have to, in order, they said fair trial, fair adjudication, then the president would have to have his opportunity to call his witnesses. And there'd be depositions, and this would drag on for months. And then that's the new precedent. Then that's the way all impeachments operate in the future. The House doesn't have to do the work. They do it quick, they throw it over the transom, and this institution gets derailed and has to deal with it. And that should not be the way, that should not be the precedent that is set here for the way this body will have to handle all impeachments in the future, because if it becomes that easy for the House to do it, they'll be doing it a lot. Thank you.
The senator from Massachusetts.
Send a question to the desk.
Question from Senator Markey to the House managers. On Monday, President Trump tweeted, "The Democrat-controlled House never even asked John Bolton to testify." End quote. So that the record is accurate, did House impeachment investigators ask Mr. Bolton to testify?
Senators, the answer is yes. Of course, we asked John Bolton to testify in the House, and he refused. We asked his deputy, Dr. Kupperman, to testify, and he refused. Fortunately, we asked their deputy, Dr. Fiona Hill, to testify, and she did. We asked her deputy, Colonel Vindman, to testify, and he did. But we did seek the testimony of John Bolton as well as Dr. Kupperman, and they refused. When we subpoenaed Dr. Kupperman, he sued us, took us to court. When we raised a subpoena with John Bolton's counsel, the same counsel for Dr. Kupperman, the answer was, Senator, you serve us with a subpoena and we will sue you too. We knew, based on the McGahn litigation, it would take months, if not years, to force John Bolton to come and testify. And I should point out, because I think this is an essential point to underscore, as the president's lawyers say, they didn't try hard enough to get John Bolton, or they should have subpoenaed John Bolton. That's what they're telling you. But let me show you what they're telling the court in the McGahn litigation. If we could pull up slide number 39. This is the president's lawyers in court in the McGahn litigation. In the Court of Appeals right now, quote, "The committee," meaning our committee, "lacks Article III standing to sue to enforce a congressional subpoena demanding testimony from an individual on matters related to duties as an executive branch official." I mean, it takes your breath away, the duplicity of that argument. They're before you saying they should have tried harder to get these witnesses, they should have subpoenaed, they should have litigated for years, and down the street in the federal courthouse, they're arguing, "Judge, you need to throw them out. They have no standing to sue to force a witness to testify." Are we really prepared to accept that? Now, counsel says, think about the precedent that we would be setting if you allow a House to impeach a president and you permit them to call witnesses. Well, I would submit, think about the precedent you will be setting if you don't allow witnesses in a trial. That, to me, is the much more dangerous precedent here. But I'll tell you there's something even more dangerous, and this was something that we anticipated from the very beginning, which is we understood when we got to this point they could no longer contest the facts that the president withheld military aid from an ally at war to coerce that ally to doing the president's political dirty work. So now they have fallen back on, you shouldn't hear any further evidence, any further witnesses on this subject. What's more, we're going to use the end-all argument, so what? A president is free to abuse their power. We're going to rely on a constitutional theory, a fringe theory, that even the advocate of which says is outside of the consensus of constitutional law, to say that a president can abuse his power with impunity. Now imagine where that leads. A president can abuse his power with impunity. Now, that argument made by Professor Dershowitz is at odds with the Attorney General's own expressed opinion on the subject, with Ken Starr's expressed opinion on the subject, with not only other counsel for the president, Jonathan Turley, who testified in the House, says that theory is constitutional, effectively nonsense. But even 60-year-old Alan Dershowitz doesn't agree with 81-year-old Alan Dershowitz. And for a reason, because where that conclusion leads us is that a president can abuse his power in any kind of way, and there's nothing you can do about it. Now, are we really ready to accept the position that this president or the next can withhold hundreds of millions of dollars in military aid to an ally at war unless they get help in their reelection? Would we say that you could, as president, withhold disaster relief from a governor unless that governor got his attorney general to investigate the president's political rival? That, to me, is the most dangerous argument of all. It's a danger to have a president who would engage in this conduct. It's a danger to have a trial with no witnesses and set that precedent. But the biggest danger of all, I think, would be to accept the idea that a president can abuse his office in this way, and the Congress is powerless to do anything about it. That is certainly not what the founders intended.
Mr. Chief Justice.
The senator from Tennessee.
Thank you, Mr. Chief Justice. I send a question to the desk on my behalf and also joined by Senators Loeffler, Lee, Kramer, and McSally.
The senators ask of counsel for the president, is the standard for impeachment in the House a lower threshold to meet than the standard for conviction in the Senate?
Mr. Chief Justice, Senators, the standard in the House, of course, the House is not making a final determination in the structure of the Constitution. An impeachment is simply an accusation. And as in most systems where there is simply an accusation being made, the House does not have to adhere to the same standard that is used in the Senate. In most instances, House members have suggested in debates on articles of whether or not to approve articles of impeachment that they should have clear and convincing evidence in the view of the members voting on it that there was some impeachable offense, and that is all. Some not even that standard. And so it is simply enough evidence that an accusation can be made. It is definitely a lower standard than the standard that has to be met here on a trial for an ultimate verdict. The Constitution speaks in terms of a conviction in the Senate. And as both Professor Dershowitz and Judge Starr pointed out in their comments, everywhere in the Constitution that there's any mention of impeachment, it is spoken of in terms of the criminal law. The offenses that define the jurisdiction for the Senate sitting as a court of impeachment are treason, bribery, and high crimes and misdemeanors. The Constitution speaks of a conviction upon being convicted in the Senate. It speaks of all crimes being tried by jury except in cases of impeachment, again suggesting notions of the criminal law. And as we pointed out in our trial memorandum, all of these textual references make it clear that the standards of the criminal law should apply in the trial, certainly to the extent of the burden and standard of proof to be carried by the House managers, which means proof beyond a reasonable doubt. And it is very clear that there is not any requirement for proof beyond a reasonable doubt simply for the House to vote upon articles of impeachment. There's a very much higher standard at stake here. As we pointed out in our trial memorandum, the mere accusation made by the House comes here with no presumption of regularity at all in its favor. The Senate sits as trier of both fact and law, reviewing both factual and legal issues de novo, and the House managers are held to a standard of proving proof beyond a reasonable doubt of every element of what would be a cognizable, impeachable offense. Here, they have failed in their burden of proof. They have also failed on the law. They have not stated in the articles of impeachment anything that on its face amounts to an impeachable offense. And on the facts, I think we have demonstrated very clearly that they have not presented facts that would amount to an impeachable offense, even under their own theories. They have presented only part of the facts and left out the key facts. And Mr. Papura, I think, went through very effectively showing that there are some facts that don't change. The transcript of the July 25th call shows the president doing nothing wrong. President Zelensky said he never felt any pressure. His other advisors have said the Ukrainians never felt any pressure. They didn't think there was any quid pro quo. They didn't even know that the military assistance had been held up until the Politico article at the end of August. The only two people with statements on record who spoke to the president, who are Sondland and Senator Ron Johnson, report that the president said to them there was no quid pro quo, and the aid flowed without anything ever being done related to investigations. That is what's in the record. That is what the House managers have to rely on to make their case, and they have failed to prove their case beyond a reasonable doubt, failed even to prove it by clear and convincing evidence, failed to prove it at all, in my opinion. Thank you.
Thank you, counsel. The senator from California is recognized.
Thank you. Mr. Chief Justice, I send a question to the House managers.
Senator Feinstein asks the House managers. The President's counsel stated that, quote, there is simply no evidence anywhere that President Trump ever linked security assistance to any investigations, end quote. Is that true?
Thank you, Mr. Chief Justice, and thank you, Senator, for that question. The President's counsel is not correct. There is, in fact, overwhelming evidence that the President withheld the military aid directly to get a personal political benefit to help his individual political campaign. There's a few points that I'd like to submit for your consideration. First, look no further than the words of the President's acting Chief of Staff, Mick Mulvaney, who on October 17th, 2019, during a national press conference, mentioned, quote, or he was asked about the direct connection between the aid, and he said, quote, did he, meaning President Trump, referring to he, quote, also mentioned to me in passing the corruption related to the DNC server? Absolutely, no question about it, but that's it. And that's why we held up the money, end quote. He was repeating the President's own explanation relayed directly to him. Second, Gordon Sondland testified he spoke by phone with President Trump on September 7th. The President denied there was a, quote, quid pro quo, but then outlined the very quid pro quo that he wanted from Ukraine. Then he told President Sondland to, quote, that President Zelensky should, quote, go to the microphone and announce the investigations. He should want to do it. Third, the president's own advisors, including the Vice President and Secretary Pompeo, were also aware of the direct connection. In Warsaw on September 1st, Ambassador Sondland told Vice President Pence that he was concerned the delay in security assistance had become, quote, tied to the issue of investigations. The Vice President simply nodded, tacitly acknowledging the conditionality of the aid. Fourth, we heard from Ambassador Taylor, who in direct emails and texts said it was crazy to tie the security assistance to the investigations. Five, we also know there's no other reason. The entire apparatus and structure of the Defense Department, the State Department, that should have been dealing with the other legitimate reasons, the policy debate that the President's Council wants you to believe that this was about, they were all kept in the dark. And the supposed interagency process that they made up several months after the fact had ended months before, during the last interagency meetings. And I'll make one final point. Again, if you have any lingering questions about direct evidence, any thoughts about anything we just talked about, anything I just relayed, or that we've talked about the last week, there is a way to shed additional light on it. You can subpoena Ambassador Bolton and ask him that question directly.
Thank you, Mr. Manager.
Mr. Chief Justice.
Senator from Utah.
I send a question to the desk.
Senator Lee asks of counsel for the President. The House managers have argued aggressively that the President's actions contravened U.S. foreign policy. Isn't it the President's place, certainly more than the place of career civil servants, to conduct foreign policy?
By the people every 4 years. That's what gives the President democratic legitimacy to have the powers that he is given under the Constitution. Our system is somewhat unique in the very broad powers that are assigned to the executive, but it works and it makes sense in a democratic system precisely because he is directly accountable to the people for the policies that he sets. Those who are staffers in the executive branch bureaucracy are not elected by the people. They have no accountability, and they have no legitimacy or authority that comes from an election by the people. And so it's critically important to recognize the President sets foreign policy. Of course, within some constraints, there's roles for Congress in foreign affairs to some extent. Statutes can be passed, funding provisions can be passed that relate to it. But the Supreme Court has recognized time and again that the President is, as the court said in Curtis Wright, the sole organ of the nation in foreign affairs. So he sets foreign policy. And if staffers disagree with him, that does not mean that the President is doing something wrong. And this is a critical point, because this is one of the centerpieces of the abuse of power theory that the House managers would like this body to adopt. And that is that they are going to impeach the President based solely on his subjective motive. The premise of their case is the objective actions that were taken were perfectly permissible and within the President's constitutional authority. But if his real reason, if we get inside his head and figure it out, then we can impeach him. And the way that they have tried to explain that they can prove that the President had a bad motive is they say, well, we compare what did the President want to do with what the interagency consensus was. And I mentioned this the other day. They say that the President defied and confounded every agency in the executive branch. That's a constitutionally incoherent statement. The President cannot defy the agencies within the executive branch that are subordinate to him. It is only they who can defy the President's determinations of policy. And what this all boils down to, really, is it shows that this case is built on a policy difference, and a policy difference where The president is the one who gets to determine policy because he's been elected by the people to do that. And we're right now only a few months away from another election where the people can decide for themselves whether they like what the president has done with that authority or not. And that's the way disputes about policy like that should be resolved. It's not legitimate to say that there's some interagency consensus that disagrees with the president, and therefore we can show he did something wrong, and therefore he could be impeached. That's an extraordinarily dangerous proposition because it lacks any democratic legitimacy whatsoever. It's contrary to the Constitution, and it should be rejected by this body. The president is the one who gets to set foreign policy because that's the role assigned to him in the Constitution. And it was even Lieutenant Colonel Vindman, who had complained about the July 25th call, himself ultimately agreed that it was only a policy difference. It was a policy concern that he raised about the call. That's not enough to impeach a president of the United States. Thank you.
Thank you, counsel. The senator from New Hampshire.
Mr. Chief Justice, I send a question to the desk.
Senator Shaheen asks the House managers. The President's counsel has argued that the alleged conduct set out in the articles does not violate a criminal statute and thus may not constitute grounds for impeachment as high crimes and misdemeanors. Does this reasoning imply that if the President does not violate a criminal statute, he could not be impeached for abuses of power, such as ordering tax audits of political opponents, suspending habeas corpus rights, indiscriminately investigating political opponents, or asking foreign powers to investigate members of Congress?
Mr. Chief Justice, Senators, I appreciate the question. The simple answer is that a president can be impeached without a statutory crime being committed. That was the position, and the question was rejected in President Nixon's case and rejected again in President Clinton's case. It should be rejected here in President Trump's case. The great preponderance of legal authority confirms that impeachable offenses of legal authority confirms that it is not defined in criminal conduct. This authority includes nearly every legal scholar to have studied the issue, multiple Supreme Court justices who addressed it in public remarks, and prior impeachments in the House. This conclusion follows that constitutional history, text, and structure, and reflects the absurdities and practical difficulties that would result were the impeachment power confined to indictable crimes. As slide 35 shows, first, the plain text of the Constitution does not require that an offense be a crime in order for it to be impeachable. Alexander Hamilton explained that impeachable offenses, high crimes, and misdemeanors are defined fundamentally by the abuse or violation of some public trust. Some public trust. They are political as they relate chiefly to injuries done immediately to the society itself. Offenses against the Constitution are different than offenses against the criminal code. Some crimes, like jaywalking, are not impeachable, and some forms of misconduct often offend both offend the Constitution and the criminal law. Impeachment and criminality must therefore be assessed separately, even though the President's commission of indictable crimes may further support a case of impeachment and removal. The American experience with impeachment confirms this. A strong majority of impeachments voted by the House since 1789 have included one or more allegations that did not charge a violation of criminal law. Although President Nixon resigned before the House could consider the articles of impeachment against him, the Judiciary Committee's allegations encompass many, many non-criminal acts. And in President Clinton's case, the Judiciary Committee report accompanying the articles of impeachment to the House floor stated that, quote, the actions of President Clinton do not have to rise to the level of violating the federal statute regarding articles obstruction of justice in order to justify impeachment. The framers intended impeachment to reach the full spectrum of presidential misconduct that threatened the Constitution. They also intended that our Constitution endure throughout the ages. In other words, if they named 1, 2, and 3, but new ones came up, you had to keep up with the times, so it was better to have the full spectrum of presidential misconduct. Because they could not anticipate and specifically prohibit every single threat a president might someday pose, the framers adopted a standard sufficiently general and flexible to meet unknown future circumstances. This standard was meant, as Mason put it, to capture all manner of great and dangerous offenses incompatible with the Constitution when the president uses the powers of his high office to benefit himself while injuring or ignoring the American people he is duty-bound to serve. He has committed an impeachable offense. The records of the Constitutional Convention offer further clarity. At the Constitutional Convention itself, no delegate linked impeachment to the technicalities of criminal law. Instead, the framers principally intended impeachment for 3 forms of presidential wrongdoing, the ABCs of impeachment. A, abuse of power. B, betrayal of the national interest through foreign entanglements. And C, corruption of office and elections. When a president abuses his power to obtain illicit help in his election from a foreign power and undermine our national security and election integrity, it is a trifecta.
Thank you. Thank you, counsel.
Thank you.
The senator from Louisiana.
Mr. Chief Justice, along with Senator Blackburn and Senator Cornyn, I send a question to the desk for the House managers and for counsel for the President.
In the case of such a question addressed to both sides, they will split the 5 minutes equally. The senators ask, why did the House of Representatives not challenge President Trump's claims of executive privilege and/or immunity during the House impeachment proceedings? We'll begin with the House managers. Soon.
Mr. Chief Justice, distinguished senators, thank you for your question. The answer is simple. We did not challenge any claims related to executive privilege because, as the President's own counsel admitted during this trial, the President never raised the question of executive privilege. What the President did raise was this notion of blanket defiance, this notion that the executive branch, directed by the President, could completely defy any and all subpoenas issued by the House of Representatives, not turn over documents, not turn over witnesses, not produce a single shred of information in order to allow us to present the truth to the American people. In the October 8th letter that was sent to the House of Representatives, there was no jurisprudence that was cited to justify the notion of blanket defiance. There has been no case law cited to justify the doctrine of absolute immunity. In fact, every single court that has considered any presidential claim of absolute immunity, such as the one asserted by the White House, has rejected it out of hand.
Counsel for the President.
Mr. Chief Justice, Senators, thank you for that question. Let me frame this partly in response to what Manager Jeffries said, and I went through this before. The idea that there was blanket defiance and no explanation and no case law from the White House is simply incorrect. I put up slides showing the letters, a letter from October 18th that explained specifically that the subpoenas that had been issued by the House because they were not authorized by a vote from the House were invalid. And there was a letter from the White House counsel saying that. There was a letter from OMB saying that. There was a letter from the State Department saying that. There were specific rationales given, citing the cases, Watkins, Roomley, and others, explaining that defect. The House, Manager Schiff, chose not to take any steps to correct that. We also pointed out other defects. We asserted the doctrine of absolute immunity for senior advisors to the president, which has been asserted by every president since the 1970s. They chose not to challenge that in court. We also explained the problem that they didn't allow agency counsel to be present at depositions. They chose not to challenge that in court. These were specific legal reasons, not blanket defiance, right? That's just a misrepresentation of the record. And there was no attempt to have that adjudicated in court. And the reason that there was no attempt is that the House Democrats were just in a hurry. They had a timetable. One of the House managers said on the floor here, they had no time for courts. They had to impeach the president before the election. So they had to have that done by Christmas. That's why the proper process wasn't followed here, because it was a partisan and political impeachment that they wanted to get done all around timing for the election. Thank you.
Thank you, counsel. Senator from Vermont. Senator Leahy asks the House managers, the President's counsel argues that there was no harm done, that the aid was ultimately released to Ukraine, the President met with Zelensky at the UN in September, and that this President has treated Ukraine more favorably than his predecessors. What is your response?
Mr. Chief Justice and Senator, thank you so much for your question. Contrary to what the White House counsel has said or has claimed, that there was no harm, no foul, that the aid eventually got there, we promised Ukraine in 2014 that if they gave up their nuclear arsenal, that we would be there for them, that we would defend them, that we would fight along beside them. 15,000 Ukrainians have died. It was interesting the other day when the White House counsel said that no American life was lost, and we are always grateful and thankful for that. But what about our friends? What about our allies in Ukraine? According to Diplomat Holmes and Ambassador Taylor, that our Ukrainian friends continue to die on the front lines, those who were fighting for us, fighting Russian aggression. When you fight Russian aggression, when the Ukrainians have the ability to defend themselves, they have the ability to defend us. The aid, although it did arrive, it took the work of some senators in this room who had to pass additional laws to make sure that the Ukrainians did not lose out on $35 million additional dollars. And contrary to the president's tweet that all of the aid arrived and that it arrived ahead of schedule, that is not true. All of the aid has not arrived. And let's talk about what kind of signal withholding the aid for no legitimate reason. The president talked about burden sharing, but nothing had changed on the ground. Holding the aid for no legitimate reason sent a strong message that we would not want to send to Russia, that the relationship between the United States and Ukraine was on shaky ground. It actually undercut Ukraine's ability to negotiate with Russia, with whom, as everybody in this room knows, is in an active war, in a hot war. So when we talk about the aid eventually got there, no harm, no foul, that is not true, senators, and I know that you know that. There was harm and there was foul. And let us not forget that Ukraine is not an enemy. They're not an adversary. They are our friends.
Thank you. Senator Cruz.
Mr. Chief Justice, I send a question to the desk.
The question is addressed to counsel for the President. As a matter of law, does it matter if there was a quid pro quo? Is it true that quid pro quos are often used in foreign policy?
Chief Justice, thank you very much for your question. Yesterday, I had the privilege of attending the rolling out of a peace plan by the President of the United States regarding the Israel-Palestine conflict. And I offered you a hypothetical the other day. What if a Democratic president were to be elected and Congress were to authorize much money to either Israel or the Palestinians, and the Democratic president were to say to Israel, no, I'm going to withhold this money unless you stop all settlement growth, or to the Palestinians, I will withhold the money Congress authorized to you unless you stop paying terrorists. And the president said, quid pro quo. If you don't do it, you don't get the money. If you do it, you get the money. There's no one in this chamber that would regard that as in any way unlawful. The only thing that would make a quid pro quo unlawful is if the quo were in some way illegal. Now, we talked about motive. There are three possible motives that a political figure can have. One, a motive in the public interest, and the Israel argument would be in the public interest. The second is in his own political interest, and the third, which hasn't been mentioned, would be in his own financial interest, his own pure financial interest, just putting money in the bank. I want to focus on the second one for just one moment. Every public official that I know believes that his election is in the public interest. And mostly you're right. Your election is in the public interest. And if a president does something which he believes will help him get elected in the public interest, that cannot be the kind of quid pro quo that results in impeachment. I quoted President Lincoln. When President Lincoln told General Sherman to let the troops go to Indiana so that they can vote for the Republican Party. Let's assume the president was running at that point, and it was in his electoral interest to have these soldiers put at risk the lives of many, many other soldiers who would be left without their company. Would that be an unlawful quid pro quo? No, because the president, A, believed it was in the national interest, but B, he believed that his own election was essential to victory in the Civil War. Every president believes that. That's why it's so dangerous to try to psychoanalyze a president, to try to get into the intricacies of the human mind. Everybody has mixed motives. And for there to be a constitutional impeachment based on mixed motives would permit almost any president to be impeached. How many presidents have made foreign policy decisions after checking with their political advisors and their pollsters? If you're just acting in the national interest, what do you need pollsters? What do you need political advisors? Just do what's best for the country. But if you want to balance what's in the public interest with what's in your party's electoral interest and your own electoral interest, it's impossible to discern how much weight is given to one to the other. Now, we may argue that it's not in the national interest for a particular president to get reelected or for a particular senator or member of Congress. And maybe we're right. It's not in the national interest for everybody who's running to be elected. But for it to be impeachable, you would have to discern that he or she made a decision solely on the basis of, as the House managers put it, corrupt motives. And it cannot be a corrupt motive if you have a mixed motive that partially involves the national interest, partially involves electoral, and does not involve personal pecuniary interests. And the House managers do not allege that this decision, this quid pro quo, as they call it, and the question is based on the hypothesis there was a quid pro quo, I'm not acting the facts, they never allege that it was based on pure financial reasons. It would be a much harder case if a hypothetical president of the United States said to a hypothetical leader of a foreign country, unless you build a hotel with my name on it, and unless you give me $1 million kickback, I will withhold the funds. That's an easy case. That's purely corrupt and in the purely private interest. But a complex middle case is, I want to be elected. I think I'm a great president. I think I'm the greatest president there ever was. And if I'm not elected, the national interest will suffer greatly. That cannot be an impeachable offense. Thank you, Mr. Chief Justice.
Recognize the Democratic leader.
Mr. Chief Justice, I send a question to the desk.
The question is for the House managers. Would you please respond to the answer that was just given by the President's counsel?
I would be delighted. There are two arguments that Professor Dershowitz makes. One that is, I have to say, a very odd argument for a criminal defense lawyer to make, and that is, it is highly unusual to have a discussion in a trial about the defendant's state of mind, intent, or mens rea. In every courtroom in America, in every criminal case, or almost every criminal case, except for a very small sliver that are strict liability, the question of the defendant's intent and state of mind is always an issue. So this is nothing novel here. You don't require a mind reader. In every criminal case, and I would assume in every impeachment case, yes, you have to show that the president was operating from a corrupt motive, and we have. But he also makes an argument that all quid pro quos are the same and all are perfectly copacetic. Now, some of you said earlier, well, if they could prove a quid pro quo over the military, now that would be something. Well, we have. So now the argument shifts to all quid pro quos are just fine, they're all the same. Well, I'm going to apply Professor Dershowitz's own test. He talked about the step test. John Rawls, the philosopher, Let's put the shoe on the other foot and see how that changes our perception of things. But I want to merge that argument with one of the other presidential counsel's argument when they resorted to the whataboutism about Barack Obama's open mic. Now, that was a very poor analogy, I think you'll agree, but let's use that analogy and let's make it more comparable to today and see how you feel about this scenario. President Obama, on an open mic, says to Medvedev, "Hey, Medvedev, I know you don't want me to send this military money to Ukraine because they're fighting and killing your people. I want you to do me a favor, though. I want you to do an investigation of Mitt Romney. And I want you to announce you found dirt on Mitt Romney. And if you're willing to do that, quid pro quo, I won't give Ukraine the money they need to fight you on the front line." Do any of us have any question that Barack Obama would be impeached for that kind of misconduct? Are we really ready to say that that would be okay if Barack Obama asked Medvedev to investigate his opponent and would withhold money from an ally that it needed to defend itself to get an investigation of Mitt Romney? That's the parallel here. And to say, well, yes, we condition aid all the time, for legitimate reasons, yes. For legitimate reasons, you might say to a governor of a state, "Hey, governor of a state, you should chip in more towards your own disaster relief." But if the president's real motive in depriving a state of disaster relief is because that governor won't get his attorney general to investigate the president's political rival, are we ready to say that the president can sacrifice the interests of the people of that state, or in the case of Medvedev, the people of our country, because all quid pro quos are fine, it's carte blanche? Is that really what we're prepared to say with respect to this president's conduct or the next? Because if we are, then the next president of the United States can ask for an investigation of you. They can ask for help in their next election from any foreign power. And the argument will be made, nope, Donald Trump was acquitted for doing exactly the same thing, therefore it must not be impeachable. Now, bear in mind that efforts to cheat an election are always going to be in proximity to an election. And if you say you can't hold a president accountable in an election year where they're trying to cheat in that election, then you are giving them carte blanche. So all quid pros are not the same. Some are legitimate and some are corrupt, and you don't need to be a mind reader to figure out which is which. For one thing, you can ask John Bolton.
Thank you, Mr. Manager.
Mr. Chief Justice,
Senator from Iowa.
I send a question to the desk.
Senator Grassley asks counsel for the President, does the House's failure to enforce its subpoenas render its, quote, obstruction of Congress, end quote, theory unprecedented?
Mr. Chief Justice, Senators, the answer is yes. As far as I am aware, there has never been a prior instance in which there's been an attempt, even in the House, as in the Nixon proceeding, never mind in the Clinton proceeding, which actually left the House and came to the Senate, to suggest that there can be obstruction of Congress when there hasn't been anything beyond simply issuing a subpoena, getting resistance, and then throwing up your hands and giving up and saying, oh, well, that's obstruction. In the Clinton situation, most of the litigation was with the independent counsel, and there were privileges asserted and litigation again and again. But the point is that the issues about the privileges were all litigated, and they were resolved before things came to this body. Similarly, in the Nixon impeachment proceeding within the House, A lot of investigation had been done by the special counsel, and there was litigation over assertions of privileges there in order to get at the tapes, and some tapes or transcripts had already been turned over. But again, there was litigation about the assertion of the privilege in response to the grand jury subpoena that then fed into the House's proceedings. So it would be completely unprecedented for the House to attempt to actually bring a charge of obstruction into the Senate where all they can present is, well, we issued a subpoena and there were legal grounds asserted for the invalidity of the subpoena, and there were different grounds as I've gone through. I won't repeat them all in detail here, but some were because the subpoenas were just invalid when issued because there was no vote. Some is that the subpoenas for witnesses were invalid because senior advisors to the president had absolute immunity from compulsion. Some were that they were forcing executive branch officials to testify without the benefit of agency counsel and executive branch counsel with them. So various reasons asserted for the invalidity and the defects in various subpoenas, and then no attempt to enforce them, no attempt to litigate out what the validity or invalidity might be, but just bring it here as an obstruction charge is unprecedented. And I'll note the House managers have said, and I'm sure that they will say again today, that, well, but if we had gone to court, the Trump administration would have said that the courts don't have jurisdiction over those claims. Now, that is true. In some cases, there's one being litigated right now related to the former counsel to the president, Don McGahn. The Trump administration position, just like the position of the Obama administration, is that an effort by the House to enforce a subpoena in Article 3 court is a non-justiciable controversy. That is our position, and we would argue that in court. But that's part of what would have to be litigated. That doesn't change the fact that the House managers can't have it both ways. And I want to make this clear. The House managers want to say that they have an avenue for going to court. They're using that avenue for going to court. They actually told the court in McGahn that once they reached an impasse with the executive branch, the courts were the only way to resolve the impasse. And as I explained the other day, there are mechanisms for dealing with these disputes between the executive and Congress. The first is an accommodations process. They didn't do that. We offered to do that in the White House counsel's October 8th letter. They didn't do accommodations. If they think they can sue, they have to take that step because the Constitution, the courts have made clear, require incrementalism in disputes between the executive and the legislative branch. So if they think that the courts can resolve that dispute, that's the next step. They should do that and have that litigated. And then things can proceed on to a higher level of confrontation. But to jump straight to impeachment, to the ultimate constitutional confrontation, doesn't make sense. It's not the system that the Constitution requires, and it is unprecedented in this case. Thank you.
Thank you, counsel. The senator from Michigan.
Thank you, Mr. Chief Justice. I send a question to the desk.
Senator Stabenow asked the House managers, would the House managers care to correct the record on any falsehoods or mischaracterizations in the White House's opening arguments?
Mr. Chief Justice and Senators, thank you for that question. We believe that the President's team has claimed basically there were 6 facts that have not been met and will not change, and all 6 of those so-called facts are incorrect. Let's be clear, on July 25th, that's not the whole evidence before us, even though it includes devastating evidence of the President's scheme. President Trump's intent was made clear on the July 25th call, but we had evidence of information before the meetings with Mr. Bolton, the text message to Mr. Zelensky's people telling him he had to do the investigations to get what he wanted, all of this evidence that makes us understand that phone call even more clearly. Now, the president's team claimed that Mr. Zelensky and other Ukrainians said they never felt pressure to open investigations. Now, of course, they didn't say that publicly. They were afraid of the Russians finding out. But Zelensky said privately that he didn't want to be involved in U.S. domestic politics. He resisted announcing the investigations. He only relented and scheduled the CNN meeting after it became clear that he was not going to receive the support that he needed and that Congress had provided in our appropriations. That's the definition of pressure. Now, Ukraine, the president's lawyers say, didn't know that Trump was withholding the security assistance until it was public. Many witnesses have contested that, including the open statement by Olena Zirkle, who was then the deputy foreign minister of Ukraine, that they knew about the president's hold on the security matters. And in the end, everyone knew it was public. And after it was, Ukraine did relent and schedule that testimony. Fourth, they said no witnesses said security was conditioned on the investigations. Not so. Mulvaney, we had other witnesses talking about the shakedown for the security assistance. But the important thing is that you can get a witness who talked to the president firsthand about what the president thought he was doing. Ultimately, of course, the funds, or at least some of them, were released. But the White House meeting that the president promised 3 different times still has not occurred. So, and we still don't have the investigation of the Bidens. Getting caught doesn't mitigate the wrongdoing. The president's unrepentant, and we fear he will do it again. Now, the Independent Government Accountability Office concluded that the president violated federal law when he withheld that aid. That misconduct is still going on. All the aid has not yet been released. And finally, I'd just like to say there's been some confusion, I think, I'm sure not intentional, but the president surely does not need the permission of his staff about foreign policy. That information is offered to you as evidence of what he thought he was doing. And he did not appear to be pursuing a policy agenda. He appeared, from all the evidence, to be pursuing a corruption of our election that's upcoming, a high crime and misdemeanor that requires conviction and removal. I yield back.
Mr. Chief Justice.
The senator from Arkansas.
I send a question to the desk for the President's Counsel on behalf of myself and Senators Bozeman, McSally, Blackburn, Kennedy, and Toomey.
The senators asked the President's counsel, did the House bother to seek testimony or litigate executive privilege issues during the month during which it held up the impeachment articles before sending them to the Senate?
Mr. Chief Justice, Senators, no, the House did not seek to litigate any of the privilege issues during that time. In fact, they filed no lawsuits arising from this impeachment inquiry to seek to contest the bases that the Trump administration gave for resisting the subpoenas, the basis for why those subpoenas were invalid. And when litigation was filed by one of the subpoena recipients, that was Dr. Charles Kupperman, the Deputy National Security Advisor, he went to the court and sought a declaratory judgment saying, President's told me I shouldn't go. I have a subpoena from the House saying I should go. Please, courts, tell me what are my obligations. And that was filed, I believe, around October 25th. It was towards the end of October. Very shortly, within a few days, the court had set an expedited briefing schedule and scheduled a hearing for December 10th that was supposed to hear both preliminary motions to dismiss, but also the merits issues. So they were going to get a decision after a hearing on December 10th that would go to the merits of the issue. The House managers withdrew the subpoena. The House of Representatives decided they wanted to moot out the case so they wouldn't get a decision. So no, the House has not pursued litigation to get any of these issues resolved. It's affirmatively avoided getting any litigation. And that seems to be, at least in part, based on, if you look at the House Judiciary Committee report, their assertion that under the sole power of impeachment assigned to the House believes that the Constitution assigns, I believe the exact words are, it gives the House the last word, something to that effect. And I mentioned this the other day. This is the new constitutional theory that because they have the sole power of impeachment, in their view, it's actually the paramount power of impeachment. And all other constitutionally based privileges or rights or immunities or roles even of the other branches, both the judiciary and the executive, fall away. And there is nothing that can stand in the way of the House's power of impeachment. If they issue a subpoena, the executive has to respond. And it can't raise any constitutionally based separation of powers concerns. If you do, that's obstruction. The courts have no role. The House has the sole power of impeachment. And that's a very dangerous construct for our Constitution. It suggests that once they flip the switch onto impeachment, there's no check on their power, on what they want to do. And that's not the way the Constitution is structured. The Constitution requires, when there are interbranch conflicts, that there be an accommodation process, that there be attempts to address the interests of both branches. And the House has taken the position, and in other litigation, the McGahn litigation, they're telling the courts are the only way to resolve these issues. And they brought that case in August. They already have a decision from the district court. They have an appeal in the D.C. Circuit. It was argued on January 3rd. A decision could come any day. That's pretty fast for litigation. But they've decided in this impeachment they don't want to do litigation. And again, it's because they had a timetable. One of the House managers admitted on this floor they had to get the president impeached before the election. They had no time for the courts, for anyone telling them what the rules were. And they had to get it done by Christmas, and that's what they did. And then they waited around for the month before bringing it here. And I think that shows you what's really behind the claims of, oh, it's urgent, then it's not urgent. It's urgent when it's our timetable to get done by Christmas. It's not so urgent when we can wait for a month because we want to tell the Senate how to run things. It's all a political charade. And that's part of the reason, a major reason, that the Senate should reject these articles of impeachment. Thank you.
Thank you, counsel.
Justice.
The senator from New Mexico.
Thank you for the recognition, Mr. Chief Justice. I send a question to the desk.
The question is for the House managers. Please address the President's counsel's argument that House managers seek to overturn the results of the 2016 election and that the decision to remove the President should be left to the voters in November.
Thank you for the question. First I just want to respond to something counsel just said. 9 months is pretty fast for litigation in the courts. Sadly, I agree with that. 9 months is pretty fast in the McGahn case, and we still don't have a decision yet. And what's more, that's the very case in which they're arguing, as I quoted earlier, that Congress has no right to come to the courts to force a witness to testify. So here we are 9 months later in that litigation that they said we're compelled under the Constitution to bring, and they're saying in court, you can't bring this, and it's 9 months and we still don't have a decision. I think that tells you just where they're coming from. It all goes back to the president's directive, fight all subpoenas, and they are. Nixon was going to be impeached for far less obstruction than anything that Donald Trump did. Now, the argument, well, if you impeach a president, you are overturning the results of the last election and you're tearing up the ballots in the next election. Okay, if that were the case, there would be no impeachment clause in the Constitution. Because by definition, if you're impeaching a president, that president is in office, has won an election. Clearly, that's not what the founders had in mind. What they had in mind is if the president commits high crimes and misdemeanors, you must remove him from office. It is not voiding the last election, it is protecting the next election. Indeed, the impeachment power was put in the Constitution not as a punishment, that's what the criminal laws are for, but to protect the country. Now, if you say you can't impeach a president before the next election, what you're really saying is you can only impeach a president in their second term. Okay, if that were going to be the constitutional requirement, the founders would have put in the Constitution, a president may commit whatever high crimes and misdemeanors that he wants as long as it's in the first term. That is clearly not what any rational framer would have written, and indeed they didn't. And they didn't for a reason. The founders were concerned that, in fact, the object of a president's corrupt scheme might be to cheat in the very form of accountability that they had prescribed, the election. So counsel has continued to mischaracterize what the managers have said. We're not saying that we had to hurry to impeach the president before the election. We had to hurry because the president was trying to cheat in that election. And the position of the president's counsel is, well, yes, it's true that if a president is going to try to cheat an election, by definition, that's prior to their re-election. By definition, that's going to be proximate to an election. But let the voters decide, even though the object would corrupt that vote of the people. That cannot be what the founders had in mind. One of the things I said at the very open of this proceeding is, yes, we're to look to history. Yes, we're to try to divine the intent of the framers, but we are not to leave our common sense at the door. The issue isn't whether this is his first term or his second. It isn't whether the election is a year away or 3 years away. The issue is, did he commit a high crime and misdemeanor? Is it a high crime and misdemeanor for a president of the United States to withhold hundreds of millions of dollars in aid to an ally at war to get help, illicit foreign interference in our election? If you believe that it is, it doesn't matter what term it is. It doesn't matter how far away the election is, because that president represents a threat to the integrity of our elections, and more than that, a threat to our national security. As we have shown by withholding that aid, and I know the argument, no harm, no foul, we held aid from an ally at war. We sent a message to the Russians when they learned of this hold that we did not have Ukraine's back. We sent a message to the Russians as Zelensky was going into negotiations with Putin to try to end that war, that Zelensky was operating from a position of weakness because there was a division between the President of the United States and Ukraine. That's immediate damage. That's damage done every day. That damage continues to this day. The damage the President does in pushing out the Russian conspiracy theories were identified during the House proceedings, and you've heard in the Senate, as Russian intelligence propaganda. The danger the President poses by taking Vladimir Putin's side over his own intelligence agencies, that's a danger today. That's a danger that continues every day he pushes out this Russian propaganda. The framers, if they meant impeachment only to imply in a second term, would have said so, but that would have made the Constitution a suicide pact. That's not what it says, and that's not how you should interpret it.
Thank you. The senator from Ohio.
Yes.
Thank you. The question is directed to counsel for the President. Given that impeachment proceedings are privileged in the Senate and largely prevent other work from taking place while they are ongoing, please address the implications of allowing the House to present an incomplete case to the Senate and request the Senate to seek testimony from additional witnesses.
Thank you, Mr. Chief Justice, Senators. I think this is one of the most important issues that this body faces, given these calls to have witnesses, because the House managers try to present it as if it's just a simple question, how can you have a trial without witnesses? But in real litigation, no one goes to trial without doing discovery. No one goes to trial without having heard from the witnesses first. You don't show up at trial and then start trying to call witnesses for the first time. And the implications here in our constitutional structure for trying to run things in such an upside-down way would be very grave for this body as an institution. Because, as the senator's question points out, it largely prevents this chamber from getting other business done as long as there is a trial pending. And the idea that the House can do an incomplete job in trying to find out what witnesses there are, having them come testify, trying to find out the facts, just rush something through and bring it here as an impeachment, and then start trying to call all the witnesses, means that this body will end up taking over that investigatory task. And all of the regular business of this body will be slowed down, hindered, or prevented while that goes on. And it's not a question of just one witness. It's not a question, a lot of people talk right now about John Bolton, but the president would have the opportunity to call his witnesses just as a matter of fundamental fairness. And there would be a long list of witnesses if the body were to go in that direction. That would mean this would drag on for months and prevent this chamber from getting its business done. There's a proper way to do things and an upside-down way of doing things. And to have the House not go through a process that is thorough and complete, and to just rush things through in a partisan and political manner and then dump it onto this chamber to clean everything up is a very dangerous precedent to be set. As I said the other day, whatever is accepted in this case becomes the new normal. If this chamber puts its imprimatur on this process, then that's the seal of approval for all time in the future. And if it becomes that easy for the House of Representatives to impeach a president of the United States, don't attempt to subpoena the witnesses, never mind litigation, it takes too long, but then leave it all to this chamber. And as I said the other day, remember, what do we think will happen if some of these witnesses are subpoenaed now that they never bothered to litigate about? Then there'll be the litigation now, most likely, and then that will take time while this chamber is still stuck sitting as a court of impeachment. That's not the way to do things. And it would forever change the relationship between the House of Representatives and the Senate in terms of the way impeachments operate. So I think it's vitally important for this chamber to consider what it really means to start having this chamber do all that investigatory work, how this chamber would be paralyzed by that, and is that really the precedent? Is that the way this chamber wants everything to operate in the future? Once you make it that much easier, and we've said this on a couple of different points, both in terms of the standards for impeachable offenses, but also in terms of the process that's used in the House. You make it really way too easy to impeach a president, then this chamber is going to be dealing with that all the time. And as Minority Leader Schumer had pointed out, at the time of the Clinton impeachment, he was prophetic. As the White House counsel pointed out the other day, once you start down the path of partisan impeachments, they'll be coming again and again and again. And if you make it easier, they'll come even more frequently. And this chamber is going to have to spending a lot of time dealing with impeachment trials and cleaning up incomplete, half-baked procedures, rushed partisan impeachments from the House. if that's the sort of system that's given your imprimatur here. And that's a very important reason for not accepting that procedure and not trying to open things up now when things haven't been done properly in the House of Representatives. Thank you.
So, the senator from Delaware.
Mr. Chief Justice, I send a question to the desk.
The question is for the House managers. Some have claimed that subpoenaing witnesses or documents would unnecessarily prolong this trial. Isn't it true that depositions of the 3 witnesses in the Clinton trial were completed in only 1 day each? And isn't it true that the Chief Justice, as presiding officer in this trial, has the authority to resolve any claims of privilege or other witness issues without any delay?
Mr. Chief Justice, the answer is yes. What is clear, based on the record that was compiled by the House of Representatives, where up to 5 depositions per week were completed, that this can be done in an expeditious fashion. It's important to note that the record that exists before you right now contains strong and uncontroverted evidence that President Trump pressured a foreign government to target an American citizen for political and personal gain as part of a scheme to cheat in the 2020 election and solicit foreign interference. That is evidence from witnesses who came forward from the Trump administration, including individuals like Ambassador Bill Taylor, West Point graduate, Vietnam War hero, including individuals like Ambassador Sondland, who gave $1 million to President Trump's inauguration, respected national security professionals like Lieutenant Colonel Alexander Vindman, as well as Dr. Fiona Hill. 17 different witnesses, Trump administration employees, troubled by the corrupt conduct that took place as alleged and proven by the House of Representatives. But to the extent that there are ambiguities in your mind, this is a trial. A trial involves witnesses. A trial involves documents. A trial involves evidence. That is not a new phenomenon for this distinguished body. The Senate in its history has had 15 different impeachment trials. In every single trial, there were witnesses. Every single trial. Why should this president be treated differently, held to a lower standard at this moment of presidential accountability? And in fact, in many of those trials, there were witnesses who testified in the Senate who had not testified in the House. That was the case most recently in the Bill Clinton trial. It certainly was the case in the trial of President Johnson. 37 out of the 40 witnesses who testified in the Senate were new. 37 out of 40. Why can't we do it in this instance? When you have such highly relevant witnesses like John Bolton, who had a direct conversation with President Trump, indicating that President Trump was withholding the aid because he wanted the phony investigations. Counsel has said the greatest invention in the history of jurisprudence for ascertaining the truth has been the vehicle of cross-examination. Let's call John Bolton. Let's call Mick Mulvaney. Let's call other witnesses, subject them to cross-examination, and present the truth to the American people.
Mr. Chief Justice.
The senator from Texas.
Mr. Chief Justice, I have to send a question to the desk.
Thank you. Senator Cornyn asks counsel for the President, what are the consequences to the presidency, the President's constitutional role as the head of the executive branch, and the advice the President can expect from his senior advisors if the Senate seeks to resolve claims of executive privilege for subpoenas in this impeachment trial without any determination by an Article III court?
Mr. Chief Justice, thank you, Senator, for the question. The Supreme Court has recognized that the confidentiality of communications with the President is essential. Keeping those communications confidential is essential for the proper functioning of government. In Nixon versus the United States, the Court explained that this privilege is grounded in the separation of powers and essential for the functioning of the executive for this reason. In order to receive candid advice, the President has to be able to be sure that those who are speaking with him have the confidence that what they say is not going to be revealed, that their advice can remain confidential. If it's not confidential, they would temper what they're saying. They wouldn't be candid with the President. And they wouldn't be able, the President then would not be able to get the best advice. And it's the same concern that underpins the deliberative process aspect of executive privilege. Even if it's not a communication directly with the President, if it's the deliberative process within the executive branch, people have to be able, before coming up with a decision, to discuss alternatives, to probe what other ways might work to address a problem, and to discuss them candidly and openly, not with the feeling that the first thing they say is going to be on the front page of the Washington Post the next day. Because if you don't have the confidence that what you're saying is going to be kept confidential, you won't be candid, you won't give your best advice. And that damages decision-making. That's bad for the government, and it's bad for the people of the United States, because it means the government and the executive branch can't function efficiently. So there is a critical need for the executive to be able to have these privileges and to protect them. And that's why the Supreme Court recognized that in Nixon versus United States and pointed out that there has to be some very high showing of need from another branch of government if there's going to be any breach of that privilege. And that's why there is an accommodations process. While the courts have said that when the Congress, when the legislature seeks information from the executive, and the executive has confidentiality interests, both branches are under an obligation to try to come to some accommodation to address the interests of both branches. But it's not a situation of simply the Congress is supreme and can demand information from the executive, and the executive must present everything. And the courts have made that clear, because that would be damaging to the functioning of government. And so here in this case, there are vital interests at stake. And in one of the potential witnesses that the House managers have raised again and again is John Bolton. Well, John Bolton was the national security advisor to the President. He has all of the nation's secrets from the time that he was the national security advisor, and that's precisely the area, the field, in which the Supreme Court suggested in Nixon versus United States there might be something approaching an absolute privilege of confidentiality in communications with the President, the field of national security and foreign affairs. That's the crown jewels of executive privilege. And so to suggest that the national security advisor, well, we'll just subpoena him, he'll come in, and that'll be easy, there won't be any problem, that's not the way it would work, because there's a vital constitutional privilege at stake there. And it's important for the institution of the office of the presidency, for every president, to protect that privilege. Because once precedents start to be set, if one president says, well, I won't insist on the privilege then, I'll let people interview this person, I won't insist on the immunity, that sets precedents. And then the next time, when it's important to preserve the privilege, the precedent is raised, and the privilege has been weakened, and it's forever weakened, and that damages the functioning of government. So this is a very serious issue to consider. It's important, the Supreme Court has made clear, for the proper functioning of the executive branch, for the proper functioning of our government, and there would be grave issues raised attempting to have a national security advisor to the president come under subpoena to testify. And that would all have to be dealt with, and that would take some time before things would continue. Thank you.
Counsel? The senator from Hawaii.
Mr. Chief Justice, I send a question to the desk.
The question from Senator Schatz is directed to the House managers. And also from Senator Feinstein. If the President were acting in the interest of national security, as he alleges, would there be documentary evidence or testimony to substantiate his claim? If yes, has any evidence like that been presented by the President's counsel?
Thank you, Mr. Chief Justice. Thank you, Senators, for the question. The answer is yes. Right? There are well-established processes, mechanisms, and agencies in place to pursue valid and legitimate national security interests of the United States, like the National Security Council, like the National Security Advisor, as in Ambassador John Bolton, and many other folks within the State Department and the Department of Defense. And as we have well established over the last week, none of those folks, none of those agencies that would have been involved in having that deliberation, reviewing that evidence, having that discussion, were incorporated into any type of interagency review process during the vast majority of the time that we are talking about here. From the time of the President's call on July 25th to the time the hold was lifted, those individuals, those agencies were in the dark. They didn't know what was happening. And more so, not only were they in the dark, but the President violated the law by violating the Impoundment Control Act to execute his scheme. None of that suggests a valid, legitimate policy objective. More so, the President himself and his counsel is bringing at issue the question of documents and witnesses. If over and over again, as we've heard in the last few days, that the President was simply pursuing a valid, legitimate policy objective, if this was a specific debate about policy, a debate about corruption, a debate about burden sharing, then let's have the documents that would show that. Let's hear from the witnesses that would show that, because the documents and the witnesses that we have forwarded, that we have talked about, show the exact opposite. So the American people in this chamber deserve to have a fair trial. The President deserves to have a fair trial. In fact, if he is arguing that there is evidence, that there was a policy debate, then I think everybody would love to see those documents, would love to see the witnesses, hear from them directly about what exactly was being debated.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from South Carolina.
I send a question to the desk for myself and Senator Cruz.
Thank you. Senator Graham and Senator Cruz pose this question for the House managers. In Mr. Schiff's hypothetical, if President Obama had evidence that Mitt Romney's son was being paid $1 million per year by a corrupt Russian company and Mitt Romney had acted to benefit that company, would Obama have authority to ask that that potential corruption be investigated?
Well, first of all, the hypothetical is a bit off because it presumes that in that hypothetical that President Obama was acting corruptly, or there was evidence he was acting corruptly with respect to his son. But nonetheless, let's take your hypothetical on its terms. Would it have been impeachable if Barack Obama had tried to get Medvedev to do an investigation of Mitt Romney, whether it was justified or unjustified? The reality is, for a president to withhold military aid from an ally, or in the hypothetical, to withhold it to benefit an adversary, to target their political opponent is wrong and corrupt, period. End of story. And if you allow a president to rationalize that conduct, rationalize jeopardizing the nation's security to benefit himself because he believes that his opponent should be investigated by a foreign power, that is impeachable. Now, if you have a legitimate reason to think that any U.S. person has committed an offense, there are legitimate ways to have an investigation conducted. There are legitimate ways to have the Justice Department conduct an investigation. Now, I would suggest to you that for a president to turn to his Justice Department and say, I want you to investigate my political rival, taints whatever investigation they do. Presidents should not be in the business of asking even their own Justice Department to investigate their rivals. The Justice Department ought to have some independence from the political desires of the president. And one of the deeply troubling circumstances of the current presidency is you do have a president of the United States speaking quite openly, urging his Justice Department to investigate his perceived enemies. That should not take place either. But under no circumstances do you go outside of your own legitimate law enforcement process to ask a foreign power to investigate your rival, whether you think there's cause or you don't think there's cause. And you certainly don't invite that foreign power to try to influence an election to your benefit. It's remarkable to me that we even have to have this conversation. I mean, our own FBI director has made it abundantly clear, and it shouldn't require an FBI director to say this, that if we were approached with an offer of foreign help, we should turn it down. We should, of course, certainly not solicit a foreign country to intervene in our election. And whether we think there's grounds or we don't, the idea that we would hold our own country's security hostage by withholding aid to a nation at war to either damage our ally or help our adversary because they will conduct an investigation into our opponent, I can't imagine any circumstance where that's justified. And I can't imagine any circumstance where we would want to say the President of the United States can target his rival, can illicit foreign help in an election, can help him cheat, and that's okay. Because that will dramatically lower the bar for what we have a right to expect in the President of the United States, and that is they're acting in our interests. So I would say it's wrong for President of the United States to be asking for political prosecutions by his own Justice Department. I would say it's wrong for President of the United States to ask a foreign power to engage in an investigation of his political rival, but particularly where, as we have shown here, there is no merit to that investigation is even more egregious. And you know there's no merit to it because he didn't even want the investigation. And the more accurate parallel, Senator, would be if Barack Obama said, I don't even need you, Russia, to do the investigation. I just want you to announce it. Because that betrays the fact there was no legitimate basis because the president didn't even need the investigation done. He just wanted it announced. And there is no legitimate explanation for that except he wanted their help in cheating in the next election.
Thank you, Mr. Manager. The senator from Michigan.
Mr. Chief Justice, I send a question to the desk.
Thank you. The question from Senator Peters is for the House managers. Does the phrase "or other high crimes and misdemeanors" in Article 2, Section 4 of the Constitution require a violation of the U.S. Criminal Code, or is a breach of public trust sufficient? Please explain.
Framers were very clear that abuse of power is an impeachable offense. In explaining why the Constitution must allow impeachment, Edmund Randolph warned that, quote, "the executive will have great opportunities of abusing his power." Alexander Hamilton described high crimes and misdemeanors as offenses which proceed from the abuse or violation of some public trust. The framers also described what it meant. It was impeachable for a president to abuse his pardon power to shelter people he was connected with in a suspicious manner. Future Supreme Court Justice James Iredell said the president would be liable to impeachment if he'd acted from some corrupt motive or other, or if he was willfully abusing his trust. As was later stated in a treatise summarizing centuries of common law, abuse of power occurs if a public officer entrusted with definite powers to be exercised for the benefit of the community wickedly abuses or fraudulently exceeds them. So when the framers said this, that abuse of power was impeachable, it wasn't just an empty, meaningless state. Remember, the founders had been participating with overthrowing the British government, a king who was not accountable. They incorporated the impeachment power into the Constitution late, actually, in the drafting of the Constitution. They knew that they were giving the president many powers, and they specified if he abused them, that those powers could be taken away. Now, the prior articles that the Congress has had on impeachment did not include specific crimes. President Nixon was charged with abusing his power, targeting political opponents, engaging in a cover-up. Now, there was conduct specified. Some of it was clearly criminal, some of it was not. But it was all impeachable because it was corrupt and it was abusing his power. In the House Judiciary Committee, we had witnesses called by both Republicans and Democrats, and the Republican-invited constitutional law expert, Jonathan Turley, testified unequivocally that it is possible to establish a case for impeachment based on a non-criminal allegation of abuse of power. Every presidential impeachment, including this one, has included conduct that violated the law, but each presidential impeachment has included the charges directly under the Constitution. It's important to note that a specific criminal law violation was not in the minds of the founders, and it wouldn't make any sense today. You could have a criminal law violation, you could deface a post office box. That would be a violation of federal law. We would laugh at the idea that would be a basis for impeachment. That is not abuse of presidential powers. It might be a crime. And yet you could have activities that are so dangerous to our Constitution that are not a crime that would be charged as an impeachable offense because they are an abuse of power. That's what the framers worried about. That's why they put the impeachment clause in the Constitution. And frankly, they opined that because of the impeachment clause, no executive would dare exceed their powers. Regrettably, that prediction did not prove true, which is why we are here today with President Trump having abused his broad powers to the detriment of our national interest for a corrupt purpose, his own personal interests. Thank you.
Thank you, counsel.
Mr. Chief Justice.
Senator, thank you.
Thank you, Mr. Chief Justice. I send a question to the desk on behalf of myself and Senator Murkowski.
Thank you, Senator. Senators ask counsel for the President. Describe in further detail your contention that all subpoenas issued prior to the passage of House Resolution 660 are an exercise of invalid subpoena authority by the House committees.
Mr. Chief Justice, thank you, senators, for that question. As I explained the other day, this contention is based on a principle that has been laid out in several Supreme Court cases, explaining that the Constitution assigns powers to each house of the legislative branch, to the House of Representatives or to the Senate. And in particular, the language of the Constitution is clear in Article 1 that the sole power of impeachment is assigned to the House. That's to the House of Representatives as a body. It's not assigned to any committee, to a subcommittee, or to any particular member of the House. And in cases such as Roomley versus United States and the United States versus Watkins, the court has been called, there are disputes about subpoenas. They're not specifically in the impeachment context, but they establish a general rule, a principle, that whenever a committee of either body of Congress issues a subpoena to someone and that person resists the subpoena, the courts will examine what was the authority of that committee or subcommittee to issue that subpoena. And it has to be traced back to some authorizing rule or resolution from the House of Representatives itself, for example, in a House subcommittee. And the courts will examine, the Supreme Court has made clear that that is the charter of the committee's authority. It gets its authority solely from an action by the House itself. That requires a vote of the House, either to establish the committee by resolution or to establish by rule the standing authority of that committee. And if the committee cannot trace its authority to a rule or a resolution from the House, then its subpoena is invalid. And the Supreme Court's made clear in those cases such subpoenas are null and void because they're ultra vires. They're beyond the power of the committee to issue. They can't be enforced. And our point here is very simple. There is no standing rule in the House that provides the committees that were issuing subpoenas here under the leadership of Manager Schiff the authority to use the impeachment power to issue subpoenas. Rule 10 of the House defines the legislative jurisdiction of committees. It doesn't mention the word impeachment even once. And so no committee under Rule 10 was given the authority to issue subpoenas for impeachment purposes. And this has always been the case in every presidential impeachment in the history of the nation. There has always been a resolution from the House first to authorize a committee to use the power of impeachment before it attempted to issue compulsory process. So in this case, there was no resolution from the House. The authority, the sole power of impeachment, remained with the House of Representatives itself, and Speaker Pelosi, by herself, did not have authority, merely by talking to a group of reporters on September 24th, to give the powers of the House to any particular committee to start issuing subpoenas. So the subpoenas that were issued were invalid when they were issued. And then 5 weeks later, on October 31st, when the House finally adopted House Resolution 660, that authorized from that point, purported to authorize at least from that point, the issuance of subpoenas, nothing in that resolution addressed the subpoenas that had already been issued. It didn't even attempt, it didn't purport to say the ones that have already been issued, we're going to try to retroactively give authority for that. It's a separate question whether that could have been done legally. They didn't even attempt to do it. And this is all explained in the opinion from the Office of Legal Counsel, which is in our trial memorandum attached as Appendix C. And it's a very detailed and thorough opinion, 37 pages of legal reasoning, but it explains all of this. The basic principle that applies generally, the history that it has always been done this way. There has always, in every presidential impeachment, been an authorizing resolution from the House, and the fact that there was none here. So there was no authority for those subpoenas. And that means that 23 subpoenas that were issued were invalid. And this was explained, as I pointed out the other day, in letters from the administration to the committees, a letter from the White House, from OMB, I think the State Department, and in very specific terms, it set out this rationale. So that is the basis on which those subpoenas were invalid, and they were properly resisted by the administration. Thank you.
Thank you, counsel. The senator from Pennsylvania.
Mr. Chief Justice, I send a question to the desk.
Thank you. The question is directed to the House managers. In Federalist 65, Alexander Hamilton writes that the subjects of impeachment are, quote, those offenses which proceed from the misconduct of public men or, in other words, from the abuse or violation of some public trust, end quote. Could you speak broadly to the duties of being a public servant and how you believe the President's actions have violated this trust?
Mr. Chief Justice, members of the Senate, President Trump used the powers of his office to solicit a foreign nation to interfere in our elections for his own benefit. Then he actively obstructed Congress in his attempts to investigate his abuses of power. These actions are clearly impeachable. The key purpose of the impeachment clause is to control abuses of power by public officials, that is to say, conduct that violates the public trust. Since the founding of the Republic, all impeachments have been based on accusations of conduct that violates the public trust. When the framers wrote the phrase high crimes and misdemeanors, they intended to capture the conduct of public officials like President Trump, who showed no respect for their oath of office. President Trump ignored the law and the Constitution in order to gain a political favor. The Constitution and his oath of office prohibited him from using his official favor to corruptly benefit himself rather than the American people. That's exactly what the President did, illegally withholding military aid and a White House meeting until the President of Ukraine committed to announcing an investigation of President Trump's opponent. In the words of one constitutional scholar, if what we're talking about is not impeachable, then nothing is impeachable. This is precisely the misconduct that the framers created the Constitution, including impeachment, to protect against. And now I want to add, in reference to some of the comments that were made by some of the President's counsel a few minutes ago. They talk about the subpoena power, about the failure of the House to act properly in the subpoena power, because they said the House did not delegate by rule, have a resolution authorizing the committees to offer subpoena power. They apparently haven't read the fact that the House has generally delegated all subpoena power to the committees. That wasn't true at the time of the Watkins case. It wasn't true 15 years ago, but it is true now. Second, the House has the sole power of impeachment, and the manner of its exercise may not be challenged from outside. Whether the President should be convicted upon our accusation is a question for the Senate. But how we reached our accusation is a matter solely for the House. Thirdly, they talk about executive privilege. And they point to the Nixon case that established executive privilege, that the President has a right to candid advice, and therefore executive privilege is established. But the same case says that executive privilege cannot be used to hide wrongdoing. And in fact, President Nixon was ordered in that case to turn over all the material. Thirdly, there's the doctrine of waiver. You cannot use executive privilege or any other privilege if you waive it. The moment President Trump said that John Bolton was not telling the truth when he said that the President told him of the improper quid pro quo, he waived any executive privilege that might have existed. He cannot characterize a conversation and put it into the public domain and then claim executive privilege against it. The President, by the way, never claimed executive privilege, ever. He has claimed instead absolute immunity, a ridiculous doctrine that the President has absolute immunity from any questioning by the Congress or by anybody else, a claim rejected by every court that has ever considered it. And finally, the difference from this President and any other President claiming privilege of any sort is that this President told us in advance, I will defy all subpoenas. Whatever their nature, I will make sure that the Congress gets no information. In other words, I am absolute. The Congress cannot question what I do because I will defy all subpoenas. I will make sure they get no information, no matter what their rights, no matter what the situation. That is the subject of Article 2 of the impeachment, because that is a claim of absolute monarchical power.
Thank you, Mr. Manager. The Majority Leader is recognized.
I'm going to suggest after two more questions on each side, one more, I've been corrected, as I frequently am. One more question on each side, we take a 15-minute break.
Thank you.
Mr. President.
Yes, the Senator from Kansas.
I sent a question to the desk for the Counsel for the President.
Thank you. Senator Roberts asks, would you please respond to the arguments or assertions the House managers made in response to the previous questions? Directed to the Counsel for the President.
Mr. Chief Justice, members of the Senate, I want to respond to a couple. First, with regard to the question or the issues that have been raised as it relates to witnesses. It's important to note that in the Clinton impeachment proceeding, the witnesses that actually gave deposition testimony were witnesses that had either been interviewed by deposition in the House proceedings, grand jury proceedings, and it was Sid Blumenthal, Verdun Jordan, and Monica Lewinsky. The new witnesses were not being called. That's because the House, in their process, move forward with a full investigation. That did not happen here. There was another statement that was raised by Mr. Chairman Schiff, Manager Schiff, regarding the Chief Justice could make the determination on executive privilege. And again, with no disrespect to the Chief Justice, the idea that the presiding officer of this proceeding could determine a waiver or the applicability of executive privilege would be quite a step. There's nothing historic precedent. There's no historic precedent that would justify it. But there's something else. If we get to the point of witnesses, then, for instance, if one of the witnesses to be called were by the President's lawyers was Adam Schiff, in the role basically of Ken Starr, Ken Starr presented the report, made the presentation before the House of Representatives, had about 12 hours of questioning, I believe, is what Judge Starr had. If Representative Schiff was called as a witness, would in fact then issues of speech and debate clause privilege be litigated and decided by the presiding officer, or would it go to court, or maybe they would waive it? But those would be the kind of issues that would be very, very significant. Senator Graham presented a hypothetical which Manager Schiff said, well, that's not really the hypothetical, but hypotheticals actually are that. They're hypotheticals. But I'll give you, to use Manager Schiff's words, he talked about it would be wrong if the FBI or the Department of Justice was starting a political investigation of someone's political opponent. And I'm thinking to myself, but isn't that exactly what happened? The Department of Justice and the FBI engaged in an investigation of the candidate for President of the United States when they started their operation called Crossfire Hurricane. He said it would be targeting a rival. Well, that's what that did. He said it would be calling for foreign assistance in that. Well, in the particular facts of Crossfire Hurricane, it has been well established now that, in fact, Fusion GPS utilized the services of a former foreign intelligence officer, Christopher Steele, to put together a dossier, and that Christopher Steele relied on his network of resources around the globe, including in Russia and other places, to put together this dossier, which then James Comey said was unverified and salacious, but yet it was the basis upon which the Department of Justice and the FBI obtained FISA warrants, and this was in 2016, against a rival campaign. So we don't have to do hypotheticals. That's precisely the situation. But to take it an additional step, this idea that a witness will be called, if this body decides to go to witnesses, that a witness will be called, would be a violation of fundamental fairness. Of course, if witnesses are called by the House managers through that motion, well, the President's counsel would have the opportunity to call witnesses as well, which we would. Thank you, Mr. Chief Justice.
Thank you, counsel. Oh, Senator?
Mr. Chief Justice, I send a question to the
California,
desk.
Of course.
Thank you.
The question from Senator Harris is for the House managers. President Nixon said, quote, "When the president does it, that means that it is not illegal," end quote. Before he was elected, President Trump said, quote, "When you're a star, they let you do it, you can do anything," end quote. After he was elected, President Trump said that Article 2 of the Constitution gives him, quote, "the right to do whatever he wants as president," end quote. These statements suggest that each of them believed that the president is above the law, a belief reflected in the improper actions that both presidents took to effect their re-election campaigns. If the Senate fails to hold the president accountable for misconduct, how would that undermine the integrity of our system of justice?
Mr. Chief Justice, Senators, I think this is exactly the fear. I think if you look at the pattern in this president's conduct and his words, what you see is a president who identifies the state as being himself. When the president talks about people that report his wrongdoing, for example, when he describes a whistleblower as a traitor or a spy, The only way you can conceive of someone who reports wrongdoing as committing a crime against the country is if you believe that you are synonymous with the country, that any report of wrongdoing against the president, the person of the president, is a treasonous act. It is the kind of mentality that says, under Article 2, I can do whatever I want, that I'm allowed to fight all subpoenas. Now, counsel has given a variety of explanations for the fighting of all subpoenas. They might have a plausible argument if the administration had given hundreds of documents but reserved some and made a claim of privilege, or the administration has said, we'll allow these witnesses to testify, but with these witnesses, with these particular questions, we want to assert a privilege. But of course, that's not what was done here. What we have instead is a shifting series of rationales and explanations and duplicitous arguments, some made in court and some made here. You have the argument that the subpoenas aren't valid before the House resolution, and then with respect to subpoenas issued after the House resolution, like to Mulvaney, well, those are no good either. You have the argument made that we have absolute immunity, and the court that addresses this says, no, you don't. You're not a king. That argument may be thought of with favor by various presidents over history. It has never been supported by any court in the land. There's no constitutional support for that either. Documents that are being released right now as we sit here, and it's a mystery to the country and it's a mystery to some of us, how are private litigants able to get documents through the Freedom of Information Act that the administration has withheld from Congress? If they were operating in any good faith, would that be the case? And of course the answer is no. What we have instead is we're going to claim absolute immunity even though the court says that doesn't exist. Now, they said, well, the House withdrew the subpoena on Dr. Kupperman. Why would they withdraw the subpoena on Dr. Kupperman when he was only threatening to tie you up endlessly in court? Now, we suggested to counsel for Dr. Kupperman that if they had a good faith concern about testifying, if this was really good faith and it wasn't just a stratagem to delay, if it wasn't just part of the president's wholesale fight all subpoenas, they didn't need to file separate litigation because there was actually a case already in court involving Don McGahn on that very subject that was ripe for decision. Indeed, the decision would come out very shortly thereafter. And we said, let's just agree to be bound by what the McGahn court decides. Well, they didn't want to do that, and it became obvious once the McGahn court decision came out because the McGahn court said, there's no absolute immunity, you must testify. And by the way, if you think people involved in national security, i.e. Dr. Kupperman and John Bolton, if you're listening, if you think you're somehow absolutely immune, you're not. So did Dr. Kupperman said, well, now I have the comfort I needed because the court has weighed in? The answer is, of course not. Now, counsel says, well, we might have gotten a quick judgment in Kupperman. Yeah, in the lower court. Do any of you believe for a single minute they wouldn't appeal to the Court of Appeals and to the Supreme Court? And the Supreme Court struck down the absolute immunity argument. They wouldn't be back in the district court saying, okay, he's not absolutely immune anymore, but we're going to claim executive privilege over specific conversations that go to the president's wrongdoing. Okay, that is the sign of a president who believes he is above the law, that Article 2 empowers him to do anything he wants. And I'll say this, if you accept that argument, if you accept the argument that the President of the United States can tell you to pound sand when you try to investigate his wrongdoing, there will be no force behind any Senate subpoena in the future. The fighting all subpoenas started before the impeachment. If you allow a president to obstruct Congress so completely in a way that Nixon could never have contemplated, nor would the Congress of that day have allowed, you will eviscerate your own oversight capability, not
Thank
just
you,
in
counsel.
impeachments.
The majority leader is recognized.
I suggest that we resume at 4 o'clock.
Without objection, so ordered.
Okay, so they are in recess until 4 p.m. Eastern Standard Time. So that's in about 20 minutes. So, I guess we're going to put on some tunes until they come back. My internet's going a little bit crazy. It was going crazy before while I was trying to chat, so sorry I just kind of stopped talking there. But thank you for joining a person. We have a person in the chat. I really like your screen name. That amuses me. Alright, so we're just going to put on some tunes. I did not know that they were going to be doing like a back and forth kind of thing today. And so I wish I could have snagged some little clips of the questions, but maybe I can do that later. It's so much to keep up with, especially with my not very good internet and computer. But I'm trying, you guys. I'm trying to get all the different kinds of information out to you. So if you haven't checked out our other content and the other kinds of things that I do, then go ahead and check out like the live stream that I did this morning or yesterday morning. I covered, this morning I covered a whole bunch of recalls that have gone unnoticed and the FDA doing stuff with gene therapy. My internet's going really crazy. Alright, I'm just gonna have to probably stop talking and just put on the tunes and just see if it works. Because I don't know if it's skipping or if it's lagging or buffering. I don't know. I don't know. It keeps going back and forth. Okay, so if you haven't checked out our other content, then make sure you do so, because the impeachment trials are just like one thing that I try to cover. So check out the other stuff as well, and thanks for joining, everybody. Make sure you're subscribed. Check us out on Twitter and Instagram at GrowTheInfo, and our website growtheinfo.com, where you can find press releases and all kinds of other good stuff. And again, if this stream cuts out, because my internet's going really wonky right now, it's kind of stormy here today, so if my internet cuts out and you want to keep watching the impeachment trials and you don't want to support the mainstream media, you can watch them on senate.gov. Alright, so let's put on some tunes.
the senator from South Dakota, Oklahoma. Senators ask the following question of the counsel for the president. Mr. Cipollone, as members of the Senate Armed Services Committee, we listened intently when Manager Crow was defending one of Senator Schumer's amendments to the organizing resolution last week, as he explained how he had firsthand experience being denied military aid when he needed it during his service. As you know, David Hale, Undersecretary of State for Political Affairs, confirmed that the lethal aid provided to Ukraine last year was future aid. Which would you say had the greater military impact? President Trump's temporary pause of 48 days on future aid that will now be delivered to Ukraine, or President Obama's steadfast refusal to provide lethal aid to Ukraine for 3 years, more than 1,000 days, while Ukraine attempted to hold back Russia's invasion and preserve its sovereignty?
Mr. Chief Justice, thank you, senators, for that question. And I think it was far more serious and far more jeopardy for the Ukrainians, the decision of the Obama administration to not use the authority that was given by Congress, that many of you all and many members of the House of Representatives voted for, giving the U.S. government the authority to provide lethal aid to the Ukrainians, and the Obama administration decided not to provide that aid. And multiple witnesses who were called in the House by the House Democrats testified that the United States policy towards Ukraine got stronger under the Trump administration, in part largely because of that lethal aid. Ambassador Yovanovitch, Ambassador Volker, others also testified that U.S. policy in providing that aid was greater support for Ukraine than was provided in the Obama administration, particularly the provision of Javelin anti-tank missiles, which they explained were lethal and would kill Russian tanks and change the calculus for aggression for the Russians in the Donbass region in the eastern portion of Ukraine, where that conflict is still ongoing. In terms of the pause, the temporary pause on aid here, the testimony in the record, put aside what the House managers have said about their speculation, and they know what it's like to be denied aid. The testimony in the record is that this temporary pause was not significant. Ambassador Volker testified that the brief pause on releasing the aid was, quote unquote, not significant. And Undersecretary of State for Political Affairs David Hale explained that, quote, this was future assistance, not to keep the Army going now. So in other words, this isn't money that had to flow every month in order to fund current purchases or something like that. It was money, it's 5-year money. Once it's obligated, it's there for 5 years. And it usually takes quite a bit of time to spend all of it. So the idea somehow that during the couple of months in July, August, and up till September 11th, 55 to 48 days, depending on how you count it, that this was somehow denying critical assistance to the Ukrainians on the front lines right then, it's simply not true. And now the House managers have tried to pivot away from that because they know it's not true, and to say, no, it was the signal to the Russians. It was the signal of lack of support that the Russians would pick up on. But here again, it's critical. Even the Ukrainians didn't know that the aid had been paused. And part of the reason was they never brought it up in any conversations with representatives of the U.S. government. And as Ambassador Volker testified, representatives of the U.S. government didn't bring it up to them because they didn't want anyone to know. They didn't want to put out any signal that might be perceived by the Russians or by the Ukrainians as any sign of lack of support. It was kept internal to the U.S. government. They've pointed to some emails that someone at the Department of Defense or Department of State, Laura Cooper, received from unnamed embassy staffers suggesting that there was a question about the aid. But her testimony was she couldn't even remember what the question really was, and she didn't want to speculate. There's not evidence that any decision makers in the Ukraine government knew about the pause. And just the other day, another article came out, I believe it was from at the time, the Foreign Minister Daniluk, explaining that when the Politico article was published on August 28th, there was panic in Kiev because it was the first time they realized there was any pause on the aid. So that was not something that was providing any signal either to the Ukrainians or the Russians because it wasn't known. It was 2 weeks later, after it became public, that the aid was released. The testimony in the record is that the pause was not significant. It was future money, not for current purchases, and it was released before the end of the fiscal year. They point out that some of it wasn't out the door by the end of the fiscal year. That happens every year. There's some percentage that doesn't make it out the door by the end of the year. And again, it's 5-year money. It's not like it's all going to be spent in the next 30, 60, 90 days anyway. So the fact that there was a little fix, Congress passed a fix to allow that $35 million to be spent. Something similar happens for some amount almost every year, and it was not affecting current purchases. It wasn't jeopardizing anything at the front lines. There's no evidence about that in the record. The evidence is to the contrary. Thank you.
Thank you, counsel.
Mr. Chief Justice.
Senator from Maine.
Mr. Chief Justice, I have a question for both sets of counsel, which I'm sending to the desk.
The question from Senator King is for both counsel to the President and the House managers. President Trump's former Chief of Staff, General John Kelly, has reportedly said, quote, "I believe John Bolton," end quote, and suggests Bolton should testify, saying, quote, "If there are people that could contribute to this, either innocence or guilt, I think they should be heard," end quote. Do you agree with General Kelly that they should be heard? I think, counsel for the President, it's your turn to go first.
Thank you, Mr. Chief Justice, members of the Senate. This was a bit of a topic that I discussed yesterday, and that was the information that came out in the New York Times piece about what is purportedly in a book by Ambassador Bolton. Now, as I've said, the idea that a manuscript that's not in the book, there's not a quote from the manuscript in the book, this is a perception of what the statement might be. There have been very forceful statements, not just from the President, but from the Attorney General. The Department of Justice stated that while the Department of Justice has not reviewed Mr. Bolton's manuscript, the New York Times account of this conversation grossly mischaracterizes what Attorney General Barr and Mr. Bolton discussed. There was no discussion of, and this again, personal favors or undue influence on investigations, nor did Attorney General Barr state that the President's conversations with foreign leaders were improper. So again, that goes to some of the allegations that were in the article. The Vice President said the same thing. He said, in every conversation with the President and Vice President in preparation for our trip to Poland, the President consistently expresses frustration that the United States was bearing the lion's share of responsibility. There's also an interview that Ambassador Bolton had given, I think in August, about the conversation where he said it was a perfectly appropriate conversation. I think that information's publicly available now. So again, to move that into a change in proceeding, so to speak, I think is not correct. The evidence that has already been presented, a accusation that if you get into witnesses, I'll do this very briefly, if we get down the road on the witness issues, let's be clear. It should not be, I certainly can't dictate to this body, it should certainly not be, though, that the House managers get John Bolton and the President's lawyers get no witnesses. We would expect if they're going to get witnesses, we will get witnesses, and those witnesses would then, but all of that, just to be clear, changes the nature and scope of the proceedings. They didn't ask for it before.
Thank you, counsel.
Senator Justice, what's the significance of the President's former Chief of Staff saying that he believes John Bolton and implicitly does not believe the President, that Bolton should testify? It's really, at the end of the day, not whether I believe John Bolton or whether General Kelly believes John Bolton, but whether you believe John Bolton, whether you'll have an opportunity to hear directly from John Bolton, whether you have the opportunity to evaluate his credibility for yourself. Now, there are a few arguments made against this. Some are rather extraordinary. It would be unprecedented, the suggestion, I think, is to have witnesses in a trial. What an extraordinary idea. But as my colleagues have said, it would be extraordinary not to. This will be the first impeachment trial in history that involves no witnesses if you decide you don't want to hear from any, that you simply want to rely on what was investigated in the House. That would be unprecedented. Yes, we should be able to call witnesses, and yes, so should the President. Relevant witnesses. Now, the President says that you can't believe John Bolton, and Mick Mulvaney says you can't believe John Bolton. Well, let the President call Mick Mulvaney, another relevant witness with firsthand information. If he's willing to say publicly, not under oath, that Bolton is wrong, let him come and say that under oath. Yes, we're not saying that just one side gets to call witnesses, both sides get to call relevant witnesses. Now, they also make the argument implicitly, well, this is going to take long. Senator's got to warn you, if you run a real trial, it's going to require witnesses, and that's going to take time. And I think the underlying threat, and I don't mean this in a harsh way, but is we're going to make this really time-consuming. The deposition took place very quickly in the House. We have a perfectly good Chief Justice behind me that can rule on evidentiary issues. What's more, the President has waived and waived and waived any claim about national security here by talking about himself, by declassifying the call record. We're not interested in asking John Bolton about Venezuela or other places or other countries, just Ukraine. And if there's any question about it, the Chief Justice can resolve. These are relevant questions to the matter at hand. What you cannot do is use privilege to hide wrongdoing of an impeachable kind and character.
Thank you, Mr. Manager. The Senator from Utah.
I send a question to the desk on behalf of myself and Senators Cruz and Hawley.
The question is directed to Counsel for the President. Is it true that Sean Misko, Abigail Grace, and the alleged whistleblower were employed by or detailed to the National Security Council during the same time period between January 20, 2017 and the present? Do you have reason to believe that they knew each other? Do you have any reason to believe that the alleged whistleblower and Misko coordinated to fulfill their reported commitment to, quote, do everything we can to take out the President, end quote?
Mr. Chief Justice, Senators, the only knowledge that I have of this comes from public reports. I gather that there is a news report in some publication that suggests a name for the whistleblower, suggests where he worked, that he worked at that time while detailed the NSC staff for then Vice President Biden, and that there were others who worked there. We have no knowledge of that other than what's in those public reports, and I don't want to get into speculating about that. It is something that, to an unknown extent, may have been addressed in the testimony of the Inspector General of the intelligence community before Chairman Schiff's committees, but that testimony, contacts with the whistleblower, contacts between members of Manager Schiff's staff and the whistleblower are shrouded in secrecy to this day. We don't know what the testimony of the ICIG was. It remains secret. It has not been forwarded. We don't know what Manager Schiff's staff's contact with the whistleblower have been and what connections there are there. It's something that would seem to be relevant since the whistleblower started this entire inquiry, but I can't make any representations that we have particular knowledge of the facts suggested in the question. We know that there was a public report suggesting connections and prior working relationships between certain people. Not something that I can comment on other than to say that there's a report there. We don't know what the ICIG discussed. We don't know what the ICIG was told by the whistleblower. Other public reports about inaccuracies in the whistleblower's report to the ICIG. We don't know the testimony on that. We don't know the situation of the contacts, coordination, advice provided by Manager Schiff's staff to the whistleblower. That all remains unknown, but something that obviously, to get to the bottom of motivations, bias, how this was all, this inquiry was all created, could potentially be relevant. Thank you.
Thank you, counsel. The senator from New Mexico.
Mr. Chief Justice, I send a question to the desk for the President's counsel.
When did the President's counsel first learn that the Bolton manuscript had been submitted to the White House for review, and has the President's counsel or anyone else in the White House attempted in any way to prohibit, block, disapprove, or discourage John Bolton or his publisher from publishing his book?
Thank you, Mr. Chief Justice, and thank you, Senator, for the question. At some point, I don't know off the top of my head the exact date. The manuscript had been submitted to the NSC for review. It is with career NSC staff for review. The White House counsel's office was notified that it was there. The NSC has released a statement explaining that it has not been reviewed by anyone outside NSC staff. In terms of the second part of the question, has there been any attempt to prevent its publication or to block its publication? I think that there was some misinformation put out into the public realm earlier today, and I can read for you a relatively short letter that was sent from NSC staff to Charles Cooper, who is the attorney for Mr. Bolton, on January 23rd, which was last week, which says, "Dear Mr. Cooper, thank you for speaking yesterday by telephone. As we discussed, the National Security Council Access Management Directorate has been provided the manuscript submitted by your client, former Assistant to President John Bolton, for pre-publication review. Based on our preliminary review, the manuscript appears to contain significant amounts of classified information. It also appears that some of this classified information is at the top secret level, which is defined by Executive Order 13526 as information that, quote, reasonably could be expected to cause exceptionally grave harm to the national security of the United States if disclosed without authorization. Under federal law and the non-disclosure agreements your client signed as a condition for gaining access to classified information, the manuscript may not be published or otherwise disclosed without the deletion of this classified information. The manuscript remains under review in order for us to do our best to assist your client by identifying the classified information within the manuscript, while at the same time ensuring the publication does not harm the national security of the United States. We will do our best to work with you to ensure your client's ability to tell his story in a manner that protects U.S. national security. We will be in touch with you shortly with additional, more detailed guidance regarding next steps that should enable you to revise the manuscript and move forward as expeditiously as possible. Sincerely, and then the signature of the career official. So it is with the NSC, doing their pre-publication review, through his lawyer, Ambassador Bolton was notified that the manuscript he submitted contains a significant amount of classified information, including at the top secret level, so that in its current form, it can't be published, but that they will be working with him as expeditiously as possible to provide guidance so it can be revised and so that he can tell his story. And that was the letter from the NSC that went out. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Iowa.
Mr. Chief Justice, I send a question to the desk on behalf of myself and Senators Burr, McSally, Daines, Moran, Young, and Sass.
The senator's question is directed to counsel for the president. Is it true the Trump administration approved supplying Javelin anti-tank missiles to Ukraine? Is it also true this decision came on the heels of a nearly 3-year debate in Washington over whether the United States should provide lethal defense weapons to counter further Russian aggression in Europe? By comparison, did President Obama refuse to send weapons or other lethal military gear to Ukraine? Was this decision against the advice of his defense secretary and other key military leaders in his administration?
Mr. Chief Justice, thank you, Senators, for the question. Yes, the Trump administration made the decision to provide Javelin anti-tank missiles, and there was a significant debate about that for some time. Authorization had been granted by Congress, and many of you voted for that statutory authorization during the Obama administration to provide lethal assistance to Ukraine. But the Obama administration decided not to provide that. It was only the Trump administration that made that lethal assistance available. And there was a significant amount of testimony in the House proceedings that President Trump's policy towards Ukraine was actually stronger. Ambassador Volker explained that America's policy toward Ukraine has been strengthened under President Trump, and that each step along the way in the decisions that got to the Javelin missiles being provided was made by President Trump. It is something that has substantially strengthened our relationship with Ukraine and strengthened their ability to resist Russian aggression. Ambassador Yovanovitch said that President Trump's decision to provide lethal weapons meant that our policy actually got stronger over the last 3 years, and she called it very significant. Another point to make in relation to this is, again, that the temporary pause that took place over the summer is something that the Ukrainian Deputy Defense Minister described as being so short that they didn't even notice it. So President Trump's policies across the board have been stronger than the prior administration's in providing defensive capability, lethal defensive capability, to the Ukrainians. And I think that that's significant. The specific part of the question, Senators, whether it was contrary to the advice of the President's Defense Secretary and others, I believe that that is accurate. It was against the advice of the Secretary of Defense. It was President Trump's decision to provide this lethal assistance, and that has been made public in the past. Thank you.
Thank you, counsel. Senator Feinstein.
Thank you, Mr. Chief Justice. I send a question to the desk on behalf of Senator Carper, Coons, Hirono, Leahy, Tester, Udall, to the House managers, and on behalf of myself. Thank you.
Senator Feinstein and the other senators is to the House managers. The President has taken the position that there should be no witnesses and no documents provided by the executive branch in response to these impeachment proceedings. Is there any precedent for this blanket refusal to cooperate, and what are the consequences if the Senate accepts this position here?
Mr. Chief Justice and Senators, President Trump has taken really an extreme measure to hide this evidence from Congress. No president has ever issued an order to direct a witness to refuse to cooperate in an impeachment inquiry before this. Despite his famous attempts to conceal the most damaging evidence against him, even President Nixon allowed senior officials to testify under oath. Not only did he allow them, he told them to go to Congress voluntarily and answer all relevant questions truthfully. But President Trump issued a blanket order directing the entire executive branch to withhold all documents and testimony from the House of Representatives. This order was categorical, it was indiscriminate, unprecedented. Its purpose was clear: to prevent Congress from doing its duty under the Constitution to hold the president accountable for high crimes and misdemeanors. Telling every person who works in the White House and every person who works in every department, agency, and office of the executive branch is just not precedented. It wasn't about specific, narrowly defined privileges. He never asserted privileges. And the President's counsel has mentioned over and over that he had some reason because of the subpoenas. Well, I'll tell you, we adopt rules about subpoenas in the House. The Senate is a continuing body, but the House isn't. And in January, we adopted our rules, and it allows the committee chairman to issue subpoenas. And that's what they did. He refused to comply with those subpoenas, not because he exerted executive privilege, because he didn't like what we were doing. He tried to say it was invalid, but it was valid, and actually he doesn't have the authority to be the arbiter of the rules of the House. The House is the sole arbiter of its rules when it comes to impeachment. Now, this refusal to give testimony documents, it's still going on. We still have former or current administration officials who are refusing to testify. We would not allow this in any other context. If a mayor said, I'm not going to answer your subpoenas, they'd be dealt with harshly if it was to cover up misdeeds and crimes as we have here. So mayors have actually gone to jail for doing that. If we allow the president to avoid accountability by simply refusing to provide any documents, any witnesses, unlike every single president who preceded him, we're opening the door not just to eliminating the impeachment clause in the Constitution. Try doing oversight. Try doing oversight, senators, and we're thinking about that in the House. If the president can just say, we're not sending any witnesses, we're not sending any documents, we don't have to, we don't like your processes, we have a wholesale rejection of what you're doing. That's not the way our Constitution was created, where each body has a responsibility. There's a sharing of power. And I know you, cherish the responsibility that we have. That will be eviscerated if the president's complete stonewalling is allowed to persist and be accepted by this body. You have to act now in this moment of history. I yield back.
Thank you.
Mr. Chief Justice.
Senator from West Virginia.
Thank you. I send a question to the desk for the President's counsel.
The senator's question is for counsel for the president. You said that Ukrainian officials didn't know about the pause on aid until August 28, 2019, when it was reported in Politico. But didn't Laura Cooper, the Deputy Assistant Secretary of Defense for Russia, say that members of her staff received queries about the aid from the Ukrainian embassy on July 25? Does that mean that Ukrainian officials knew about the hold on aid earlier than the Politico article?
Mr. Chief Justice. Members of the Senate, Senator, thank you for your question. It does not mean that. As we explained on Saturday, the overwhelming body of evidence indicates that the Ukrainians at the very highest levels, President Zelensky and his top advisors, only became aware of the pause in the security assistance through the August 28 Politico article. I addressed on Saturday, and so those comments will stand, the emails from the Deputy Assistant Secretary of Defense, Laura Cooper, testified about previously. What she had said was that her staff had gotten emails from someone at the State Department who had had some sort of conversation with Ukrainian officials here that somehow related to the aid at a time prior to August 28. She did not know the substance of the emails, nor whether they mentioned hold, pause, review, anything of that nature. And she even said herself that she didn't want to speculate as to what the emails mean and cannot say for certain what they were about. I presented on Saturday the evidence, which again, referencing the common sense that would be in play here. This was something that on August 28th caused a flurry of activity among the highest-ranking Ukrainian officials. Never before did they raise any questions at any of the meetings they had with the high-ranking U.S. officials through July and August. There were meetings on July 9, July 10, July 25 call, July 26, and August 27. At none of those meetings was the pause on aid revealed or inquired about. However, as soon as the Politico article came out on August 28th, within hours of that Politico article coming out, Mr. Yermak texted the article to Ambassador Volker and asked to speak with him. That's consistent with someone finding out about it for the first time. The Ukrainians have also made statements that they learned about it for the first time, and then Mr. Philbin just referenced an article that came out yesterday in the Daily Beast, which was an interview with Mr. Daniluk, who was at the time a very high-ranking defense official with the Ukrainians. And this is interesting, and I'm going to read this article because I think it's important, and I suggest it to the Senate if they wish to have something to consider further on this. Daniluk said he first found out that the U.S. was withholding aid to Ukraine by reading Politico's article published August 28. U.S. officials and Ukrainian diplomats, including the country's foreign minister, Elena Zerkal, have said publicly that Kiev was aware that there were problems as early as July. And that's the article that they've mentioned in the statement that the House members have mentioned. Here's Mr. Daniluk. I was really surprised and shocked because just a couple of days prior to that, I actually had a meeting with John Bolton. Actually, I had several meetings with him, and we had extensive discussions. The last thing I'd expected to read was an article about military aid being frozen, Daniluk said. After that, I was trying to get the truth. Was it true or not true? Daniluk said that it was a panic inside the Zelensky administration after the initial news broke, saying Zelensky was convinced there had been some sort of mistake. That's President Zelensky. Daniluk put in calls to the National Security Council and asked other officials in Washington what to make of the news, again on August 28th, or right after August 28th. The next time we met in September, it was in Poland for the commemoration of the beginning of the Second World War. the Warsaw meeting we've discussed previously. Daniluk said, adding that he met with Bolton on the sidelines of the commemoration. I had my suspicions. There was a special situation with one of our defense companies that were acquired by the Chinese, and the U.S. was concerned about this. Bolton actually made the public comments about this as well. So somehow I linked this to things and tried to understand, okay, maybe this could be related to this. So not only did they not know until August 28th, when they did find out, they didn't link it to any investigations. Where's the quid pro quo? If this is such the forefront of their minds, such pressure on them that the Ukrainians have to do these investigations to get the aid, when the aid was held up, they didn't think it was connected to the investigations.
Thank you, counsel.
Thank you, Mr. Chief.
The Senator from Maryland.
Mr. Chief Justice, I have a question on behalf of Senator Baldwin and myself I sent to the desk.
The question is addressed to the House managers. Is the White House correct in its trial memorandum and in presentations of its case that, quote, President Zelensky and other senior Ukrainian officials did not even know that the security assistance had been paused, end quote, before seeing press reports on August 28, 2019, which was more than a month after the July 25 phone call between Presidents Zelensky and Trump?
Thank you, Chief Justice and Senators, for the question. The answer is no. The evidence does not show that. We know that Defense Department official Laura Cooper testified that her staff received 2 emails from the State Department on July 25th revealing that the Ukrainian embassy was, quote, asking about security assistance. And in fact, counsel for the president brought up these emails just now. So I would propose that the Senate subpoena those emails so we can all see for ourselves what exactly was happening. We also know that career diplomat Catherine Cross stated that she was, quote, very surprised at the effectiveness of my Ukrainian counterparts' diplomatic tradecraft, as in to say they found out very early on or much earlier than I expected them to, end quote. And that Lieutenant Colonel Alex Vindman testified that by mid-August he was getting questions from Ukrainians about the status of security assistance. So the evidence shows over and over again from the House inquiry that there was a lot of discussion, and there should be. Because we also know that delays matter. They matter a lot. And you don't have to take my word for it. You know, this is not just about a 48-day delay. The Ukrainians were consistently asking about it because it was urgent. They needed it. They needed it, and who else was asking for it was American businesses. The contractors who are going to be providing this were also making inquiries about it because there's a pipeline. And as my esteemed Senate Armed Services colleagues know very well, that providing aid is not like turning on and off a light switch. You have to hire employees. You have to get equipment. You've got to ship it. It takes a long time for that pipeline to go. And in fact, I had to come together as a Congress to pass a law to extend that timeline because we were at risk of losing it. And to this day, $18 million of that aid have still not been spent. But let's just assume for a minute, also broadly speaking, that the President's counsel's argument that support for Ukraine has never been better than it is today. That under the Trump administration, they are the strongest ally the Ukraine has seen in years. So just assuming for a minute that argument to be true, it kind of makes our own argument. It kind of makes our argument. Then why hold the aid? Why hold the aid? Because nothing had changed in 16, nothing had changed in 17, nothing had changed in 18. One thing had changed in 19, and that was Vice President Biden was running for president. Lastly, the question before by my Senate Armed Services colleagues framed this in terms of the military impact. And they asked what was greater in terms of military impact, not providing lethal aid or a 48-day delay. Let's not forget the reason for the delay, because there's a lot of discussion today about the technicalities of the delay, and that the president's mentality, his mindset doesn't matter. It doesn't matter what he intended to do. But I would posit that's exactly why we're here. That it does matter what the president intended to do, because the American people, in matters of national security, deserve to go to bed every night knowing that the president, the commander-in-chief, the person who is ultimately responsible for the safety and security of our nation every night, has the best interests of them and their families in this country in mind, not the best interests of his political campaign. And that is why we are here.
Mr. Manager.
Mr. Chief Justice.
Senator.
I sent a question to the desk on behalf of myself and Senator Murkowski.
The question is to counsel for the President. Witnesses testified before the House that President Trump consistently expressed the view that Ukraine was a corrupt country. Before Vice President Biden formally entered the 2020 presidential race in April 2019, did President Trump ever mention Joe or Hunter Biden in connection with corruption in Ukraine to former Ukrainian President Poroshenko or other Ukrainian officials, President Trump's cabinet members or top aides or others? If so, what did the President say to whom and when?
Mr. Chief Justice, Senators, thank you for that question. Of course, I think it's important at the outset to frame the answer by bearing in mind I'm limited to what's in the record, and what's in the record is determined by what the House of Representatives sought. It was their proceeding. They were the ones who ran it. They were the ones who called the witnesses. So part of the question refers to conversations between President Trump and other cabinet members and others like that. There's not something in the record on that. It wasn't thoroughly pursued in the record. So I can't point to something in the record that shows President Trump at an earlier time mentioning specifically something related to Joe or Hunter Biden. It is in the record that he spoke to President Poroshenko twice about corruption in the Ukraine, both in June of 2017 and again in September of 2017. But there is other information publicly available and in the record that I think is important for understanding the timeline and understanding why it was that the information related to the Bidens and the Burisma affair came up when it did. So one important piece of information to bear in mind is President Poroshenko was the person that Joe Biden himself, on the tapes we've seen, went to have the prosecutor fired. So as long as President Poroshenko was still in charge in Ukraine, he was the person that Joe Biden had spoken to get the prosecutor, Shokin, fired when Shokin was looking into, according to public reports, looking into Burisma. As long as he was still the president in Ukraine, questioned the utility of raising an incident in which he was the one who was taking the direction from Vice President Biden to fire the prosecutor. So when you have an election in April of 2019, and you have a new president, President Zelensky, who is run on an anti-corruption platform, and there is a question, is he really going to change things? Is there going to be something new in the Ukraine? It opens up an opportunity to start looking really at anti-corruption issues and raising questions. Now, the other important thing to understand in the timeline is that we've heard a lot about Rudy Giuliani, the president's private lawyer, and what was he interested in Ukraine, and what was his role? Well, as we know, it's been made public, Mr. Giuliani, as the president's private lawyer, had been asking a lot of questions in the Ukraine dating back to the fall of 2018. And in November 2018, he said publicly he was given some tips about things to look into. He gave a dossier to the State Department in March of this year. Remember, Vice President Biden announces his candidacy in April 25th. In March, Rudy Giuliani gave documents to the State Department, including interview notes from interviews he conducted both with Shokin and with Yuri Lutsenko, who was also a prosecutor in the Ukraine. And those interview notes are from January 23rd and January 25th, 2019, so months before Vice President Biden announced any candidacy. And it goes through in these interview notes, Shokin explaining that he was removed at the request of Mr. Joseph Biden, the Vice President. And it explains that he had been investigating Burisma and that Hunter was on the board. And it raises all of the questions about that. So it was Mr. Giuliani who had been, as Jane Raskin explained the other day as counsel for the president here, Mr. Giuliani as counsel for the president is looking into what went on in Ukraine. Is there anything related to 2016? Are there other things related there? And he's given this information, tips about this, and starts pursuing that as well. And he's digging into that in January of 2019. We know that Mr. Giuliani is the president's private counsel. I can't represent specific conversations they had. They would be privileged. But we do know from testimony that the president said in a May 23rd Oval Office meeting with respect to Ukraine, talk to Rudy. Rudy knows about Ukraine. So the president, it seems from that, gets information from Mr. Giuliani. Months before Vice President Biden announced his candidacy, Mr. Giuliani is looking into this issue, interviewing people and getting information about it. In addition, in March of 2019, articles began to be published. Then 3 articles were published by ABC, by The New Yorker, and by The Washington Post before the July 25th call. Washington Post on July 22nd, 3 days before the call, has an article specifically about the Bidens and Burisma. That's what makes it suddenly current, relevant, probably to be in someone's mind. So that's the timeline.
Mr. Chief Justice.
Senator from California.
Thank you. I sent a question to the desk on behalf of Senator Patty Murray and myself.
Senator Harris and Murray ask the House managers. The House of Representatives is now in possession of a tape of President Trump saying of Ambassador Maria Yovanovitch, quote, "Get rid of her, get her out tomorrow. I don't care, get her out tomorrow, take her out, okay, do it," end quote. President Trump gave this order to Lev Parnas and Igor Fruman, 2 men who carried out Trump's pressure campaign in Ukraine at the direction of Rudy Giuliani. Does the discovery of this tape suggest that if the Senate does not pursue all relevant evidence, including witnesses and documents, that new evidence will continue to come to light after the Senate renders a verdict?
The answer is yes. What we have seen really over the last several weeks since the passage of the articles in the House of Representatives is every week, indeed, sometimes every day, there is new information coming to light. We know there's going to be new information coming to light on March 17th when the Bolton book comes out. That is, if the NSC isn't successful in redacting it or preventing much of its publication. And on that issue, I do want to mention one other thing in response to the question about the Bolton manuscript and what did the White House lawyers know, because I listened very carefully to the answer to that question, and maybe you listened more carefully than I did. What I thought I heard them say in the answer to that question, what did they know about the manuscript and when did they know it? Their statement was very precisely worded. The NSC unit reviewing the book did not share the manuscript. Well, that's a different question than whether the White House lawyers found out what's in it. Because you don't have to circulate the manuscript to have someone walk over to the White House and say, you do not want John Bolton to testify. Let me tell you, you do not want John Bolton to testify. You don't need to read his manuscript because I can tell you what's in it. So the denial was a very carefully worded one. I don't know what the White House lawyers knew and when they knew it, but they did represent to you repeatedly that the president never told a witness that he was freezing the aid to get Ukraine to do these investigations. And we know that's not true. You know that from the witnesses we've already heard from, but we also know, at least if the reporting is correct, and you should find out if it is, that John Bolton tells a very different story. So there are going to continue to be revelations, and members of this body on both sides of the aisle are going to have to answer a question each time it does, why didn't you want to know that when it would have helped inform your decision? In every other trial in the land, you call witnesses to find out what you can. Again, we're not a court of appeals here. We are the trial court. We're not confined to the record below. There is no below. Counsel says, in answer to the senator's question about whether Donald Trump ever brought up the Hunter Biden problem with President Poroshenko in the past, and says, well, we're confined to the record before us. You're not confined to the record in the House, nor is the president. The president could call witnesses if they existed. There's nothing to prevent them from saying, as a matter of fact, tomorrow we're going to call such and such, and they're going to testify that indeed Donald Trump brought up Hunter Biden to President Poroshenko. There's nothing prohibiting them from doing that. But at the end of the day, we are going to continue to see new evidence come out all the time. But among the most significant evidence, we know what that's going to be. And the effort to suggest that, well, because this president was stronger on javelins than his predecessor, when we know from the July 25th call, the moment that Zelensky brings up the javelins, what's the very next thing the president says? He wants a favor. The question is, why did he stop the aid? Why did he stop the aid this year and no prior year? Was it merely a coincidence? Are we to believe it was merely a coincidence that it was the year that Joe Biden was running for president? Are we to believe that of all the companies and all the land, of all the gin joints and all the land in Ukraine, that it was just Hunter Biden walking into this one? That was the reason why that he was interested in Burisma, was just a coincidence that involved the son of his opponent. But look, more and more is coming out. Let's make sure that you learn whatever you feel you need to know to render a judgment now, when it can inform your decision, and not later.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from Nebraska.
I send a question to the desk on behalf of myself, Senator Crapo, and Senator Risch.
Thank you. The senators ask counsel for the president. The President's counsel has underscored the administration's ongoing anti-corruption focus with our allies. At what point did the United States government develop concerns about Burisma in relation to corruption and concerns with Russia?
That question, and I think it bears on the answer that I was last giving to the last question. This is something that became, of course, President Trump, in his conversation with President Zelensky in the July 25th call, as the transcript shows us, brought up a couple of things. He brought up burden sharing specifically, and he raised the issue of corruption in two specifics. The specific case of potential Ukrainian interference in the 2016 election, which he had heard about and asked about, and the incident involving the firing of a prosecutor who, according to public reports, had been looking into Burisma, the company that Vice President's son was on the board of. And that was the president's way of pinpointing specific issues related to corruption. So when did it become part of the president's concern, those issues related to corruption in Ukraine? Of course, we have the evidence that everyone in the government, Fiona Hill testified to this, thought that anti-corruption was a major issue for U.S. policy with respect to Ukraine. When there was a new president elected in April, President Zelensky, that brought the possibility of reform to the forefront. Then we know that the president was receiving information from his private attorney, Rudy Giuliani. And he spoke in the Oval Office of, Rudy knows about the Ukraine. You guys go talk to him, because he was explaining to the delegation that had just returned from the inauguration for President Zelensky, that he had concerns about Ukraine because they're all corrupt. And he kept saying, it's a corrupt country, I don't know, they tried to get me in the election. So it draws again, and there's his specific experience with Ukrainian corruption, because he knew from the public reports, as in the Politico article that has been referenced many times, the Politico article in January of 2017 explained a laundry list of Ukrainian government officials who had been out there attempting to assist the Hillary Clinton campaign and spread misinformation or bad information, or assist in digging up dirt on members of the Trump campaign. Mr. Giuliani had been investigating things related to Ukraine in 2016 and was led to the information about the Burisma situation and Vice President Biden having the prosecutor fired. So that was in January that he had these interviews. He turned over to the State Department in March. And then there were a series also of public articles published. John Solomon in The Hill published an article in March. Rudy Giuliani tweeted about it in March. There was an ABC story in June. There was a two-part New Yorker story about Biden's in Burisma in July. Then July 22nd, the Washington Post had an article and explained specifically on just July 22nd, this is 3 days before the July 25th call, the Washington Post reported that Mr. Shokin, the prosecutor, quote, believed his ouster was because of his interest in the company, end quote, referring to Burisma. And he said that, quote, had he remained in his post, he would have questioned Hunter Biden, end quote. So I think it is a reasonable inference that as there were these articles being published in close proximity to the time, this was information that was available to the president, and it became available to him as something that was a specific example of potentially serious corruption. And remember, everyone who testified, who was asked about it, does it seem like there's an appearance of a conflict of interest? Does it seem like that's fishy? Everyone testified below, yes, there's at least an appearance of a conflict of interest there. And I think it was after the information had come to Mr. Giuliani, long before Vice President Biden had announced his candidacy, that it came to the attention of the president and became something worth raising because, again, President Poroshenko is the one who fired the prosecutor. While he's still the president, it's not really as much of an opportunity or possibility of raising that. And so I think it was in that time frame, along that arc of the timing, that it came to the president's attention, and that's why it was raised in that timing. Thank you.
Mr. Chief Justice.
The senator from Connecticut.
Thank you, Mr. Chief Justice. I have a question for the counsel for the president.
Thank you. Senator Blumenthal asks, did anyone in the White House or outside the White House tell anyone in the White House counsel's office that publication of the Bolton book would be politically problematic for the president?
Thank you, Mr. Chief Justice. Thank you, Senator, for the question. No one from inside the White House or outside the White House told us that the publication of the book would be problematic for the president. I think we assumed that Mr. Bolton was disgruntled, and we didn't expect he was going to be saying a lot of nice things about the president, but no one told us anything like that.
So,
The
Senator from Texas.
I sent a question to the desk on behalf of myself and Senators Moran and Hawley. It is a question for the House managers.
Thank you. The question from the senators to the House managers. An August 26, 2019 letter from the Intelligence Community Inspector General to the Director of National Intelligence discussing the so-called whistleblower stated that the Inspector General identified some indicia of an arguable political bias on the part of the complainant in favor of a rival political candidate. Multiple media outlets reported that this likely referred to the whistleblower's work with Joe Biden. Did the so-called whistleblower work at any point for or with Joe Biden? If so, did he work for or with Joe Biden on issues involving Ukraine? And did he assist in any material way with the quid pro quo in which then Vice President Biden has admitted to conditioning loan guarantees to Ukraine on the firing of the prosecutor investigating Burisma?
Thank the senators for the question, and I want to be very careful in how I answer it so as not to disclose or give an indication that may allow others to identify the identity of the whistleblower. But first I want to talk about why we're making such an effort to protect the identity of the whistleblower. If you could put up slide 48. This slide shows, and it may be difficult for some of you to read, so let me try to, actually, if you could hand me a copy of that as well. I have a chance to distribute that to everyone. It's not just that we view the protection of whistleblowers as important. Members of this body have also made strong statements about just how important it is to protect whistleblowers. Senator Grassley said this person appears to have followed the whistleblower protection laws and ought to be heard out and protected. We should always work to respect whistleblowers' requests for confidentiality. Senator Romney, whistleblowers should be entitled to confidentiality and privacy because they play a vital function in our democracy. Senator Burr, we protect whistleblowers, we protect witnesses in our committee. Even my colleague, the ranking member, Mr. Nunes, we want people to come forward, and we will protect the identity of those at all cost. This has been a bipartisan priority and one that we have done our best to maintain. So I want to be very careful, but let me be clear about several things about the whistleblower. First of all, I don't know who the whistleblower is. I haven't met them or communicated with them in any way. The committee staff did not write the complaint or coach the whistleblower what to put in the complaint. The committee staff did not see the complaint before it was submitted to the Inspector General. The committee, including its staff, did not receive the complaint until the night before Acting Director of National Intelligence. We had an open hearing with the Acting Director on September 26, more than 3 weeks after the legal deadline by which the committee should have received the complaint. In short, the conspiracy theory, which I think was outlined earlier, that the whistleblower colluded with the Intel Committee staff to hatch an impeachment inquiry, is a complete and total fiction. This was, I think, confirmed by the remarkable accuracy of the whistleblower complaint, which has been corroborated by the evidence we subsequently gathered in all material respects. So I'm not going to go into anything that could reveal or lead to the revelation of the identity of the whistleblower, but I can tell you, because my staff's names have been brought into this proceeding, that my staff acted at all times with the most complete professionalism. I am very protective of my staff, as I know you are. And I'm grateful that we have such bright, hardworking people working around the clock to protect this country and who have served our committee so well. And it really grieves me to see them smeared, and some of them mentioned here today have concerns about their safety and their online threats to members of my staff as a result of some of the smears that have been launched against them. I can tell you there's no one who can understand the plight of Ambassador Yovanovitch more than some of my staff who have been treated to the same kind of smears and now have concerns over their own safety. They acted at all times with the utmost propriety and integrity. Your Senate Intelligence Committee and your chairman and vice chairman can tell you, encourage whistleblowers to come to their committee, and so do we. And when they do, we try to figure out, is their complaint within the scope of jurisdiction of the intelligence community? And if it is, then we suggest they get a lawyer. We suggest they talk to the Inspector General, which is what happened here. The whistleblower did exactly what they should, except for the president. That's unforgivable, because the whistleblower exposed the wrongdoing of the president. In the president's view, that makes him or her a traitor or a spy. And as the president tells us, there's a way we used to treat traitors and spies. You wonder why we don't want to call the whistleblower? Well, first of all, we know firsthand what the whistleblower wrote secondhand in that complaint. There's no need for that whistleblower anymore, except to further endanger that person's life. That, to me, does not seem a worthwhile object for anyone in this chamber, on the other side of this building, in the Oval Office, or anywhere else.
Thank you, Mr. Manager. Senator from Rhode Island.
Mr. Chief Justice, on my own behalf and on behalf of Senators Blumenthal, Booker, Coons, Klobuchar, Leahy, Markey, Peters, and Udall, I send a question to the desk.
The question from Senator Whitehouse and the other senators to the House managers. The missing witness rule, which dates back to 1893 Supreme Court case Graves versus United States, allows one party to obtain an adverse inference against the other for failure to produce a witness under that party's control with material information. Here, one party, the President, has prevented witnesses within his control from testifying or providing documents. Do the House managers believe senators should apply the missing witness rule here? And if so, what adverse inferences should we draw about the missing testimony and documents?
Mr. Chief Justice, Senators, we do believe that you should draw an adverse inference against the party resisting the testimony of these witnesses like John Bolton. Courts have long recognized that when a party has relevant evidence within his control which he fails to produce, that failure gives rise to an inference that that evidence is unfavorable to him. Courts have frequently drawn adverse inferences where a party acts in bad faith to conceal evidence or preclude witnesses from offering testimony. And I would suggest that it is bad faith when counsel comes before you and says that if you really wanted these witnesses, you should have sued to get them in the House, and goes into the courtroom down the street and says, you can't sue to get witnesses before the House. But that's what's happened here. And you are, I think, not only permitted, but absolutely should draw an adverse inference that when a party is making that argument on both sides of the courthouse, that the evidence those witnesses would provide runs against them. The administration hasn't produced a single document, not one, a single document. That's extraordinary. They can argue executive privilege and absolute immunity. Most of that has nothing to do with the overwhelming majority of these documents, not a whit. There's no absolute immunity from providing documents. The vast, vast majority don't have anything to do with privilege, and if they did, they would be redactions, very specific redactions. None of that happened. Are you allowed to draw an adverse inference that the reason why the President's team, which has possession of those emails regarding inquiries by Ukraine into why the aid was frozen, are you allowed to draw an inference, if they won't show you those emails, that those emails would confirm that Ukraine knew the aid was withheld, just like the former Deputy Foreign Minister of Ukraine said publicly when she told the New York Times, yes, we knew. By the end of July, we knew. This is the Deputy Foreign Minister at the time. We knew the aid was frozen, but I was instructed by Andrei Yermak not to mention it. I had a trip planned to Washington to talk to Congress. I was told not to go. Why? Because they didn't want it public. Are you entitled to draw an inference that those records, they refuse to turn over all those State Department records, the fact that they won't allow John Bolton's notes to be turned over, they won't let Ambassador Taylor's notes to be turned over? Should you draw an adverse inference? You're darn right you should. Now, they say, well, the President only told Sondland no quid pro quo. They leave out the other half where Sondland told Taylor, but he said no quid pro quo, but you got to go to the mic and announce these investigations. Well, Ambassador Taylor wrote down the notes of that conversation. That took place right after that call with the President. Are you allowed to draw an adverse inference from the fact they don't want you to see Ambassador Taylor's notes, from the fact they don't want you to see Ambassador Taylor's cable? You're darn right you should draw an adverse inference. And finally, with respect to who has become a central witness here, I think the adverse inference screams at you as to why they don't want John Bolton. But you shouldn't rely on an inference here, not when you have a witness who's willing to come forward. There is no need for inference here. There's just a need for a subpoena.
Thank you, Mr. Manager.
Mr. Chief Justice.
Yes, the Senator from South Dakota.
I have a question to send to the desk.
Thank you. Senator Thune's question is for counsel for the President. Would you please respond to the arguments or assertions the House managers just made in response to the previous questions?
Mr. Chief Justice, thank you, Senator, for the question. I haven't read recently the case that was cited about the missing witness rule, so I can't say specifically what's in it, but I am willing to bet that the missing witness rule does not apply when there's been a valid assertion of a privilege or other immunity for keeping the witness out of court. So, for example, if they tried to subpoena the defendant's lawyer and the defendant said, wait, I have attorney-client privilege, you can't subpoena him, they're not going to be able to get an adverse inference from that. And that's critical because, as I've gone through multiple times, and we keep going back and forth on this, they keep representing that there was a blanket defiance and there was no explanation and there was no legal basis for what the president was doing. And it's just not true. There were letters back and forth. I put them up on the screen. There were specific immunities asserted. There were specific legal deficiencies in the subpoenas that were sent. And this is important because if you're going to impeach the President of the United States, turning square corners and proceeding by the law matters. And for the House managers to come here and say it was blanket defiance, it was unprecedented, that you have to draw an adverse inference against them because they didn't respond to any of our document subpoenas. All of the document subpoenas were issued without authorization. Maybe they disagree with us, but they can't just say we provided no rationale and you have to draw an adverse inference. There was a specific legal rationale provided. And they didn't try to engage in the accommodation process, and they didn't try to go to court. And now, yes, it's true. Our position is that when they go to the court, Article III courts don't have jurisdiction over that. Their position is Article III courts do have jurisdiction over that. They believe that they can get a court order to require us to comply with a valid subpoena. But they never tried to establish in court that their subpoenas were valid. We have an assertion of a legal deficiency on one side. They think it's different. They don't want to go to court to get it resolved. We have the assertion of absolute immunity from congressional compulsion for senior advisors to the president. It's been asserted by virtually every president since Nixon. They try to say, oh, it's preposterous, it's irrelevant, we don't have to worry about that. Every president since Nixon, virtually, has asserted that. It's only been addressed by 2 district courts, trial-level courts. The first one rejected it, and its decision was stayed by the appellate court, which means the appellate court thought, probably you got it wrong, or at a minimum, it's a really difficult question, we're not sure about that. And the second district court decision is being litigated right now. They're litigating it. And when they say that when Charlie Kupperman went to court, they were trying to do something reasonable to say, oh, well, we don't want to litigate this with you. You should just agree to be bound by the McGahn decision. What's the saying, every litigant gets his day in court? Why shouldn't Charlie Kupperman get to have his counsel argue that issue on his behalf? That's what he wanted. He didn't want to say, I'm going to trust it to the other people litigating the other case. I've got my case. I want to make the arguments. But they wouldn't have that, so they mooted out the case. They withdrew the subpoena to moot out the case because they didn't want to go to the hearing in front of Judge Leon on December 10th. They've also pointed out, as if it's some outrage, that documents have been more readily produced under FOIA than in response to their subpoenas. But what that actually shows is that when you turn square corners and follow the law and make a request to the administration that follows the law, the administration follows the law and responds. And that's right. The documents were produced. Information came out. But they didn't get it because they issued invalid subpoenas and they didn't try to do anything to establish the validity of their subpoenas. If you're going to be sloppy and issue invalid subpoenas, you're not going to get a response. But if some private litigant follows FOIA and submits a FOIA request, they get a response. So to act like the Trump administration has done some blanket denial of everything simply isn't accurate, and there's no basis for any adverse inference because there's a specific privilege or basis for every reason not to produce something. Thank you.
Thank you, counsel.
Mr. Chief Justice.
Senator from New Hampshire.
Thank you, Mr. Chief Justice. I send a question to the desk for the House managers.
Thank you. The question is for the House managers. Did Acting Chief of Staff Mick Mulvaney waive executive privilege in his October 17 press conference in which he stated that there was, quote, political influence, end quote, in the Trump administration's decision to withhold aid to Ukraine?
Mr. Chief Justice, distinguished members of the Senate, I thank you for that question. Mick Mulvaney has absolutely waived executive privilege. He has never asserted executive privilege. In fact, as the President's Counsel has acknowledged, they have not asserted executive privilege once. The President's Counsel has said, when we made that point during our opening arguments, that that was technically true. No, it's true. It's not an alternate fact, it's a fact. You have never asserted executive privilege in connection with Mick Mulvaney's testimony or anyone else. It was not asserted as it relates to any of the 17 witnesses who testified, 12 of whom testified publicly. The other phony arguments that have been articulated respectfully are that the House needed to vote in order for the subpoenas to be valid. There is nothing in the Constitution that required the full House to vote, nothing in Supreme Court precedent, nothing under federal law, nothing under the House rules. It was a phony argument. Yet the House, after the initial stages of the investigation, did fully vote, and fully voted on October 31st. Interestingly enough, Mick Mulvaney was subpoenaed thereafter, not before, thereafter, after the House had voted. Subpoenaed on November 7th. Here it is. The next day, the White House responded. It responded with a 2-page letter dated November 8th. There's no mention of executive privilege in the November 8th letter. But here's what it does say. The Department of Justice has advised me that Mr. Mulvaney is absolutely immune from compelled congressional testimony with respect to matters related to his service as a senior advisor to the President. What's interesting about this letter from Mr. Cipollone is that it doesn't cite a single legal case for that outrageous proposition. A single legal case for the proposition that Mick Mulvaney is absolutely immune. Why? Because there's no law to support it. The President tried to cheat, he got caught, and then he worked hard to cover it up. The Senate can get to the truth. You can get to the truth by calling witnesses who can testify. And any privilege issues can be worked out by the Chief Justice of the Supreme Court. The American people deserve a fair trial. The President deserves a fair trial. The Constitution deserves a fair trial. That includes Mulvaney. That includes Bolton. That includes other relevant witnesses.
Thank you, Mr. Manager.
Mr. Chief Justice.
The Senator from Alaska.
Mr. Chief Justice, I send a question to the desk on behalf of myself and Senator Young and Senator Crapo. The question is to be directed to both parties.
Thank you. The question directed to Counsel for the President and the House managers. The Constitution does not specify the standard of proof to be used in trials of impeachment. and the Senate has not adopted a uniform standard by rule. Thus, the standard of proof is arguably a question for each individual senator. In the Clinton trial, and now with President Trump, it appears that Republicans and Democrats apply different standards depending on whether the president is a member of their party. What standard of proof should be used in trials of impeachment? Preponderance of the evidence, clear and convincing, beyond a reasonable doubt, and why? I think it's the turn of the House managers to go first.
Mr. Chief Justice, Senators, there is no court case on this. The House needs strong evidence, but it's never been decided beyond a reasonable doubt, as the President's counsel has suggested. And as the question notes, the Constitution does not specify either the House's evidentiary burden of proof or the Senate's. I would note that the House Judiciary Committee held itself to a clear and convincing standard of proof in the Nixon matter, which requires that the evidence of wrongdoing must be substantially more probable to be true than not, and that the trier of fact must have a firm belief in its factuality. In the Clinton case, the House did not commit to any particular burden of proof, and I would recommend against including an express standard. Instead, like in the Clintons, simply finding the facts and any inferences from those facts without legal technicalities. It has been opined that in the end, it is up to each senator to make a judgment, and I think there is much truth to that. Your oath holds you to a finding of impartial justice, and I trust that each and every one of you is holding that oath very dear to your heart. It will find the facts and lead to a just result for our country, the Constitution, and for a future that hopefully is as free as our past has been. I yield back.
Thank you.
Mr. Chief Justice, Senators, thank you for the question. I think that the Constitution makes it clear in the terms that it speaks of impeachment are all related to the criminal law. It speaks of an offense, it speaks of conviction, it speaks of a trial, and saying that crimes shall be tried by jury except in the case of impeachment. And both that and the gravity of a presidential impeachment, which is an issue of breathtaking importance for the country and could cause tremendous disruption to our government, both counsel in favor of the traditional criminal standard of proof beyond a reasonable doubt. And in the Clinton impeachment, senators, both Republicans and Democrats, repeatedly advocated in favor of that standard. Senator Russ Feingold then said that, quote, "In making a decision of this magnitude, it is best not to err at all. If we must err, however, we should err on the side of respecting the will of the people." Similarly, Senator Barbara Mikulski then said, quote, "The U.S. Senate must not make the decision to remove a president based on a hunch that the charges may be true. The strength of our Constitution and the strength of our nation dictate that the Senate be sure beyond a reasonable doubt." The preponderance standard is wholly insufficient. That means just 50.1%. You think it's a little more likely than not. That's not sufficient to remove the president. Even clear and convincing evidence is not. It has to be beyond a reasonable doubt. As Senator Rockefeller explained at the time of the Clinton impeachment, that means, quote, "It is proven to a moral certainty the case is clear." That is the standard that the senators should apply, because the gravity of the issue before you would not permit applying any lesser standard. Thank you.
Counsel?
Mr. Chief Justice.
Senator from New Jersey.
Thank you, sir. Mr. Chief Justice, I send a question to the desk. manager. Thank you.
The question is for the House manager. Even if a communication or a document is covered by executive privilege, that privilege can be overcome by showing the evidence is important and unavailable elsewhere. On January 22nd, while this trial was underway, President Trump said, quote, "I thought our team did a very good job, but honestly, we have all the material. They don't have the material," end quote. Can you comment on whether executive privilege allows a president to conceal information from Congress, particularly if the evidence cannot be obtained elsewhere?
Thank you, Mr. Chief Justice, and I thank the distinguished senator from New Jersey for his question. President Trump alone has the power to assert executive privilege. And as counsel admitted on Saturday, the president has not formally invoked it over any document requested in this impeachment inquiry. It's not been asserted as it relates to any single document. Now, executive privilege gives President Trump a qualified form of confidentiality when he does get advice from his aides in order to carry out the duties of his office. And as I know you are all aware, it is often the case in congressional investigations that a president will claim executive privilege over a very small subset of materials. In that case, what the executive branch usually does and should do is to produce everything that it can and then provide a log of documents in dispute or permit a private review of the documents that have been contested. That's not what has occurred in this case, because the president has ordered the entire executive branch to defy our constitutionally inspired impeachment inquiry. Blanket defiance is what has taken place. And there's no right to do that. Every court that has considered the matter has asserted that the president cannot assert a privilege to protect his own misconduct, to protect wrongdoing, to protect evidence that the Constitution may have been violated. The president cannot do it. In an impeachment inquiry, the congressional need for information and its constitutional authority, of course, are at its greatest. It's imperative to investigate serious allegations of misconduct that might constitute high crimes and misdemeanors. And that is what is before you right now. Let's look at what the Supreme Court has said in circumstances that are closest to what we face today in U.S. versus Nixon, in the context of a grand jury subpoena. The Supreme Court found that President Nixon's generalized assertion of privilege must yield to the demonstrated need for evidence in the pending trial. And the federal court here in D.C. has recognized that Congress's need for information and for documents during an impeachment inquiry is particularly compelling. Turning to the facts of this matter briefly, any argument that every single document requested by Congress is subject to privilege or some form of absolute immunity is absurd. There are calendar invitations, scheduling emails, photographs, correspondence with outside parties like Rudolph Giuliani. These are all important pieces of evidence for you to consider and are not the type of materials subject to any reasonable claim of executive privilege. If you want a fair trial, it should involve documents. Given the nature of these proceedings, documents like Ambassador Bolton's notes, Lieutenant Colonel Vindman's presidential decision memo should also be provided to you so you can seek the truth, the whole truth, and nothing but the truth.
Thank you. Mr. Manager.
Mr. Chief Justice.
Senator from Louisiana.
Senator Moran, my colleague from Kansas, and I send a question to the desk for counsel for the President.
Thank you. The question for counsel for the President is, what did Hunter Biden do for the money that Burisma Holdings paid him?
Thank you for the question. Chief Justice, Senators, as far as we know, Hunter Biden has said he, quote, attended a couple board meetings a year, end quote. Here's what we do know. Hunter Biden did attend one board meeting in Monaco. Now, we also heard that when Zlochevsky, the owner of Burisma, fled the Ukraine, he was living in Monaco. So Hunter Biden did attend a board meeting in Monaco. We also know that Hunter Biden went to Norway on a fishing trip, and he took his daughter and his nephew. So he took two of Joe Biden's children with him on a fishing trip to Norway with Zlochevsky, and that is as much as we know, other than his statement that he attended one or two board meetings. Factually, that is what he said, and the timeline shows that, again, Devin Archer was on the board with him, and then Hunter Biden remained on the board, but factually in the record, that is as much as we know that he did involving Burisma and Zlochevsky. The Norway trip was June of 2015. He remained on the board until April of 2019. We also know that prior to then, a Ukrainian court in September of 2016 canceled Zlochevsky's arrest warrant. We also know December 15th, Vice President Biden called President Poroshenko, and then mid-January 2017, Burisma announces all legal proceedings against the company, and Zlochevsky had been closed.
Democratic leader is recognized.
Question to the desk for both the counsel for the President and the House managers.
Thank you. The question reads as follows. The House managers say the President demands absolute immunity. The President's counsel disputes this. Can either of you name a single witness or document to which the President has given access to the House when requested? I believe it's time for counsel for the President to go first.
Mr. Chief Justice, thank you, Minority Leader Schumer, for the question. And let me try to be clear and distinguish a couple of things. The House managers have said there was blanket defiance. That's the way they characterize it. Just, we're not going to give you anything, and that's all we said. It was just blanket defiance. We're not going to respond. What I've tried to explain several times is that that was not the president's response. There were specifically articulated responses to different requests based on different legal rationales because there were different problems with different subpoenas. So one problem is all the subpoenas up until October 31st were not validly authorized. So those subpoenas, we said, we're not going to respond to those because they weren't validly issued. It wasn't an assertion of executive privilege. It wasn't an assertion of absolute immunity. It wasn't anything else. It was the fact that they weren't validly authorized. They pointed out that, we subpoenaed, I think it was, they mentioned Acting Chief of Staff Mulvaney after October 31st. That's true. We didn't rely on the fact that the subpoena was not authorized. We pointed out the doctrine of the absolute immunity of senior advisors to the president. This is not some blanket absolute immunity for the entire executive branch. It doesn't apply to all of the subpoenas they issued. As we explained in our brief, it applies to 3. There were 3 people they subpoenaed as witnesses that was on this basis alone that the president declined to make them available. Acting Chief of Staff Mulvaney, the legal advisor to the National Security Council, John Eisenberg, and the Deputy National Security Advisor, Mr. Kupperman, I believe, but it's in our brief. It was those 3 who had immunity. A doctrine asserted by every president since Nixon. Then there was a different problem with some of the subpoenas. Some of the other witnesses who were not senior advisors to the president did not assert that they had absolute immunity. Instead, those subpoenas refused to allow those executive branch personnel to have executive branch counsel accompany them. And there's an OLC opinion. It's been published. It's online. It's cited in our trial memorandum saying that it is unconstitutional to refuse to allow the executive branch personnel to have the assistance of executive branch counsel to protect privileged information during the questioning. And therefore, it's not valid to force them to appear without that.
Thank you, counsel.
Thank you.
Mr. Chief Justice and Senators, we've received nothing as part of our impeachment inquiry. It's worth pointing out that the House committees that subpoenaed before the House vote had standing authority under the House rules. And they were the Oversight Committee, which has, under its standard authority, to investigate any matter at any time, as well as the Foreign Affairs Committee. They had the authority under the rules of the House adopted January 11th to issue subpoenas. They did, and they were defied. The idea of absolute immunity has never been upheld by any court, and it's really incomprehensible to think that somehow this concept of absolute immunity has lurked in hiding for centuries for presidents to use it in this day. It's when you think of the 2 cases, the Myers case and McGahn case, courts completely rejected the idea of absolute immunity. On slide 38, if you could, there is a decision recently made in the McCann case, and here's what it says. Stated simply, the primary takeaway from the past 250 years of recorded American history is that presidents are not kings. That's the judge's words, not mine. Compulsory appearance by dint of a subpoena is a legal construct, not a political one, and per the Constitution, no one is above the law. The president is not permitted by the Constitution or by the law to assert any kind of absolute immunity. That does not exist in America. And as the judges pointed out, that would be something that a king would assert. I'm not saying that, but I will say this. It's something our founders set up our checks and balances to prevent. Nobody has absolute power in our system of government, not the Senate and House, not the President, not the judiciary. This is unprecedented and just wrong as a matter of law and as a matter of the Constitution. Thank you.
Thank you.
Mr. Justice.
Senator from Georgia.
Thank you, Mr. Chief Justice. I send a question to the desk for both the Counsel of the President and the House managers on behalf of Senator Cruz and myself.
Thank you. The question is, you refuse to answer the question on political bias. Are the House managers refusing to tell the Senate whether or not the so-called whistleblower had an actual conflict of interest? There are 7 billion people on planet Earth. Almost all had no involvement in Biden's quid pro quo. Are the House managers unwilling to say whether the so-called whistleblower was a fact witness who directly participated in and could face criminal or civil liability for Joe Biden's demanding Ukraine fire the prosecutor who was investigating Burisma? And why did you refuse to transmit to the Senate the Inspector General transcript? Which side is, it's addressed to both sides. I think perhaps the House managers could go first.
With respect to the ICIG, the President and his allies have tried to shift focus to the Inspector General of the intelligence community, a highly respected veteran of the Justice Department, and his handling of the whistleblower complaint. There was an effort to insinuate wrongdoing on the part of the whistleblower, and there's been an effort to insinuate wrongdoing on behalf of the Inspector General. The briefings that we had with the ICIG related to the unusual and problematic handling of this particular whistleblower complaint within the executive branch, which diverged sharply from any prior whistleblower complaint by anyone within the intelligence community. The Intelligence Committee is continuing its ongoing oversight to determine why and how this complaint was initially concealed from the committee in violation of the law. ICIG Michael Atkinson continues to serve admirably and independently as he is supposed to do. Like the Senate Intelligence Committee, the House Intelligence Committee does not release the transcripts of its engagements with inspector generals on sensitive matters, because doing so risks undercutting an important mechanism for the committee to conduct oversight. The transcripts remain properly classified in conformity with IC requirements to protect sensitive information. The ICIG made every effort to protect the whistleblower's identity and briefed us with the expectation that it would not be made public, and we are trying to honor that expectation. With respect to allegations of bias on the part of the whistleblower, let me just refer you to the conclusion of the Inspector General, which is, after examining the whistleblower's background, any potential allegations of any bias, the whistleblower drew two conclusions. The whistleblower was credible, meaning that whatever issue, perceived or real, the Inspector General found that whistleblower credible. The Inspector General also found that the whistleblower's complaint was urgent and that it needed to be provided to Congress. The Inspector General further found that it was withheld from Congress in violation of the law, in violation of the statute, and for that, he is being attacked. Now, counsel for the President rely on an opinion of the Office of Legal Counsel as its justification for violating the Whistleblower Protection Act and not transmitting the complaint to Congress.
Thank you, Mr. Manager.
Mr. Chief Justice, members of the Senate, on page 5 of the Inspector General's report, it states, Although the Inspector General's preliminary review identified some indicia of arguable political bias on the part of the complainant. Now, that's in the actual statement. He goes on to say, involving a rival political candidate, such evidence did not change his view about the credible nature of the concern or what appears to be credible. But to argue that it does not include an issue of political bias, the Inspector General himself says that that's, in fact, at least that they said that their preliminary reviews indicate some political bias. Now, there's been reports in the media that the individual may have worked for Joe Biden when he was vice president. He may have had some area under his watch involving Ukraine. But I also thought it was just interesting that managership just talked about the importance of how they control the process as it relates to whistleblower reports because of the sensitive nature of those. Do we not think that the sensitive nature of information shared by the president's most senior advisors should not be subject to the same type of protections? Well, of course, it has to be. Thank you.
Thank you, counsel.
Send a question to the desk for both the President's counsel and the House managers. Thank you.
The question from Senator Manchin reads as follows. The framers took the words high crimes and misdemeanors straight out of English law, where it had been applied to impeachments for 400 years before our Constitution was written. The framers were well aware when they chose those words that Parliament had impeached officials for high crimes and misdemeanors that were not indictable as crimes. The House has repeatedly impeached and the Senate has convicted officers for high crimes and misdemeanors that were not indictable crimes. Even Mr. Dershowitz said in 1998 that an impeachable offense, quote, certainly doesn't have to be a crime, end quote. What has happened in the past 22 years to change the original intent of the framers and the historic meaning of the term high crimes and misdemeanors? It's counsel for the President's turn.
What happened since 1998 is that I studied more, did more research, read more documents, and like any academic, altered my views. That's what happens. That's what professors ought to do. And I keep reading more, and I keep writing more, and I keep refining my views. In 1998, the issue before this Senate was not whether a crime was required. It was whether the crime that Clinton was charged with was a high crime. When this impeachment began, the issue was whether a crime is required. Actually, 2 years earlier in a book, and then in an op-ed, I concluded, not on partisan grounds, on completely academic grounds, that you could not impeach for abuse of power and that a technical crime was not required, but criminal-like behavior was required. I stand by that view. The framers rejected maladministration. That was a prime criteria for impeachment under British law. Remember, too, the British never impeached prime ministers. They only impeached middle-level and low-level people. So the framers didn't want to adopt the British approach. They rejected it by rejecting maladministration. And what's a metaphor or what's a synonym for maladministration? Abuse of power. And when they rejected maladministration, they rejected abuse of power. Mr. Congressman Schiff asked a rhetorical question, can a president engage in abuse of power with impunity? In my tradition, we answer questions with questions, and so I would throw the question back. Can a president engage in maladministration with impunity? That's a question you might have asked James Madison had you been at the Constitutional Convention. And he would say, no, a president can't engage in that with impunity, but it's not an impeachable crime. Maladministration is not impeachable, and abuse of power is not impeachable. The issue is not whether a crime is required. The issue is whether abuse of power is a permissible constitutional criteria, And the answer from the history is clearly, unequivocally no. If that had ever been put to the framers, they would have rejected it with the same certainty they rejected maladministration.
Thank you.
Was of power. The first draft of the Constitutional Convention said treason or bribery. That was rejected because it wasn't inclusive enough. Mason proposed maladministration, found too vague. So they said high crimes and misdemeanors. That was a well-understood term in English law. It was a well-understood term in the Warren Hastings impeachment going on in England right then. And it meant primarily abuse of power. That is the main meaning of high crimes and misdemeanor. Charles Pinckney said, those who behave amiss or betray their public trust. Edmund Randolph misbehaves. But I quoted Justice Story the other day. Every impeachment in American history has been for abuse of power in one form or another. The idea that you have to have a crime, bribery, is right there in the Constitution. Treason, bribery, other crimes. Bribery was not made a statutory crime until 1837, so it couldn't have been impeachment. The fact of the matter is that crimes and impeachment are two different things. Impeachments are not punishments for crimes. Impeachments are protections of the Republic against the president who would abuse his power, who would aggrandize power, who would threaten liberty, who would threaten the separation of powers, who would threaten the powers of the Congress, who would try to arrogate power to himself. That is why punishment upon conviction for impeachment only goes to removal from office. Can't put him in jail, as you could for a crime. You can't fine him, as you could for a crime. They are two different things. An impeachable offense need not be a crime, and a crime need not be an impeachable offense. Two completely different tests, understood that way throughout American history, and by all scholars in our history, except for Mr. Dershowitz.
Thank you, Mr. Manager. The senator from North Carolina.
Mr. Chief Justice, I send a question to the desk for the counsel of the President.
Senator Burr asks, we've seen the House managers repeatedly play video clips of Acting Chief of Staff Mick Mulvaney's press conference in which they claim he said that there was a quid pro quo. How do you respond to the House managers' allegation that Mr. Mulvaney supported their claims in his press conference?
Mr. Chief Justice. Members of the Senate, Senator, thank you for the question. We respond as Mr. Philbin did earlier today with that, which is Mr. Mulvaney has issued two statements, one after his press conference and then one Monday after the New York Times article concerning Mr. Bolton's alleged statements in his manuscript. So I think the easiest thing is just to read them, to understand what he said and to put it into context for everyone in the chamber. This is the day of the press conference. Once again, the media has decided to misconstrue my comments to advance a biased and political witch hunt against President Trump. Let me be clear. There was absolutely no quid pro quo between Ukrainian military aid and any investigation into the 2016 election. The president never told me to withhold any money until the Ukrainians did anything related to the server. The only reasons we were holding the money was because of concern about lack of support from other nations
and concerns over corruption. Multiple times during the more than 30-minute briefing, where I took over 25 questions, I referred to President Trump's interest in rooting out corruption in Ukraine and ensuring taxpayer dollars are spent responsibly and appropriately. There was never any connection between the funds and the Ukrainians doing anything with the server. This was made explicitly obvious by the fact that the aid money was delivered without any action on the part of the Ukrainians regarding the server. There was never any condition on the flow of the aid related to the matter of the DNC server. Then, on January 27th, which was Monday, there was a statement from Bob Driscoll, who is Mr. Mulvaney's attorney. And I'll read it in its full. The latest story from the New York Times, coordinated with a book launch, has more to do with publicity than the truth. John Bolton never informed Mick Mulvaney of any concerns surrounding Bolton's purported August conversation with the president. Nor did Mr. Mulvaney ever have a conversation with the president or anyone else indicating that Ukrainian military aid was withheld in exchange for a Ukrainian investigation of Burisma, the Bidens, or the 2016 election. Furthermore, Mr. Mulvaney has no recollection of any conversation with Mr. Giuliani resembling that reportedly described in Mr. Bolton's manuscript, as it was Mr. Mulvaney's practice to excuse himself from conversations between the president and his personal counsel to preserve any attorney-client privilege. So I wanted to read those statements in full so that everyone had the full context. Even after Mr. Philbin referenced the statement after the press conference, the House managers again came back and said Mr. Mulvaney indicated or admitted there was a quid pro quo. That's not true. If Mr. Mulvaney misspoke or if the words were garbled, he corrected it that day and has been very clear. Thank you. Thank you, Mr. Chief Justice.
So,
Mr. Chief Justice.
the senator from Maryland.
Mr. Chief Justice, I send a question to the desk for the President's counsel and the House managers.
The question to both parties, the House managers will go first. What did National Security Advisor John Bolton mean when he referenced whatever drug deal Sondland and Mulvaney are cooking up on this, end quote, and did he ever raise that issue in any meeting with President Trump?
Mr. Chief Justice, Senators, when John Bolton, and this is according to Dr. Hill's testimony, brought up the drug deal, it was in the context of a July 10th meeting at the White House. There were two meetings that day. There was a meeting that Ambassador Bolton was present for, and then there was a follow-on meeting after Ambassador Bolton abruptly ended the first meeting. In the first meeting, the Ukrainians naturally wanted to raise the topic of getting the White House meeting that President Zelensky so desperately wanted. And after raising the issue, at some point, Ambassador Sondland said, no, we've got a deal. They'll get the meeting once they announce the investigations. And this is the point where Ambassador Bolton stiffened. Now, you can look up Dr. Hill's exact words. I'm paraphrasing here. But this is the point where Ambassador Bolton stiffens and he ends the meeting. Hill then follows Sondland and the delegation into another part of the White House where the meeting continues between the American delegation and the Ukrainian delegation. And there it's even more explicit because in that second meeting, Sondland brings up the Bidens specifically. Hill then goes to talk to Bolton and informs him what's taken place in the follow-on meeting. And Bolton's response is, go talk to the lawyers and let them know I don't want to be part of this drug deal that Sondland and Mulvaney have got cooking up. So At that point, that specific conversation is a reference to the quid pro quo over the White House meeting. Now, we know, of course, from other documents and testimony about the quid pro quo about the White House meeting and all the efforts by Giuliani to make sure that the specific investigations are mentioned in order to make this happen. But don't take my word for it. We can bring in John Bolton and ask him exactly what he was referring to when he described the drug deal. Now, did Bolton describe and discuss this drug deal with the president? Well, it certainly appears from what we know about this manuscript that they did talk about the freeze on aid. And whether John Bolton understood and at what point he understood that the drug deal was even bigger and more pernicious than he thought, that involved not just the meeting, but it involved the military aid, there's one way to find out. And I would add this in terms of Mr. Mulvaney. No, maybe I'll add it later.
Mr. Chief Justice.
As 2.5 minutes.
Thank you, Mr. Chief Justice. Thank you, Senator, for the question. The question asks about what Ambassador Bolton meant in a comment that is reported as hearsay by someone else saying what he supposedly said. What we know is that there are conflicting accounts of the July 10th meeting at the White House. Dr. Hill says that she heard Ambassador Sondland say one thing. He denies that he said that. Dr. Hill says she went and talked to Ambassador Bolton, and Bolton said something to her about what was said in the meeting where he wasn't there, but he was saying something about it, calling it a drug deal. And what he meant by that, I'm not going to speculate about. It's a hearsay report of something that he said about a meeting that he wasn't in, characterizing it some way. And I'm not going to speculate about what he meant by that.
Thank you. The senator from North Dakota.
Thank you, Mr. Chief Justice. I have a question for myself, also for Senator Portman and Senator Bozeman. And it's for the President's Counsel, and I'm sending it to the desk.
The question from the senators is as follows. In September of 2019, the security assistance aid was released to Ukraine. Yet the House managers continue to argue that President Trump conditioned the aid on an investigation of the Bidens. Did the Ukrainian president or his government ultimately meet any of the alleged requirements in order to receive the aid?
Mr. Chief Justice. Thanks, Senator, for the question. And the very short answer is no. But I'll explain. And I think that's clear. And I think we demonstrated in our presentations on Friday and Monday that the aid was released, the aid flowed. There was a meeting at the UN General Assembly. There was a meeting previously scheduled in Warsaw, precisely as President Zelensky had suggested, and there was never any announcement of any investigations undertaken regarding the Bidens, Burisma, the 2016 election. No statements made, no investigations announced began by the Ukrainian government. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Virginia.
Mr. Chief Justice, I send a question to the desk for the House managers.
The question is, Do you know about additional information related to Russia disseminating President Trump's or Rudolph Giuliani's conspiracy theories? Should the Senate have this information before we deliberate on the articles of impeachment?
Mr. Chief Justice, Senators, I think there are three categories of relevant material here. The first you do have access to, and that is the supplemental testimony of Jennifer Williams. And I would encourage you all to read it. I think it sheds light very specifically on the Vice President and what he may or may not know vis-a-vis this scheme. So I would encourage you to read that submission. There is a second body of intelligence that the committees have been provided that is relevant to this trial that you should also read. And we should figure out the mechanism that would permit you to do so because it is directly relevant to the issues we are discussing and pertinent. There's a third category of intelligence, too, which raises a very different problem, and that is that the intelligence communities are for the first time refusing to provide to the Intelligence Committee. And that material has been gathered. We know that it exists, but the NSA has been advised not to provide it. Now, the director says that this is the director's decision, but nonetheless there is a body of intelligence that is relevant to requests that we have made that is not being provided. And that raises a very different concern than the one before this body, and that is, are now other agencies like the intelligence community that we require to speak truth to power, that we require to provide us the best intelligence, now also withholding information at the urging of the administration. And that is, I think, a deeply concerning and new phenomenon. That problem we've obviously had with other departments that have been part of the wholesale obstruction, but it now is rearing its ugly head with respect to the IC. But the shorter answer to the question on, apart from Jennifer Williams, are there other relevant materials? The answer is yes. And I would encourage that you and we work together to find out how you might access them.
Thank you, Mr. Manager. Mr. Majority Leader.
Mr. Chief Justice, the next two questions, one from each side, will be the last before we break for dinner. I would ask that following the next two questions, the Senate stand in recess for 45 minutes.
Thank you. Senator from Alabama.
I send a question to the desk.
Question is directed to counsel for the President. How does the non-criminal abuse of power standard advanced by the House managers differ from maladministration, an impeachment standard rejected by the framers? Where is the line between such an abuse of power and a policy disagreement?
Thank you very much for that question, because that question, I think, hits the key to the issue that's before you today. When the framers rejected maladministration, and recall that it was introduced by Mason and rejected by Madison on the ground that it would turn our new republic into a parliamentary democracy where a prime minister, in this case a president, can be removed at the pleasure of the legislature. Remember, too, that in Britain, impeachment was not used against the prime minister. All you needed was a vote of no confidence. It was used against lower-level people. And so maladministration was introduced by Mason, and Madison said, no, it would turn us, it was just too vague and too general. Now, what is maladministration? If you look it up in the dictionary and you look up synonyms, the synonyms include abuse, corruption, misrule, dishonesty, misuse of office, and misbehavior. Even Professor Nicholas Bowie, a Harvard professor who was in favor of impeachment. So this is an admission against interest by him. He's in favor of impeachment. He says abuse of power is the same as misconduct in office, and he says that his research leads him to conclude that a crime is required. By the way, the congressman was just completely wrong when he said, I'm the only scholar who supports this position. In the 19th century, which is much closer in time to when the framers wrote, Dean Dwight of the Columbia Law School wrote that the weight of authority, by which he meant the weight of scholarly authority and the weight of judicial authority, this is 1867, the weight of authority is in favor of requiring a crime. Justice Curtis came to the same conclusion. Others have come to a similar conclusion. You asked what happened between 1998 and the current to change my mind. What happened between the 19th century and the 20th century to change the mind of so many scholars? Let me tell you what happened. What happened is that the current president was impeached. If, in fact, President Obama or President Hillary Clinton had been impeached, the weight of current scholarship would be clearly in favor of my position, because these scholars do not pass the shoe on the other foot test. These scholars are influenced by their own bias, by their own politics, and their views should be taken with that in mind. They simply do not give objective assessments of the constitutional history. Professor Tribe suddenly had a revelation himself. At the time when Clinton was impeached, he said, oh, the law is clear. You cannot charge a president with a crime while he's the sitting president. Now we have a current president. Professor Tribe got woke. And with no apparent new research, he came to the conclusion, oh, but this president can be charged while sitting in office. That's not the kind of scholarship that should influence your decision. You can make your own decisions. Go back and read the debates, and you will see that I am right, that the framers rejected vague, open-ended criteria, abuse of power, and what we had is the manager made a fundamental mistake again. She gave reasons why we have impeachment. Yes, we feared abuse of power. Yes, we feared criteria like maladministration. That was part of the reason. We feared incapacity. But none of those made it into the criteria because the framers had to strike a balance. Here are the reasons we need impeachment, yes. Now, here are the reasons we fear giving Congress too much power. So we strike a balance. How did they strike it? Treason, a serious crime. Bribery, a serious crime. Or other high crimes and misdemeanors akin to treason and bribery. That's what the framers intended. They didn't intend to give Congress a license to decide who to impeach and who not to impeach on partisan grounds. I read you the list of 40 American presidents who have been accused of abuse of power. Should every one of them be impeached? Should every one of them have been removed from office? It's too vague a term. Reject my argument about crime. Reject it if you choose to. Do not reject my argument that abuse of power would destroy the impeachment criteria of the Constitution and turn it, in the words of one of the senators of the Johnson trial, to make every president, every member of the Senate, every member of Congress be able to define itself from within their own bosom. We heard from the other side that every senator should decide whether you need proof beyond a reasonable doubt or proof by a preponderance. Now we hear that every senator should decide what abuse of power. Thank you, Mr. Chief Justice.
President. Mr. Chief Justice.
Senator from Maryland.
Chief Justice, I have a question on behalf of Senator Markey and myself that I send to the desk for the House managers.
The question is as follows. Supreme Court Justice Byron White, in a concurring opinion in Nixon versus United States, 1993, acknowledged that the Senate, quote, has very wide discretion in specifying impeachment trial procedures, end quote, but stated that the Senate, quote, would abuse its discretion, end quote, if it were to, quote, insist on a procedure that could not be deemed a trial by reasonable judges, end quote. If the Senate does not allow for additional evidence and the testimony of key witnesses with firsthand knowledge of President Trump's actions and intentions, would a reasonable judge conclude these proceedings constitute a constitutionally fair trial?
I think the answer is yes. I don't know that we need to look to the words of a prior justice to tell us that a trial without witnesses is not really a trial. It's certainly not a fair trial if the House moves forward with impeachment and comes before the Senate and wants to call witnesses and wants to make its case and is told, "Thou shalt not call witnesses." That's not a fair trial. I think that the American people understand that without reading the case law. They go to jury duty themselves every year, and they see the first thing that takes place after the jury is sworn in is the government makes its opening statement, the defense makes theirs, and then begins the calling of witnesses. I do want to take this opportunity, though, to respond to Professor Dershowitz's argument while they're fresh. You can say a lot of things about Alan Dershowitz. You cannot say he's unprepared. He's not unprepared today. He wasn't unprepared 21 years ago. And to believe that he would not have read 21 years ago what Mason had to say, or Madison had to say, or Hamilton had to say, I'm sorry, I don't buy that. I think 21 years ago he understood that maladministration was rejected, but so was a provision that confined the impeachable offenses to treason and bribery alone was rejected. I think the Alan Dershowitz from 21 years ago understood that, yes, while you can't impeach for a policy difference, you can impeach a president for abuse of power. That's what he said 21 years ago. Nothing has changed since then. I don't think you can write off the consensus of constitutional opinion by saying they're all never Trumpers. All the constitutional law professors, in fact, let's play a snippet from Professor Turley, who was in the House defending the president, and see what he had to say recently.
On abuse of power, in my view, it's clear. You can impeach a president for abuse of power. You can impeach a president for non-criminal conduct.
Okay, now, we can't argue plausibly that his position is owing to some political bias, right? I mean, just a few weeks ago, he was in the House arguing the case for my GOP colleagues that the president shouldn't be impeached. Now, he did say, well, if you could actually prove these things, you could prove, as indeed we have, that the president abused his power by conditioning military aid to help his reelection campaign, yes, that is an abuse of power. You can't impeach for that kind of abuse of power. And that's exactly what we have here. We're not required to leave our common sense at the door. If we're to interpret the Constitution now as saying that a president can abuse their power, and I think the professor suggested before the break that he can abuse his power in a corrupt way to help his reelection, and you can't do anything about it. You can't do anything about it because if he views it as in his personal interest, that's just fine. He's allowed to do it. None of the founders would have accepted that kind of reasoning. In fact, the idea that the core offense that the founders protected against, that core offense is abuse of power, is beyond the reach of Congress through impeachment, would have terrified the founders. I mean, you can imagine any number of abuses of power. A president who withholds aid from another country at war as a thank you for that adversary allowing him to build a Trump Tower in that country. Okay, that may not be criminal, but are we really going to say that we're going to have to permit a president of the United States to withhold military aid as a thank you for a business proposition? Now, counsel acknowledges that a crime is not necessary, but something akin to a crime. Well, we think there's a crime here of bribery or extortion, conditioning of official acts for personal favors. That is bribery. It's also what the founders understood as extortion. And you cannot argue, even if you argue, well, under the modern definition of bribery, you've got to show such and such. You cannot plausibly argue that it's not akin to bribery. It is bribery, but it's certainly akin to bribery. But that's the import of what they would argue, that no, the president has a constitutional right. Under Article 2, he can do anything he wants. He can abuse his office and do so sacrificing our national security, undermining the integrity of the elections, and there's nothing Congress can do about it.
Thank you, Mr. Manager. We're in recess.
Okay, so they are in recess until 7:15 Eastern Time, so that's 6:15 Central Standard Time. So that's what, like 30 minutes? No, like 45 minutes. Okay, you guys, so there is another thing that's going on. I think I'm just going to go ahead and end the stream here because, well, I don't know if they're going to be voting on the ability to include other witnesses or not, actually, so maybe I should just keep it going. You know what? I'm going to keep it going. Is there anybody in here to hear me arguing with myself? No, I think it's just me and myself on my phone. Okay, so I'm just going to leave this up and running. There is another hearing that's happening at 10 o'clock Eastern Time for some reason, 10 o'clock p.m. I don't know what that's about, but I'm gonna hopefully stream that. I'm not sure if it's actually happening or not, so we shall see. Thank you all for watching. I'm gonna go ahead and put on some tunes until they come back. Like I said, it's gonna be a little while, so we're just gonna put on some tunes until then. That way I don't have to start the stream back up. Make sure you're subscribed and hit that like button or the don't like button if you don't like it. Whatever, that's cool. It's all gravy, baby. You have your opinion. And check us out on Twitter and Instagram at GrowTheInfo, and check out our website, growtheinfo.com, for all kinds of great information, press releases, and stuff that you can use to make your own content. Thank you guys so much for watching. Okay, they should start back up here soon, hopefully. Thanks for joining, Carolyn. Anybody that's watching, go check out Carolyn. She's got some awesome videos. Yeah, the senators were at recess, and you know how it is trying to get in kids from recess. They just want to play and play and play, so I guess that's why it's taking so long. I am trying to see, let's see here if I can show you guys what else I'm looking at. So tonight, can you see what do you see what I see? Yes, okay, you do see what I see. Alrighty. So today, Wednesday, January 29th, on house.gov, at the very bottom, after all of these hearings that they've had today, which I was thinking about switching to some of them, but I could not be bothered to do that today. I had so much other stuff to do. But they have one at 10 p.m. for evaluating the Trump administration's policies on Iran, Iraq, and the use of force. This is something that they keep talking about a lot. See, it says January 29th at 10 a.m. and it says postponed. And then if you look at the hearing notice, it says January 28th. And then it says postponed. Today's the 29th, but see down here it says Wednesday, January 29th, 2020, and then note the hearing will be rescheduled. So it was supposed to be on the 28th, and then they had to postpone it, and then maybe it was supposed to be at 10 a.m., and now it's going to be at 10 p.m., and Mike Pompeo is going to be the witness. So regardless of if the impeachment hearings are still going on, I'm going to be, if that's going on tonight, then I'm going to be showing that. I know probably nobody's going to be watching it, but I don't know what they're going to be talking about at 10 p.m. That's really, really late. Like, really late. Like, I'll probably go to sleep and have the stream up and running. But I want to know what they're talking about. And in the stream this morning, I covered some stuff that's going on between the U.S. and Israel. So if anybody's watching that hasn't seen
Senate will
that,
come to order.
then check that out. Thank you guys so much for watching. You're awesome. Love you. Yay.
Mr. Chief Justice.
Oh, the senator from Arizona?
I send a question to the desk on behalf of myself and Senator Scott of Florida, Hawley, and Hoven.
Thank you. The question is for counsel for the president from Senator McSally, Senator Scott from Florida, Senator Hawley, and Senator Hoven. Chairman Schiff just argued that, quote, we think there's a crime here of bribery or extortion, or, quote, something akin to bribery, end quote. Do the articles of impeachment charge the president with bribery, extortion, or anything akin to it? Do they allege facts sufficient to prove either crime? If not, are the House manager's discussion of crimes they neither alleged nor proved appropriate in this proceeding?
Mr. Chief Justice, Senators, thank you for that question. And no, the articles of impeachment do not charge the crime of bribery, extortion, or any other crime. And that's a critical point because, as the Supreme Court has explained, no principle of procedural due process is more clearly established than that of notice of the specific charge and a chance to be heard in a trial of the issues raised by that charge are among the constitutional rights of every accused. That was the Supreme Court in Cole versus Arkansas. And the court has also explained that for over 130 years, a court cannot permit, it has been the rule that a court cannot permit a defendant to be tried on charges that are not made in the indictment against him. That is the rule in the criminal law, and it is also the case for impeachments. It is the House's responsibility to make an accusation, and a specific accusation, in articles of impeachment. The House had the opportunity to do that, and they did that. And the charges that they put in the articles were abuse of power on a vague standard that they made up and obstruction of Congress. They put some discussion about other things in a House Judiciary Committee report, but they did not put that in the articles of impeachment. And if this were a criminal trial in an ordinary court, and Mr. Schiff had done what he just did on the floor here and start talking about crimes of bribery and extortion that were not in the indictment, it would have been an automatic mistrial. We'd all be done now, and we could go home. And Mr. Schiff knows that because he's a former prosecutor. It is not permissible for the House to come here failing to have charged, failing to have put in articles of impeachment any crime at all, and then to start arguing that actually, oh, we think there is some crime involved, and actually, we think we actually proved it, even though we provided no notice we were going to try to prove that. It's totally impermissible. It's a fundamental violation of due process. And scholars have pointed out those rules apply equally in cases of impeachment. Charles Black and Philip Bobbitt explained in their work, Impeachment, a handbook that is regarded as one of the authorities collecting sources of authority on impeachments. They said, quote, "The senator's role is solely one of acting on the accusations, the articles of impeachment, voted by the House of Representatives. The Senate cannot lawfully find the president guilty of something not charged by the House, any more than a trial jury can find a defendant guilty of something not charged in the indictment," end quote. So what Manager Schiff just attempted here was totally improper. It would have resulted in a mistrial in any court in this country. And there is nothing that has been introduced in the facts that would satisfy the elements of a crime of extortion or bribery either. And to attempt, after making their opening, after not charging anything in the articles that is a crime, after not specifying any crime, after providing no notice that they're going to attempt to argue a crime, in the question and answer session to try to change the charges that they've made against the President of the United States and to say that actually there's bribery and extortion is totally unacceptable. It's not permissible. And this body should not consider those arguments. They were not permissible bounds for argument. They're not included in the articles of impeachment, and they should be ignored. Thank you.
Thank you, Counsel. Yes, the senator from New Mexico.
Thank you for the recognition, Mr. Chief Justice. Mr. Chief Justice, I have sent a question to the desk. I'm joined in this question by Senators Blumenthal, Leahy, and Whitehouse.
Thank you. The question from Senator Udall, joined by Senators Blumenthal, Leahy, and Whitehouse, is to the House managers. The President's Counsel has argued that Hunter Biden's involvement with Burisma created a conflict of interest for his father, Joe Biden. President Trump, the Trump Organization, and his family, including those who serve in the White House, maintain significant business interests in foreign countries and benefit from foreign payments and investments. By the standard the President's Counsel has applied to Hunter Biden, should Mr. Kushner and Ms. Trump's conflicts of interest with foreign governments also come under investigation?
Mr. Chief Justice, and to the senators, thank you so much for that question. Let me just preface what I'm about to say with this statement. This has been a tough few days. It's been a trying time for each of us and for our nation. But I just want to say this in response to the question that has been posed. I stand before you as the mother of 3 sons. I'm sure that many of you in this chamber have children, sons and daughters, and grandchildren that you think the world of. My children's last name is Demings. And so when they go out to get a job, I wonder if there are people who associate my sons with their mother and their father. I just believe as we go through this very tough, very difficult debate about whether to impeach and remove the President of the United States, that we stay focused. The last few days we've seen many distractions. Many things have been said to take our minds off of the truth, off of why we're really here. In my former line of work, I used to call it working with smoke and mirrors. Anything that will take your attention off of what's painfully obvious, what's there in plain view. The reason why we're here has nothing to do with anybody's children, as we've talked about. The reason why we're here is because the President of the United States, the 45th President, used the power of his office to try to shake down, I'll use that term because I'm familiar with it, a foreign power to interfere into this year's election. In other words, the President of the United States tried to cheat and then tried to get this foreign power, this newly elected president, to spread a false narrative that we know is untrue about interference in our election. That's why we are here, and it really would help, I believe, the situation if the Attorney General, perhaps the Department of Justice, who's been pretty silent, would issue a ruling or an opinion about any person of authority, especially the President of the United States, using or abusing that authority to invite other powers into interfering in our election. And so, Mr. Chief Justice, I will just close my remarks as I began them. Let us stay focused. This doesn't have anything to do with the President's children or the Biden's children. This is about the President's wrongdoing. Thank you.
Thank you. Senator from Idaho.
Mr. Chief Justice, on behalf of myself, Senator Risch, Senator Cruz, Graham, Braun, Moran, and Bozeman, I send a question to the desk for the Counsel for the President.
The question from Senator Crapo and the other senators for the Counsel for the President. Does the evidence in the record show that an investigation in the Burisma Biden matter is in the national interest of the United States and its efforts to stop corruption?
Mr. Chief Justice, Senators, thank you for that question. And the straightforward answer is yes, the evidence does show that it would be in the interest of the United States. In fact, the evidence on that point is abundant. Here's what we know. Hunter Biden was appointed to the board of an energy company in Ukraine without any apparent experience that would qualify him for that position. He was appointed shortly after his father, the vice president, became the Obama administration's point man for policy on Ukraine. We know that his appointment raised several red flags at the time. Chris Hines, the stepson of the then Secretary of State, severed his business relationship with Hunter, citing Hunter's lack of judgment in joining the board of that company, Burisma, because Burisma was owned by an oligarch who was repeatedly under investigation for corruption, for money laundering, and other offenses. Contemporaneous press reports speculated that Hunter's role with Burisma might undermine U.S. efforts, led by his father then at that time, to promote the U.S. anti-corruption message in Ukraine. The Washington Post said, quote, "The appointment of the vice president's son to Ukrainian oil board looks nepotistic at best, nefarious at worst," end quote. There were other articles. There was one that reported, quote, "The credibility of the United States was not helped by the news that Hunter had been on the board of the directors of Burisma." There was another article saying, sadly, the credibility of Mr. Biden's message may be undermined by the association of his son with the Ukrainian natural gas company, Burisma Holdings, which is owned by a former government official suspected of corrupt practices. And it went on. Reports from the Wall Street Journal said that activists here, that is in the Ukraine, say that the U.S.'s anti-corruption message is being undermined as his son receives money from a former Ukrainian official who is being investigated for graft. At the same time, within the Obama administration, officials raised questions. The Special Envoy for Energy Policy, Amos Hochstein, raised the matter with the Vice President. Similarly, Deputy Assistant Secretary of State Kent testified that he too voiced concerns with Vice President Biden's office. Everyone who was asked in the proceedings before the House of Representatives agreed that there was at least an appearance of a conflict of interest when Mr. Biden's son was appointed to the board of this company. That included Ambassador Yovanovitch, Deputy Assistant Secretary Kent, Lieutenant Colonel Vindman, Jennifer Williams, Ambassador Sondland, Dr. Fiona Hill, and Ambassador Taylor. They all agreed there was an appearance of a conflict of interest. And even in the transcript of the July 25th telephone call, President Zelensky himself acknowledged the connection between the Biden and Burisma incident, the firing of the prosecutor who reportedly had been looking into Burisma, when Vice President Biden openly acknowledged he leveraged $1 billion in U.S. loan guarantees to make sure that that particular prosecutor was fired. He openly acknowledged it was an explicit quid pro quo. You don't get $1 billion in loan guarantees unless and until that prosecutor is fired. My plane's leaving in 6 hours, he said on the tape. And when the President Trump, raised this in the July 25th call, President Zelensky recognized that this related to corruption. And he said, the issue of the investigation of the case, and he's referring to the case of Burisma, is actually the issue of making sure to restore the honesty, so we will take care of that. And he later said in an interview that he recognized that President Trump had been saying to him, things are corrupt in Ukraine, and he was trying to explain, no, we're going to change that. There's not going to be corruption. So that explicit exchange in the July 25th call shows that President Zelensky recognized that that Biden-Burisma incident had an impact on corruption and anti-corruption. And so it was definitely undermining the U.S. message on anti-corruption, and it was a perfectly legitimate issue for the president to raise with President Zelensky to make clear that the United States did not condone anything that would seem to interfere with legitimate investigations and to enforce the proper anti-corruption message. Thank you.
Thank you, counsel. Senator from Illinois. Thank you. Senator Durbin's question is directed to the House managers. Would you please respond to the answer that was just given by the President's counsel?
Mr. Chief Justice, Senators, the President sought Ukraine's help in investigating the Bidens only after reports suggested Vice President Biden might enter the 2020 presidential race and would seriously challenge President Trump in the polls. President Trump had no interest in Biden's Obama-era Ukraine work in 2017 or 2018, when Biden was not running against him for president. None of the 17 witnesses in the impeachment inquiry provided any credible evidence, no credible evidence, to support the allegation that former Vice President Biden acted inappropriately in any way in Ukraine. Instead, witnesses testified that the former vice president was carrying out official U.S. policy in coordination with the international community when he advocated for the ouster of a corrupt Ukrainian official. In short, the allegations are simply unfounded. President Trump's own handpicked special envoy to Ukraine Ambassador Kurt Volker knew they were unfounded too. He testified that he confronted the president's attorney, Mr. Giuliani, about these conspiracy theories and told him that, quote, "It is simply not credible to me that Joe Biden would be influenced in his duties as vice president by money or things for his son or anything like that. I've known him for a long time. He's a person of integrity, and that's not credible." Giuliani acknowledged that he did not find one of the sources of these allegations, a former Ukrainian prosecutor, to be credible. So even Giuliani knew the allegations were false. Our own Justice Department confirmed that the president never spoke to the Attorney General about Ukraine or any investigation into Vice President Biden. If President Trump genuinely believed that there was a legitimate basis to request Ukraine's assistance in law enforcement investigations, there are specific formal processes that he should have followed. Specifically, he could have asked the DOJ to make an official request for assistance through the Mutual Legal Assistance Treaty. It's worth noting the president only cares about Hunter Biden to the extent that he is the vice president's son, and therefore a means through which to smear a political opponent. But President Trump specifically mentioned Vice President Biden in asking for the removal of the former prosecutor on that July 25 call. That is what he wanted, not an investigation into Hunter Biden. This is yet another reason you know that there is no basis for investigating Vice President Biden. Can we get slide 52 up? The timing shows clearly that despite the fact that this conduct occurred in 2015, it wasn't until Vice President Biden began consistently beating Trump in national polls in the spring of 2019 by significant margins that the president targeted Biden. He was scared of losing. The president wanted to cast a cloud over a formal political opponent. This wasn't about any genuine concern of wrongdoing. The evidence proves that this was solely about the president wanting to make sure that he could do whatever it took to make sure that he could win. So he froze the critical money to Ukraine to coerce Ukraine to help him attack his political opponent and secure his reelection. Well, the President of the United States cannot use our taxpayer dollars to pressure a foreign government to do his personal bidding. No one is above the law.
Thank
I yield
you.
back.
The senator from South Carolina.
Thank you, sir. I send a question to the desk on behalf of myself, Senators Crapo and Graham, for the White House Counsel.
The question is from Senator Scott to the White House Counsel. House managers claim that the Biden-Burisma affair has been debunked. What agency within the government or independent investigation led to the debunking?
Mr. Chief Justice,
members of the Senate, there is no evidence in the record about any investigation, let alone debunked, sham, discredited, or, as Manager Jeffries told you tonight, phony. The House managers haven't cited any evidence in the record because none exists. A couple of days ago, I read to you a quote and statements from Vice President Biden dealing with corruption in Ukraine. What I didn't tell you was he made those statements before the Ukrainian parliament directly. He spoke about the historic battle of corruption. He spoke about fighting corruption, specifically in the energy sector. He spoke about no sweetheart deals. He said oligarchs and non-oligarchs must play by the same rules. Corruption siphons away resources from the people. It blunts economic growth, and it affronts the human dignity. Those were Vice President Biden's words. So the real question is this: is corruption related to the energy sector in Ukraine run by a corrupt Ukrainian oligarch who was paying our Vice President's son and his son's business partner millions of dollars for no apparent legitimate reason, while his father was overseeing our country's relationship with Ukraine, merit any public inquiry, investigation, or interest? The answer is yes. And simply by saying it didn't happen is ridiculous. And with all due respect to the House managers inciting to our children, the message to our children, especially when you're overseeing a corruption and trying to root it out in another country, is to make sure your children aren't benefiting from it. That's what should be happening, not to sit there and say that it's okay. The House managers don't deny that there's a legitimate reason to do an investigation. They just say it was debunked, it's a sham, it's illegitimate, but they don't tell you when it happened. And we all remember the email that Chris Hines sent. Keep this in mind. He is the stepson of the then Secretary of State, John Kerry. He sends an official email to the State Department, to the Chief of Staff, to John Kerry and his special assistant. The subject is Ukraine. There's no question when you look at that email that it's a warning shot to say, I don't know what they're doing, but we're not invested in it. He's taking a giant step back. And think about the words, and remember the video that we saw about Hunter Biden. What did he say? I'm not going to open my kimono. I'm not going to open my kimono when he was asked how much money he was making. In 1 month alone, Hunter Biden and his partner made almost as much as every senator and congressman, just in 1 month alone, what you earn in a year. And you don't think that merits inquiry? Does anyone here think, when they say it's a debunked investigation that didn't happen, that we wouldn't remember if there was testimony of Hunter Biden, Joe Biden, Secretary of State John Kerry, his stepson, their business partner, his chief of staff, and his special assistant? How can you tell the American people it doesn't merit inquiry when our vice president's son is supposedly doing this for corporate transparency in Ukraine? He's going to oversee the legal department of a Ukrainian company? He's going to help them. And if you look at his statement that I read to you beforehand, there's another part of it from October of 2019. If you want to know whether he thought it dealt with outside of Ukraine in just the Burisma, he says he was advising Burisma on its corporate reform initiatives, an important aspect of fueling Burisma's international growth and diversity. And listen to this statement by Hunter Biden's attorney. Vibrant energy production, particularly natural gas, was central to Ukraine's independence and to stemming the tide of Vladimir Putin's attack on the principles of a democratic Europe. Do you think he understood when he was getting the millions of dollars what his father was doing? The only problem is that statement didn't come out till October of 2019. Only when the news story started to break, only when the House managers raised these issues did people start to talk about it. Tell us where we saw Joe Biden, Hunter Biden, John Kerry testify about it. Tell us where you did it when you did your impeachment hearings. I don't remember seeing that testimony. I don't remember seeing the bank records. We put the bank records in front of you. And the people are entitled to know
what exactly was going on.
Thank you, counsel. The senator from Oregon.
Thank you, Mr. Chief Justice. On behalf of the senator from New Mexico, Martin Heinrich, and myself, I have a question to send to the desk.
Thank you. The question from Senator Merkley and other senators is for counsel to the President. Please clarify your previous answer about the Bolton manuscript. When exactly did the first person on the President's defense team first learn of the allegations in the manuscript? Secondly, Mr. Bolton's lawyer publicly disputes that any information in the manuscript could reasonably be considered classified. Was the determination to block its publication on the basis that it contains classified information made solely by career officials, or were political appointees in the White House counsel's office or elsewhere in the White House involved?
Mr. Chief Justice, Senator, to address your question specifically, the allegation that came out in the New York Times article about a conversation that is allegedly reported in the manuscript between the President and Ambassador Bolton, officials, lawyers in the White House counsel's office learned about that allegation for the first time on Sunday afternoon when the White House was contacted by the New York Times. In terms of the classification review, it is conducted at the NSC. The White House counsel's office is not involved in classification review, determining what's classified or not classified. I can't state the specifics. My understanding is that it's conducted by career officials at the NSC, but it's handled by the NSC. So I'm not in a position to give you full information on that. My understanding is being done by career officials, but it is not being done by lawyers in the White House counsel's office. And I hope that answers your question, Senator.
Thank you, counsel.
Mr. Chief Justice.
Senator from Alaska.
Mr. Chief Justice, I send a question to the desk on behalf of myself and Senator Langford for the President's counsel.
Thank you. Question from Senator Sullivan and Langford to the counsel for the President. There has been conflicting testimony about how long the Senate might be tied up in obtaining additional evidence. At the beginning of this trial, the minority leader offered 11 amendments to obtain additional evidence in the form of documents and depositions from several federal agencies. If the Senate had adopted all 11 of these amendments, how long do you think this impeachment trial would take?
Mr. Chief Justice, members of the Senate, it would take a long time. It would take a long time just to get through those motions. But there have been 17 witnesses. We're talking about now additional witnesses that the managers have put forward and that Democratic Leader Schumer has discussed. He's discussed 4 witnesses in particular, as if this body would, if it were to grant witnesses, would say, yes, you get those 4 witnesses, and the White House and the President's counsel gets what? Whatever I want. That's what he said, Mr. Schumer, whatever I want. Here's who I want. I want Adam Schiff. I want Hunter Biden. I want Joe Biden. I want the whistleblower. I want to also understand there may be additional people within the House Intelligence Committee that have had conversations with that whistleblower. I get anybody we want. By the way, if we get anybody we want, we will be here for a very long time. The fact of the matter is, we're not here to argue witnesses tonight, but it obviously is an undercurrent. But to say that this is not going to extend this proceeding, months. Because understand something else. Despite the executive privilege and other nonsense, I suspect Manager Schiff, smart guy, he's going to say, wait a minute, I got some speech and debate privileges that may be applicable to this. I'm not saying that they are, but they may raise it, be legitimate to raise it. So this is a process that this would be the first of many weeks. I think we've got to be clear. They put this forward in an aggressive and fast-paced way. And now they're saying, now we need witnesses. After 31 or 32 times you said you proved every aspect of your case. That's what you said. Well, you didn't. You said he just said he did. Well, then I don't think we need any witnesses. Thank you.
Thank you, counsel. Yeah, the senator from New Jersey. The question is from Senator Menendez to the House managers. President Trump has maintained that he withheld U.S. security assistance to Ukraine because he was concerned about corruption. Yet his purported concern about corruption did not prevent his administration from sending congressionally appropriated assistance to Ukraine more than 45 times between January 2017 and June 2019, totaling more than $1.5 billion. So why did the president suddenly become concerned about corruption in early 2019?
Mr. Chief Justice, Senator, thank you for the question. He became concerned about corruption, supposedly, in early 2019 because Vice President Biden was running for election for the presidency. That is what the overwhelming amount of the evidence shows, because there's no other legitimate reason, as your question points out. First, the publicly released records of President Trump's April 21 and 25 calls with President Zelensky never mentioned the word corruption, despite the fact that the talking points for these calls prepared by his own staff listed corruption. Second, in May 2019, the State and Defense Department certified to Congress Ukraine had, quote, taken substantial actions for the purposes of decreasing corruption, end quote, and met the anti-corruption benchmarks this very body has established when it appropriated $250 million of those funds. Third, by the time of the July 25th call, President Zelensky had already established his anti-corruption bona fides, having introduced a number of reform bills in Ukraine. Fourth, on July 26th, the day after his call with President Zelensky, President Trump spoke to Ambassador Sondland, who was in Ukraine. The one question the president asked Ambassador Sondland was not about corruption, but about whether or not President Zelensky was going to do the investigations. Fifth, the released aid, as your question points out, Senator, the president released the aid in 2017 and in 2018. And he released it in 2019 only after having gotten caught. In the words of Lieutenant Colonel Vindman and other witnesses, the conditions on the ground had not changed. So, we're hearing a lot tonight about the concerns about corruption, Burisma, Russia. But the facts still matter here. We are here for one reason and one reason only. The President of the United States withheld foreign aid that he was happy to give in the 2 prior years, that suddenly we are to believe something changed, the conditions on the ground changed, and he had an epiphany about corruption within a week of Vice President Biden announcing his candidacy. It doesn't make any sense. And one other thing I will say with regard to the aid is this assertion that President Trump has been the strongest supporter of Ukraine. And I talked about this earlier. Let's just assume that to be the case. And if it is the case, as the President's counsel has contended over and over again, then there is, of course, no reason to withhold the aid because nothing has changed. This leads us inevitably only to one conclusion, and that is that the President of the United States used taxpayer dollars, the American people's money, to withhold aid from an ally at war to benefit his political campaign. Do not be distracted by Russian propaganda, by conspiracy theories, by people asking you to look in other directions. That is what this is about. That will not change. The facts will continue to come out, whether this body subpoenas them or not. The facts will come out. The question now is, will they come out in time, and will you be the ones asking for them when you are going to be making the decision in a couple of days to sit in judgment?
Mr. Manager.
Mr. Chief Justice.
Senator from Wisconsin.
I sent a question to the desk for the President's counsel.
Thank you. Question from Senator Johnson for the President's counsel. If House managers were certain it would take months to litigate a subpoena for John Bolton, why shouldn't the Senate assume lengthy litigation and make the same decision as the House made, reject a subpoena for John Bolton?
Mr. Chief Justice, members of the Senate, I think that's precisely the point. And the fact is that if, in fact, we are to go down that road of a witness or witnesses that had national, in the case of Ambassador Bolton, high-ranking NSA. This is an individual that's giving the president advice at the highest level. The Supreme Court's been very consistent on that. That's where privileges are at their highest level. The presumed privilege, actually, is what the Supreme Court has said. And in a situation like this, I think we're going down a road, if the Senate goes this road, of a lengthy proceeding with a lot more witnesses. And then I want to ask this question and just plant it as a thought. Is that going to be the new norm for impeachment? You put an impeachment together in a couple of weeks. We don't like what the president did. We get it through in a 2-day proceeding in front of the Judiciary Committee. We wrap it up and we send it up here and say, now go figure it out. Because that's what this is really becoming. That's what this actually is. So I think if we're looking at the institutional interests that are at stake here, this is a very dangerous precedent. Because what they're doing, what they're saying is basically, well, we have enough to prove our case. That's what Manager Schiff says, but not really. So we really need more evidence, not because we need it, because we want it. But we didn't want it bad enough when we were in the House, so we didn't get it. So now you issue the subpoena, and then let's duke it out in court and see what happens. Sounds like to me that this is, they're acting like this is some municipal traffic court proceeding. I remind everybody that we're talking about, under their articles of impeachment, they are requesting the removal of the President of the United States. So, they're already saying in the media that there are ongoing investigation. They're going to continue to investigate. So are we going to be doing this every 3 weeks? Every month except in the summer? There's an election months away. The people should have a right to vote. My colleague Pat Cipollone, the White House counsel, said that. So when I look at all of this, whether it's the late need of witnesses after you said you proved your case, if it's how do privileges apply or not apply, Senator Schumer said we get anybody we want, we'd be here for a very, very long time. And that's not good for the United States. Thank you.
Thank you, counsel. The Democratic leader is recognized.
I have a question.
The question is for the House managers. Would you please respond to the answer that was just given by the President's counsel?
I think we can all see what's going on here, and that is if the House wants to call witnesses, if you want to hear from a single witness, if you want to hear what John Bolton has to say, we are going to make this endless. We, the president's lawyers, are going to make this endless. We promise you. We're going to want Adam Schiff to testify. We're going to want Joe Biden to testify. We're going to want Hunter Biden. We're going to want the whistleblower. We're going to want everyone in the world. If you dare, if you have the unmitigated temerity to want witnesses in a trial, we will make you pay for it with endless delay. The Senate will never be able to go back to its business. That's their argument. How dare the House assume there will be witnesses in a trial? Shouldn't the House have known when they undertook its investigation that the Senate was never going to allow witnesses? That this would be the first impeachment trial in the history of the Republic with no witnesses. So Mr. Sekulow wants me to testify. I'd like Mr. Sekulow to testify about his contacts with Mr. Parnas or Mr. Cipollone about the efforts to implement the president's fight on all subpoenas. I'd like to ask questions about, well, I'd like to ask questions of the president and put him under oath. But we're not here to indulge in fantasy or distraction. We're here to talk about people with pertinent and probative evidence. And you know something? I trust the man behind me, sitting way up, who I can't see right now. But I trust him to make decisions about whether a witness is material or not, whether it's appropriate to out a whistleblower or not, whether a particular passage in a document is privileged or not. It's not going to take months of litigation, although that's what the President's Counsel is threatening. They're doing the same thing to the Senate they did to the House, which is you try to investigate the President, you try to try the President, we will tie you and your entire chamber up in knots for weeks and months. And you know something? They will if you let them. You don't have to let them. You can subpoena John Bolton. You can allow the Chief Justice to make a determination in camera whether something is relevant, whether it deals with Ukraine or Venezuela, whether it's privileged or it isn't, whether it's the privilege is being misapplied to hide criminality or wrongdoing. We don't have to go up and down the courts. We've got a perfectly good Chief Justice sitting right behind me who can make these decisions in real time. So don't be thrown off by this claim, oh, if you even think about it, we are going to make you pay with delays like you've never seen. We're going to call witnesses that will turn this into a circus. It shouldn't be a circus. It should be a fair trial. You can't have a fair trial without witnesses. I think when I was asked that question before, I answered the affirmative when it meant the negative. You can't have a fair trial without witnesses. And you shouldn't presume that when a House impeaches, the Senate trials from now on will be witness-free, will be evidence-free. That's not what the founders intended. If it was, they would have made you the Court of Appeals, but they didn't. They made you the triers of fact. They expected you to hear from witnesses. They expected you to evaluate their credibility. Don't take my word for it about John Bolton. Look, I'm no fan of John Bolton, although I like him a little more than I used to. But you should hear from him. You should want to. Don't take General Kelly's view for it. Make up your own mind, whether you believe him or Mick Mulvaney, whether you believe John Bolton or the President. Make up your own mind. Yes, we proved our case, counsel. We proved it overwhelmingly. But you chose to contest the fact that the President withheld military aid to coerce an ally. You chose to contest it. You chose to make John Bolton's testimony relevant, pertinent. If you had stipulated the President did as he is charged, then you might make the argument that you're making here. But you haven't. You've contested it. And now you want to say, but the Senate shall not hear from this witness. That's not a fair trial. It's not even the appearance of fairness. You can't have a fair trial without basic fairness.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from Louisiana.
I send a question to the desk on behalf of myself and Senator Risch. To be both to the White House counsel and the House managers.
Thank you. Question from Senator Cassidy and Senator Risch for both parties, beginning with the President's counsel first. We saw a video of Mr. Nadler saying, quote, "There must never be a narrowly voted impeachment or an impeachment supported by one of our major political parties and opposed by the other. Such an impeachment will lack legitimacy, will produce divisiveness and bitterness in our politics for years to come, and will call into question the very legitimacy of our political institutions," end quote. Given the well-known dislike of some House Democrats for President Trump and the stated desire, of some to impeach before the President was inaugurated, and the strictly partisan vote in favor of impeachment, do the current proceedings typify that which Mr. Nadler warned against 20 years ago?
Mr. Chief Justice, Senators, thank you for the question. The simple answer is yes. These are exactly the sort of proceedings that Manager Nadler warned against 20 years ago. It is a purely partisan impeachment, and it has been clear that at least some factions on the other side of the aisle, on the Democratic side of the aisle, have been intent on finding some way to impeach the President from the day he was sworn in and even before the day he was sworn in. And that's dangerous for our country. To allow partisan venom and enmity like that to take hold and become the norm for driving impeachments is exactly what the framers warned against. It's in Federalist number 65. Hamilton warned against it. He warned against persecution by an intemperate and designing majority in the House of Representatives, and that's exactly what the framers did not want impeachment to turn into. And yet, that is clearly what it is turning into here. And both Manager Nadler and Democratic Leader Schumer, in the video that we saw, were prescient in forewarning that if we start to go down this road, I mean, one thing that seems to be sure in Washington is that what goes around comes around. If it's done once to one party, it'll happen again from the other party to the other party once the office of the presidency change hands. And then we'll be in a cycle. It'll get worse and worse, and there'll be more and more. And every president will be impeached. That's not what the framers intended, and this body shouldn't allow it to happen here. Thank you.
Counsel?
The evidence is overwhelming that President Trump pressured a foreign government to target an American citizen for personal and political gain as part of President Trump's corrupt effort to cheat and solicit foreign interference in the 2020 election. There is a remedy for that type of stunning abuse of power, and that remedy is in the Constitution. That remedy is impeachment and the consideration of removal, which is what this distinguished body is doing right now. That's not partisan. That's not the Democratic Party playbook. That's not the Republican Party playbook. That is the playbook in a democratic republic, given to us in a precious fashion by the framers of the Constitution. The impeachment in this instance, of course, and the consideration of removal is necessary because President Trump's conduct strikes at the very heart of our free and fair elections. As North Carolinian Delegate William Davey noted at the Constitutional Convention, quote, "If he be not impeachable while in office, he will spare no efforts or means whatsoever to get himself re-elected." The framers of the Constitution understood that perhaps this remedy would one day be necessary. That is why we are here right now. The American people should decide an American election, not the Ukrainians, not the Russians, not the Chinese, the American people. That is why this president was impeached. That is why it is appropriate for Democrats and Republicans, both sides of the aisle, not as partisans, as Americans, to hold this president accountable for his stunning abuse of power.
Thank you, Mr. Manager.
Chief Justice,
Senator from Vermont.
I send the question to the desk for the House managers.
Thank you. Senator Sanders asks the House managers, Republican lawyers have stated on several occasions that two people, Senator Johnson and Ambassador Sondland, were told directly by President Trump that there was no quid pro quo in terms of holding back Ukraine aid in exchange for an investigation into the Bidens. Given the media has documented President Trump's thousands of lies while in office, more than 16,200 as of January 20th, why should we be expected to believe that anything President Trump says has credibility?
Well, I'm not quite sure where to begin with that question, except to say that if every defendant in a trial could be exonerated just by denying the crime, there would be no trial. It doesn't work that way. I think it's telling that when Ambassador Sondland spoke with President Trump, the first words out of his mouth, according to Sondland, were no quid pro quo. That's the kind of thing you do. You blurt out when you've been caught in the act and you say, it wasn't me. I didn't do it. But even then, the president couldn't help himself, because the other half of that conversation was no quid pro quo, but Zelensky needs to go to the mic, and what's more, he should want to. No quid pro quo, but quid pro quo. Now, this reminds me of something that came up earlier. Why would the president, when he's on the call on July 25th, knowing that there are other people listening, why on earth would the president engage in this kind of shakedown with others within earshot? You know, and I think this question comes up in almost every criminal trial. Why would the defendant do that? And sometimes it's very hard to fathom. Sometimes just people make mistakes. But I think in the case of this president, he truly believes that he's above the law. He truly believes that he's above the law. It doesn't matter who's listening. It doesn't matter who's listening. If it's good for him, this is, I guess, a version of the Dershowitz argument. If it's good for him, it's good for the state, because he is the state. If it helps his reelection, it's good for America. And whatever means he needs to effectuate his election, whether it's withholding military aid or what have you, as long as it helps him get elected, well, it's good for America because he is the state. This is why I think he is so irate when people come forward and blow the whistle. Not just the whistleblower, but people like John Bolton or General Kelly. And you might ask the question, why do so many people who leave this administration, why do they walk away from this president with such a conviction that he is undermining our security, that you cannot believe what he says? I mean, think about this. The president's now former chief of staff, General Kelly, doesn't believe the president of the United States. He believes John Bolton. I mean, can everybody be disgruntled? Can it all be a matter of bias? I think we know the answer. I think we know the answer. I mean, how do you believe a president that the Washington Post has documented so many false statements? The short answer is you can't. And I remember early in this presidency, many of us talked about how once as president you lose your credibility. Once as president, your country or your friends or allies around the world cannot rely on your word, just how destructive and dangerous it is to the country. And so we can't accept the denial. It's a false denial. And indeed, if you look at that Wall Street Journal article that Senator Johnson was interviewed in when he had that conversation with Sondland and had that sinking feeling because he didn't want those two things tied together, everyone understood they were tied together. It was as simple as 2 + 2 = 4. So can you rely on a false exculpatory? You can't with this president any more than you can with any other accused. And probably, given the president's track record, a lot less than other accused. But at the end of the day, we have people with firsthand knowledge. You don't have to rely on his false exculpatory. You don't have to rely on Mick Mulvaney's recanting what you all saw so graphically on TV. How does someone who say, without a doubt, this was a factor, this is why he did it? And by the way, Alan Dershowitz lost a criminal case in which he argued that if a corrupt motive was only part of the motive, you can't convict, and the court said, oh, yes, you can. If a corrupt motive is any part of it, you can convict. So he's lost that argument before. He makes that argument again before this court. It shouldn't be any more availing here than it was there. At the end of the day, though, there's no more interested party here than the President of the United States. And I think we have seen he will say whatever he believes suits his interest. Let's instead rely on the evidence and rely on others, and one is just a subpoena away.
Thank you, Mr. Manager. Senator from Colorado.
I send the question to the desk.
Thank you. Question from Senator Gardner is for counsel to the President. Arguments have been made that any assertion of protection from disclosure is indicative of guilt, and that the House's assertion of impeachment power cannot be questioned by the executive. Is that interpretation of the House's impeachment power consistent with the Constitution, and what protects the executive from the House abusing the impeachment power in the future?
Mr. Chief Justice and Senators, thank you for that question. The House manager's assertion that any effort to assert a privilege, assert a legal immunity, to decline disclosing information is somehow a sign of guilt is not the law. It is actually fundamentally contrary to the law. Legal privileges exist for a reason. We allow people to assert their rights. It's a basic part of the American justice system, and asserting your rights, asserting privileges, immunities, due process rights, even if it means limiting the information that might be turned over to a tribunal, is not and cannot be treated as evidence of guilt. And to the second part of the question, as to the House manager's theory that the power of impeachment means that the president can't resist any subpoena that they issue pursuant to the power of impeachment, it's not consistent with the Constitution. The Constitution gives the House the sole power of impeachment, which means only that the House is the only place, the only part of the government that has that power. It doesn't say that they have a paramount power of impeachment that destroys all other constitutional rights or privileges or immunities. It doesn't mean that executive privilege suddenly disappears. And the House managers a number of times have cited Nixon versus United States. Or I might get it reversed now, United States versus Nixon. The case involving President Nixon. In 1974, the Supreme Court determined that in that particular case, after a balancing of interests, assertions of executive privilege would have to give way. But it did not say that there is just an absolute blanket rule that any time there's an allegation of wrongdoing or that there's some impeachment going on in the background, executive privilege just disappears. That is not the rule from that case. And in fact, even in that context, the court pointed out that there might be an absolute immunity or privilege in the field of foreign relations and national security, which is the field that we're dealing with here. The framers recognized that there could be partisan and illegitimate impeachments. They recognized that the House could impeach for the wrong reasons. They didn't leave the executive branch totally defenseless to that. Executive privilege, immunities rooted in executive privilege, such as the absolute immunity for senior advisors, still applies even in the context of an impeachment. That's part of the checks and balances in the Constitution. They don't fall away simply because the House says, now we want to proceed on impeachment. It's necessary for the proper functioning of the government and the separation of powers for the executive branch to retain that ability to protect confidentiality interests, to protect the prerogatives of the office of the presidency. And for any president to fail to assert those rights and to protect them would do lasting damage to the office of the presidency for the future. And I think that's a critical point to understand, that there is a danger in the legal theory that the House managers are proposing here, because it would do lasting damage to the separation of powers, to the structure of our government, to have the idea be that as soon as the House flips the switch that they want to start proceeding on impeachment, the executive has no defenses and has to open every file and display everything. That's not the way the framers had it in mind, because the executive branch has to have still its defenses for its sphere of authority under the Constitution. That's part of the checks and balances. And before I sit down, I'd just like to close, going back to the senator who asked the question about the review process on the Bolton book. I believe I was clear about this, but I just want to make 100% sure. To the extent the senator was asking for an assurance that only career officials in the NSC review it for classification review, I can't make that assurance because it's an NSC process. And I'm not sure at the levels of the process there might be other reviews. So I didn't intend to give, and I don't want it to be understood as giving that assurance to you. Thank you.
Thank you, counsel. The senator from Massachusetts.
Mr. Chief Justice, I sent a question to the desk for House managers and counsel to the President.
Thank you. The House managers will respond first to this question from Senator Warren. If Ukrainian President Zelensky called President Trump and offered dirt on President Trump's political rivals in exchange for President Trump handing over hundreds of millions in military aid, that would clearly be bribery and an impeachable offense. So why would it be more acceptable and somehow not impeachable for the reverse? That is, for President Trump to propose this same corrupt bargain.
Bribery is obviously an impeachable offense. Bribery is contained within the accusation that the House leveled of abuse of power. We explained in the Judiciary Committee report the practice of impeachment in the United States has tended to envelop charges of bribery within the broader standard of other high crimes and misdemeanors. That's the historical standard. The elements of bribery are clearly established here. The abuse of power is clearly established when the President of the United States offers something of, extorts a foreign power to get a benefit for himself, withholds military aid in order to get that foreign power to do something that will help him politically. That is clearly bribery, it's clearly an abuse of power, and there's no question about it. Now, by the way, the question was raised earlier as to what the proper standard of proof is. People pointed out the Constitution doesn't say. But the highest standard of proof is beyond a reasonable doubt, and these facts have been proven not beyond a reasonable doubt, beyond any doubt.
the question. I think what this hypothetical shows and Manager Nadler shows is this is an effort to try to smuggle into articles of impeachment that do not mention any crime the idea that there is some crime alleged here. There's not. And I went through that earlier. The articles of impeachment specify a theory of the charge here that is abuse of power. They do not allege the elements of bribery or extortion. They don't mention bribery or extortion. If the House managers had wanted to bring those charges, they had to put them in the articles of impeachment. Just the way a prosecutor, if he wants to put someone on trial for bribery, he's got to put it in the indictment. If you don't, and you come to trial and then try to start arguing that, well, actually, we think there is bribery going on here, that's impermissible. It's prosecutorial misconduct. And so a hypothetical that is contrary to what the facts were here to try to suggest that maybe there's some element of bribery, that's all beside the point. We have specific facts. We have evidence that has been presented in the record. We have a specific article of impeachment. It doesn't say bribery. It doesn't say extortion. And there's no way to get that into this case at this point because the House managers had the opportunity to frame their case. They had every opportunity to frame it any way they wanted because they controlled the whole process. They controlled all the evidence that went in. They controlled all the evidence that was the witnesses that were called. And they could frame it any way they wanted. And they didn't put in any crime. There's no crime asserted here. It's not part of the articles of impeachment, and it can't be considered now. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Kansas.
Thank you, Mr. Chief Justice. I submit to the desk a question on my behalf and on behalf of Senator Cornyn.
The question from Senator Moran and Senator Cornyn is for counsel to the President. Is it true that in these proceedings that the Chief Justice can rule on the issue of production of exhibits and the testimony of witnesses over the objection of either the managers or the President's counsel? Would a determination by the Chief Justice be subject to judicial review?
Mr. Chief Justice, Senators, thank you for the question. And let me answer it this way, lay out my understanding of the process. If we were going to start talking about subpoenaing witnesses, subpoenaing documents, having things come into evidence that way, the first question would be subpoenas would have to be issued to the witnesses or for the documents. And if those subpoenas were resisted on the grounds of some privilege or immunity, then that would have to be sorted out. Because if the President asserted, for example, the immunity of a senior advisor to the President or an executive privilege over certain documents, then the Senate would have to determine whether it was going to fight that assertion and how, through some accommodation process and negotiation, or if the Senate were going to go to court to litigate that. And that whole process would have to play out. That would be the first stage. And that would have to be gone through any time the President resisted the subpoena on the witnesses or documents. That would take a while. That's what the House managers decided not to do in the House of Representatives. Then, once there had been everything resolved on a subpoena or something like that, it sounds like the question asks further in terms of questions here in the trial, admissibility of particular evidence. It's my understanding then that the presiding officer, the Chief Justice, could make an initial determination if there were objections to admission of evidence, but that all such determinations can be challenged by the members of the Senate and would be subject to a vote. So it would not be, I think there were some suggestions earlier that we don't need any other courts, we don't need anything, the involvement of anyone else, because the Chief Justice is here. That's not correct. On the subpoenas at the front end, that's not going to be something that's determined, just with all respect, sir, by the Chief Justice. That's something that would have to be sorted out in the courts or by negotiation with the executive branch. Then once we're here on specific evidentiary objections, if we have a witness and there are objections during depositions that later have to be resolved or by a witness on the stand, if there are objections to particular documents, authentication or things like that, The Chief Justice could make an initial ruling, but every one of those rulings could be appealed to this body to vote by a majority vote on whether the evidence would come in or not. And you might have to consider rules, whether you're going to have the federal rules of evidence apply or some modified rules of evidence, and all of that would have to be sorted out. I don't think that we would get to the stage then of any determinations on evidence here being in any way appealed out to the courts. But that would be a process that this body would have to decide what would be admissible in evidence in the trial. Thank you.
Thank you, counsel.
Mr. Chief Justice. Mr. Chief Justice, I send a question.
I'm sorry, excuse me? Yes, Senator from Minnesota.
Thank you. I send a question to the desk.
Thank you. The question from Senator Smith is to the House managers. The President has stated multiple times in public that his actions were perfect, yet he refuses to allow Bolton, Mulvaney, and others to testify under oath. If the President's actions are so perfect, why wouldn't he allow fact witnesses to testify under oath about what he has said publicly?
Well, the short answer is if the President were so confident that this was a perfect call and that those around him would agree that there was nothing nefarious going on, he would want witnesses to come and testify. But of course he doesn't. He doesn't want his former National Security Advisor to testify. He doesn't want his current Chief of Staff to testify. He doesn't want those that were heading OMB to testify. He doesn't want you to hear from any of them. Now, I think that's pretty indicative that he knows what they have to say. And he doesn't want you to hear what they have to say. He doesn't want you to see any of the myriad of documents that he has been withholding from this body as he did from the House. But I also want to address the last question, if I could. Is the Chief Justice empowered under the Senate rules to adjudicate questions of witnesses and privilege? And the answer is yes. Can the Chief Justice make those determinations quickly? The answer is yes. Is the Senate empowered to overturn the Chief Justice under certain circumstances? Is the vote 50 or is the vote 2/3? That would be something that we would have to discuss with the parliamentarian and with the Chief Justice. But the Chief Justice has the power to do it. And what's more, under the Senate rules, you want expedited process? We are here to tell you we will agree with the Chief Justice's ruling on witnesses, on their materiality, on the application or non-application of privilege. We agree to be bound by the Chief Justice. We will not seek to litigate an adverse ruling. We will not seek to appeal an adverse ruling. Will the President's counsel do the same? And if not, just as the President doesn't trust what these witnesses have to say, the President's lawyers don't want to rely on what the Chief Justice's rulings might be. Now, why is that? They, as we understand, the Chief Justice will be fair. I'm not for a moment suggesting they don't think the Chief Justice is fair. Quite the contrary. They're afraid he'll be fair. They're afraid he'll make a fair ruling. That should tell you something about the weakness of their position. They don't want a fair trial with witnesses. They don't want a fair justice to adjudicate these questions. They just want to suggest to you that they will delay and delay and delay. I think it was Thomas Paine said, those who would enjoy the blessings of liberty must undergo the rigors of defending it, the fatigues of defending it. Is it too much fatigue for us to hear from a witness? Is that how little effort we're willing to put into the blessings of freedom and liberty? Is that how little fatigue we are willing to incur?
Thank you, Mr. Manager.
Mr. Chief Justice,
The gentleman from Nebraska.
I send a question to the desk on behalf of myself, Tim Scott, and Marco Rubio.
Thank you. Question from Senator Sass, and also on behalf of Senator Scott from South Carolina and Mr. Rubio. It's directed to counsel for the President. Mr. Cipollone pointed senators to the, quote, golden rule of impeachment, end quote. In elaborating on that rule, can you offer your views on the limiting principles, both in the nature of offenses that should be considered and in the proximity to elections, for future impeachments toward the end of safeguarding public trust by putting guardrails on both parties?
Thank you, Mr. Chief Justice, members of the Senate. In elaborating on the golden rule of impeachment, I would say principle number one, if we listen to what the Democratic senators said in the past and the House managers and other members of the House, that should guide us. And that principle is, and it's a principle based in precedent, that you shouldn't have a partisan impeachment. If you have a partisan impeachment, that in and of itself is a danger sign. Because that means that there's not the bipartisan support that even the Speaker of the House has said you would need to even begin to consider the impeachment of a president, because it is the overturning of an election. They don't dispute that. It is the overturning of an election. In addition, it is the removal of this president from an election that's occurring in just months from now, which I think is another important principle. I think the other important fact here is that there's actually bipartisan opposition to this impeachment. Democrats voted against it in the House of Representatives. That's an important principle. The other principle would be that if you have a process that's unprecedented, that should be something that ought to be considered. Always in the past, there's been a vote authorizing an impeachment. Why? Because they say the House is the sole authority of an impeachment, but that's the House, not the Speaker of a House at a press conference. That's another important consideration. Another important consideration is all of the historical precedents related to rights given to a president in a process have been violated. We haven't seen anything like that in our history. The President's counsel wasn't able to attend, wasn't allowed to cross-examine witnesses, wasn't allowed to call witnesses. And they're coming here and basically asking you, number one, to call witnesses that they refuse to pursue. But more importantly, I think what they're saying is do what they did. Only call witnesses that they want. Don't allow the President to call witnesses that the President wants. That doesn't work. That's not due process. You know, the other important principle there is we hear a lot about fairness, but in the American justice system, fairness is about fairness to the accused. Fairness is about fairness to the accused. So how you could suggest that what we're going to do is we're going to have a trial, we'll get the witnesses as prosecutors that we want, even though you got to call no witnesses in the House, you got to cross-examine none of the witnesses that we called, and have we got a deal for you? Let us call another witness, but you call none. That's another principle. And I think the reality is that what Professor Dershowitz said is true. I think when you're thinking about impeachment as much as we can as human beings, we should think about it in terms of the president is the president regardless of party. And how would we treat a president of our own party in similar circumstances? And I think that's the golden rule of impeachment. And I don't think we have to guess here, because I think we have lots of statements from Democrats when we were here last time around, and principles, and I said, I agree with them. I agree with those principles. I just ask that they be applied here. So that's my answer. Thank you.
Thank you, counsel. Senator from Illinois. Thank you. Senator Durbin asks the House managers, if President Trump were to actually invoke executive privilege in this proceeding, wouldn't he be required to identify the specific documents or communications containing sensitive material that he seeks to protect?
As stated before, executive privilege is a very limited privilege that must be claimed by the President. He has at no time claimed executive privilege. Rather, he's claimed absolute immunity, a non-existent concept that every court that has ever considered it has rejected it. Instead, he has simply said, we will oppose all subpoenas. We will deny to the House all information, whatever they want, they can't have. This is way beyond the pale. And it is intended to, because he fears the facts. And the facts are, he tried to extort a foreign government through withholding military aid that this Congress had voted. He broke the law to withhold the aid that this Congress had mandated be sent to them in order to pressure them into announcing an investigation of his political opponents. Those are the facts. Those facts are proven beyond any doubt at all. So what do we have? We have diversion after diversion. Diversions about what Hunter Biden may have done in Ukraine. Irrelevant. Whatever he did in Ukraine, the question is, did the president withhold foreign military aid in order to extort a foreign government into helping him rig an American election? We hear diversions about privilege. We hear questions about witnesses. We know he's telling the senators, don't allow witnesses. Why? Because he knows what the witnesses will say. We hear arguments from his counsels. Well, we've taken enough time with witnesses. The House shouldn't have voted if it didn't have proof positive. We had proof positive. We voted it. Doesn't mean you shouldn't have more proof if it comes forward. There is no argument that Mr. Bolton shouldn't be permitted to testify, and he's not going to waste our time. He's told us he'll testify with a subpoena. So all of the questions are diversions. They're diversions by a president who is desperate because we have proven the facts that he threatened a foreign government, not just threatened them, did in fact withhold mandated American military aid from them in order to blackmail them into serving his political purposes for private political purposes. We know that. Everything else is a diversion. No witnesses, because maybe those witnesses will testify in a way he doesn't want. Privilege, when you're dealing with accusations of wrongdoing against the president, the Supreme Court told us in the Nixon case, privilege yields. So all of these arguments are diversions. Keep your eye on the facts. The facts we have proven, and let's see the additional witnesses. And as Mr. Schiff said, witnesses should not be a threat, not to the Senate, not to anybody else. And it's not going to waste too much time because the Chief Justice can rule on relevant questions of relevancy or privilege or anything else. But the facts are the facts. The president is a danger to the United States. He's tried to rig the next election. He's abused his power, and he must be brought to heel, and the country must be saved from his continuing efforts to rig our elections.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from Utah.
I submit a question to the desk.
Thank you. The question from Senator Romney is for the counsel to the president. On what specific date did President Trump first order the hold on security assistance to Ukraine, and did he explain the reason at that time?
Mr. Chief Justice, Senator, thank you for the question. I don't think that there is evidence in the record of a specific date, the specific date, but there is testimony in the record that individuals at OMB and elsewhere were aware of a hold as of July 3rd, and there is evidence in the record of the President's rationales from even earlier than that time. There is an email from June 24th that has been publicly released. It was publicly released in response to a FOIA request that is from one DOD staffer up to the Chief of Staff in DOD, from the Chief of Staff down to a staffer in DOD relating on the subject line POTUS follow-up. It's follow-up from a meeting with POTUS, the President of the United States, explaining questions that had been asked about the Ukraine assistance, which were specifically, what was the funding used for, i.e., did it go to U.S. firms, who funded it, and what do other NATO members spend to support Ukraine? So from the very beginning in June, the President had expressed his concern about burden sharing, what the other NATO members do. Similarly, in the July 25th transcript, there was the President asked President Zelensky specifically, he raised the issue of burden sharing, again showing that that was his concern. In addition, it was, I believe, Mr. Morrison who testified that he was aware from OMB that the President had expressed concerns about corruption and that there was a review process to consider corruption in Ukraine. So the evidence in the record shows that the President raised concerns at least as of June 24th, that people were aware of the hold as of July 3rd. The President's concerns about burden sharing were in the email on June 24th. They're reflected in the July 25th call. Similarly, there's testimony from later in the summer that the President had raised concerns about corruption in Ukraine. And so that is the evidence in the record that reflects the President's concerns. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Nevada.
Thank you. I send a question to the desk.
Thank you. The question from Senator Cortez Masto is to the House managers. The President's counsel has claimed that the President was unfairly excluded from House impeachment processes. Can you describe the due process President Trump received during House proceedings compared to previous presidents? Did President Trump take advantage of any opportunities to have his counsel participate?
Mr. Chief Counsel, and to the Senator, thank you so much for that question. Let me make this plain. The President is not the victim here. The victim in this case is the American people. President Trump was invited to attend and participate in all of the Judiciary Committee hearings. He could have had Mr. Cipollone, Mr. Sekulow, or any of the other attorneys who have joined at the counsel's table participate throughout the Judiciary Committee's proceedings in the House. They could have attended all of the judiciary hearings, and imagine this, cross-examine witnesses, raise objections, present evidence favorable to the president if they had any to present. And they could have requested to have President Trump's own witnesses called. But President Trump refused to participate. He wrote to the House, and I quote, "If you are going to impeach me, do it now, fast, so we can have a fair trial in the Senate." In every event, President Trump was asked, and indeed legally required, to provide evidence during the Intelligence Committee's investigation, but he refused, as we've already said over and over again, to produce any documents or allow witnesses to testify. We thank God for the 17 public servants who came forward in spite of the president's efforts to obstruct. In addition, Republican members in Congress had an equal opportunity to ask questions during the depositions and the hearings in both the Intelligence and the Judiciary Committee hearings. Republican members called 3 witnesses during the Intelligence Committee's hearings and an additional witness during the Judiciary Committee's hearings. Of course, a House impeachment inquiry is not a full-blown criminal trial. We do know that, but this is a trial, and obviously the president is being afforded every due process right during these proceedings.
Thank you.
Mr. Chief Justice.
The senator from Alaska.
Mr. Chief Justice, I send a question to the desk.
Thank you. Senator Murkowski's question is for the House managers. In early October, Mr. Cipollone sent the letter saying none of the subpoenas issued by the House were appropriately authorized and thus invalid. When the House passed their resolution authorizing the impeachment inquiry and granting subpoena power to the Intelligence and Judiciary Committees, the body could have addressed the deficiency the White House pointed out and proclaimed those subpoenas as valid exercises of the impeachment inquiry. Alternatively, the House could have reissued the subpoenas after the resolution was adopted. Please explain why neither of those actions took place.
Mr. Chief Justice, Senator, I appreciate your question. These arguments, plain and simple, are a red herring. The House's impeachment inquiry and its subpoena were fully authorized by the Constitution, House rules, and President. It is for the House, not the President, to decide how to conduct an impeachment inquiry. The House's autonomy to structure its own proceedings for an impeachment inquiry is rooted in 2 provisions of Article 1 of the Constitution. First, Article 1 vests the House with the sole power of impeachment. It contains no requirements as to how the House must carry out that responsibility. Second, Article 1 states that the House is empowered to determine the rules of proceedings. Taken together, these provisions give the House sole discretion to determine the manner in which it will investigate, deliberate, and vote for grounds of impeachment. In exercising its responsibility to investigate and consider the impeachment of a President of the United States, the House is constitutionally entitled to relevant information from the executive branch concerning the President's misconduct. The framers, the courts, and past presidents have recognized and honored Congress's right to information in an impeachment investigation and is critical as safeguard to our system of divided powers. Otherwise, a president could hide his own wrongdoing to prevent Congress from discovering impeachable misconduct, effectively nullifying Congress's impeachment power. That is precisely what President Trump has tried to achieve here. The president has asserted the power to determine for himself which congressional subpoenas he will respond to and those that he will not. The President's counsel would have you believe that each time anyone in the executive branch gets a subpoena, it's open season for creative lawyers in the White House and DOJ to start inventing theories about House rules and parliamentary precedent. This is not how the separation of powers works, and to accept that argument would wholly undermine the House and Senate's ability to provide oversight of the executive branch. It would also make impeachment a nullity. The President argues that there was no resolution fully authorizing the impeachment inquiry. But again, there is no requirement for the full House to take a vote before conducting an impeachment inquiry. President Trump and his lawyers invented this theory. As Chief Judge Howell of the U.S. District Court in D.C. has stated, and this is a direct quote, "This claim has no textual support in the U.S. Constitution or governing rules in the House. The Constitution itself says nothing about how the House may exercise its sole power of impeachment, but instead confirms the House shall have the sole power to determine the rules of its own proceedings." This conclusion is also confirmed by precedent. Numerous judges have been subjected to impeachment investigations in the House, and even impeached by the House and convicted by the Senate without any previous vote of the House authorizing an impeachment inquiry. As recently as the 114th Congress, the Judiciary Committee considered impeaching the IRS commissioner following a referral from another committee and absent a full House vote. The Judiciary Committee began an investigation into President Nixon's misconduct for 4 months before approval of a full House resolution. The House rules also do not preclude committees from inquiring into the potential grounds for impeachment. Instead, those rules vest the relevant committees of the House with robust investigatory powers, including the power to issue subpoenas. Each of the 3 committees that conducted the initial investigation of President Trump's conduct in Ukraine, Intelligence, Oversight, and Foreign Affairs, indisputably had oversight jurisdiction over these matters. The President's counsel has pointed to the Nixon impeachment, where the full House—
Thank you very much. Thank you.
Thank you. I yield back.
Mr. President.
The senator from Rhode Island.
Mr. President, I send a question to the desk, and because my question references an earlier question, I have attached that earlier question as a reference to the presiding officer and the parliamentarian in case it should be of interest.
Thank you. The question from Senator Whitehouse is to counsel for the President. White House counsel refused to answer a direct question from Senator Collins and Senator Murkowski, saying he could only cite to the record. 5 minutes afterward, House counsel read recent newspaper stories to the Senate from outside the House record. Could you please give an accurate and truthful answer to the Senator's question? Did the President ever mention the Bidens in connection to corruption in Ukraine before Vice President Biden announced his candidacy in April 2019? What did the President say, to whom, and when?
Mr. Chief Justice, Senator, thank you for the question. I don't think that I refused to answer the question at all. We had been advised by the House managers that they were going to object if we attempted to introduce anything that was not either in the public domain, so things that are in newspaper articles, things like that that are out there we could refer to, or things that were in the record. And so I'm not in a position to go back into things that the President might have said in private, and there's been no discovery into that. It's not part of this inquiry. So I can't go telling now about things that the President might have said to cabinet members. I'm not in a position to say that. I can tell you what's in the public, and I can tell you what's in the record. And I answered the question fully to the best of my ability based on what is in the public domain and what is in the record. I'd like to take a moment to also respond to the last question that was posed by Senator Murkowski with respect to the vote on authorizing the issuance of subpoenas, because there has always been a vote from the full House to authorize any impeachment inquiry into a presidential impeachment. It was that way in the Johnson impeachment. It was that way in the Nixon impeachment. There have been references to the fact that the House Judiciary Committee began some investigatory work before the House actually voted on the resolution. I think it was Resolution 803 to authorize the impeachment inquiry. But all of that work was simply gathering things that were in the public domain or that had been already gathered by other committees. And there was no compulsory process issued. And in fact, Chairman Rodino of the House Judiciary Committee specifically determined when there was a move to have the House Judiciary Committee issue subpoenas after the Saturday Night Massacre, that the committee lacked the authority to issue any compulsory process until there had been a vote by the full House to authorize the committee to do that. And this is not some esoteric special rule about impeachments. As I've tried to explain, this is just a fundamental rule under the Constitution about how authority that has been given by we the people to chambers of the legislature, to either the House or the Senate, once it's given there to the House, how does it get to a committee? It can only get down to a committee if it's delegated by the House. That can only happen if the House votes. And there is no standing rule that gives the House Judiciary Committee authority to use the power of impeachment as opposed to the authority to legislate. There's no rule that gives it the power to use the authority of impeachment to issue compulsory process. Rule 10 doesn't mention impeachment at all. The word doesn't appear in it. And that's why it has always been the understanding that there must be a vote from the House to authorize the House Judiciary Committee, or in this case, it was contrary to all prior practice, it was given to Manager Schiff's committee and other committees, the authority to use the power of impeachment to issue subpoenas. It was very clear to the House of Representatives that the position of the executive branch was that all of the subpoenas issued before House Resolution 660 were invalid on their face. And Senator Murkowski's question is exactly correct. There was no effort in House Resolution 660 either to attempt to retroactively authorize those subpoenas or to say that those subpoenas, to retroactively authorize those subpoenas, or then to reissue them under House Resolution 660. So the subpoenas remained invalid, and there was no response from the House to that. Thank you.
Thank you, counsel. Senator from Missouri.
Mr. Chief Justice, I sent to the desk a question for both counsel to the President and the House managers on my own behalf and on behalf of Senator Cruz, Senator Daines, and Senator Braun.
Thank you. The President's Counsel will respond first to the question from Senator Hawley and the other senators. When he took office, Viktor Shogun, Ukraine's prosecutor general, vowed to investigate Burisma. Before Vice President Joe Biden pressed Ukrainian officials on corruption, including pushing for the removal of Shogun, did the White House counsel's office or the Office of the Vice President Legal Counsel issue ethics advice approving Mr. Biden's involvement in matters involving corruption in Ukraine or Shogun, despite the presence of Hunter Biden on the board of Burisma, a company widely considered to be corrupt. Did Vice President Biden ever ask Hunter Biden to step down from the board of Burisma?
Mr. Chief Justice, Senators, thank you for the question. We're not aware of any evidence that then Vice President Biden sought any ethics opinion. We are aware that both Amos Hochstein and Deputy Assistant Secretary of State Kent testified, Amos Hochstein is in the public domain. Deputy Assistant Secretary Kent testified in the proceedings before the House that they each raised the issue with Vice President Biden of the potential appearance of a conflict of interest with his son Hunter being on the board of Burisma. Deputy Assistant Secretary Kent testified that although he raised that issue with the Vice President's office, the response was that the Vice President's office, the Vice President was busy dealing then with the illness of his other son, and there was no action taken. So from what we know, there wasn't any effort to seek an ethics opinion. We're not aware of an ethics opinion having been issued. Although the issue was flagged for the Vice President's office, we're not aware that President Biden asked his son to step down or that any other action was taken. And I believe that Vice President Biden has said that he never discussed, he said publicly, he never discussed his son's overseas business dealings with him. Thank you.
So,
Mr. Chief Justice and Senator, I appreciate your question. The facts about Vice President Biden's conduct are clear and do not change. Let's go through them. First, every witness asked about this topic testified that Mr. Shulkin was widely considered to be a corrupt and ineffective prosecutor who did not prosecute corruption. Shulkin was so corrupt that the entire free world, the United States, the European Union, the International Monetary Fund, pressed for his office to be cleaned up. So I would caution you to be skeptical of anything that Mr. Shulkin claims. Second, witnesses, including our own anti-corruption advocate, Ambassador Yovanovitch, remember that very dedicated anti-corruption ambassador, testified that Shulkin's removal made it more likely that investigations of corrupt Ukrainian companies would move forward. Let me repeat that. The dismissal of Shulkin made it more likely that Burisma would be investigated. Third, Burisma was not under scrutiny at the time Joe Biden called for Shulkin's ouster. According to the National Anti-Corruption Bureau of Ukraine, an organization several witnesses testified is effective at fighting corruption. Shulkin's office investigated Burisma, but the probe focused on a period before Hunter Biden joined the company. But again, in another investigation was warranted, dismissing Shulkin would have made that more likely.
thank you. Senator
Mr. Chief
from Maine.
Justice. Mr. Chief Justice, I have a question for the House managers I will send to the desk.
Thank you. Senator King's question for the House managers reads as follows. Mr. Rudolph Giuliani was in Ukraine exclusively on a political errand by his own admission, so doesn't the President's mention of Giuliani by name in the July 25th call conclusively establish the real purpose of the call?
Mr. Chief Justice, members of the Senate, Mr. Giuliani played a key role in President Trump's months-long scheme to pressure Ukraine to announce political investigations to benefit the president's re-election campaign. Remarkably, the president's defense is wrapping themselves in Rudy Giuliani's involvement in Ukraine while trying to minimize his role. There is overwhelming evidence, not just testimony, but texts, call records, and other corroborating documents, establishing Mr. Giuliani's key role in executing the president's pressure campaign beginning in early spring 2019 with the smear campaign against Ambassador Yovanovitch, and then throughout the summer. Everyone knew that Rudy Giuliani was the gatekeeper to the president on Ukraine. On May 10th, Mr. Giuliani canceled a trip to Ukraine during which he planned to dig up dirt on former Vice President Biden and on a discredited conspiracy theory after his plans became public. He admitted, "We're not meddling in an election, we're meddling in an investigation." He explained that someone could say it's improper and this isn't foreign policy. I'm asking them to do an investigation that they're already doing and that other people are telling them to stop. And he was talking about the investigations of the Bidens. During a May 10th appearance on Fox News, Giuliani also said that he canceled his trip because they're enemies of Trump around President Zelensky. Mr. Giuliani's associate, Lev Parnas, produced a set of documents to the House Intelligence Committee that included a letter, and I believe we have slide 50 here, Mr. Giuliani sent to President-elect Zelensky during this time period. In the letter dated May 10th, Mr. Giuliani informed Zelensky that he represented President Trump as a private citizen, not as President of the United States. He also requested a meeting with President Zelensky on May 13th and 14th, along with Victoria Toensing in his capacity as personal counsel to President Trump and with his knowledge and consent, close quote. Mr. Giuliani confirmed President Trump's knowledge of his actions with regard to Ukraine, stating, "He knows what I'm doing. Sure, as his lawyer." He added, "My only client is the President of the United States. He's the one I have an obligation to report to. Tell him what happened." President Trump repeatedly instructed senior American and Ukrainian officials to talk to Rudy, demonstrating that Mr. Giuliani was a key player in the corrupt scheme. In a May 23rd Oval Office meeting to discuss Ukraine policy, President Trump directed his handpicked three amigos to talk to Rudy. In response, Ambassador Sondland testified, "Secretary Perry, Ambassador Volker, and I worked with Mr. Rudy Giuliani on Ukraine matters at the express direction of the President of the United States." After two explosive White House meetings on July 10th, in which Ambassador Sondland explicitly conveyed the President's demand for political investigations to Ukrainian officials, top Ukrainian aide Andrei Yermak texted Ambassador Volker, "I feel that the key for many things is Rudy." And what was Rudy asking? Investigations of two American citizens, not corruption in general, investigations. In fact, he wasn't even asking for an investigation. He was just asking for an announcement of an investigation so that American citizens, the Bidens, could be smeared. On the July 25th call with President Zelensky, President Trump mentioned Rudy Giuliani by name no less than 4 times and informed Zelensky that Rudy very much knows what's happening. He told President Zelensky, "Mr. Giuliani is a highly respected man." He added, "Rudy very much knows what's happening." In August, Mr. Giuliani met with a top Ukrainian aide and conveyed that Ukraine must issue a public statement announcing investigations. Ambassador Sondland and Volker then worked closely with Giuliani and the Ukrainians to ensure that the planned statement would meet Mr. Giuliani's demands. Specifically, Mr. Giuliani insisted that the statement include specific references to Burisma and the 2016 election and Biden. Throughout this process, Sondland stated that he knew that they needed the approval of Giuliani for the press statement and that they knew Giuliani represented the interests of the president. Rudy Giuliani admitted on live television to pressuring Ukraine to look into Joe Biden, not into corruption, into Joe Biden. In September 2019, Chris Cuomo asked Giuliani, "So you did ask Ukraine to look into Joe Biden?" In response, Giuliani insisted, "Of course I did." Mr. Giuliani insisted that Ukraine look into an American citizen on behalf of his client, President Trump. Finally, during the pendency of the impeachment proceedings, Mr. Giuliani has not ceased in his efforts to dig up dirt to benefit the president. In December, he again traveled to Ukraine to meet with Ukrainian officials, which he described as a secret assignment, and after which the president reportedly called him immediately upon landing and asked, "What did you get?" To which Mr. Giuliani responded, "More than you can imagine." It's worth noting that in Ms. Raskin's presentation about Giuliani, she never
thank you,
mentioned
Mr.
his
Manager.
repeated requests for investigations into Biden, not into corruption.
Mr. Chief Justice,
The senator from Florida.
I send a question to the desk on behalf of myself, Senator Sass, Braun, Risch, McSally, Roberts, and Hoeven.
Thank you. The question from Senator Rubio and the other senators is for counsel for the President. How would the framers view removing a president without an overwhelming consensus of the American people and on the basis of articles of impeachment supported by one political party and opposed by the other?
Thank you, Senators. Alexander Hamilton addressed that issue very directly. He said the greatest danger of impeachment is if it turns on the votes of one party being greater than the votes of another party in either house. So I think they would be appalled to see an impeachment going forward in violation of the Schumer rule and the rules of other congressmen that were good enough for us during the Clinton impeachment but seem to have changed dramatically in the current situation. The criteria that have been set out are so lawless, they basically paraphrase Congresswoman Maxine Waters, who said, there is no law. Anything the House wants to do to impeach is impeachable. That's what's happened today. That places the House of Representatives above the law. We've heard much about no one's above the law. The House of Representatives is not above the law. They may not use the Maxine Waters. Gerald Ford made the same point, but it was about the impeachment of a judge. Judges are different. There are many of them. There's only one president. But to use that criteria, that it's whatever the House says it is, whatever the Senate says it is, turns those bodies into lawless bodies in violation of the intent of the framers. Manager Schiff confused my argument when he talked about intent and motive. You've said I'm not a constitutional law, but you admitted I'm a criminal lawyer, and I've taught criminal law for 50 years at Harvard. And there is an enormous distinction between intent and motive. If somebody shoots somebody, the intent is that when you pull the trigger, you know a bullet will leave and will hit somebody and may kill them. That is the intent to kill. Motive can be revenge, it could be money. It almost never is taken into consideration except in extreme cases. There are cases where motive counts. But let's consider a hypothetical growing out of the situation that we've discussed. Let's assume that President Obama had been told by his advisors that it really is important to send lethal weapons to the Ukraine. But then he gets a call from his pollster and his political advisor who says, we know it's in the national interest to send lethal weapons to the Ukraine, but we're telling you that the left wing of your party is really going to give you a hard time if you start selling lethal weapons and getting into a lethal war, potentially with Russia. Would anybody here suggest that was impeachable? Or let's assume President Obama said, I promised to bomb Syria if they had chemical weapons, but I'm now told by my pollsters that bombing Syria would hurt my electoral chances. Certainly not impeachable at all. So let me apply that to the current situation. As you know, I said previously, there are three levels of possible motive. One is the motive is pure. Only interest is in the way what's good for the country. In the real world, that rarely happens. The other one is the motive is completely corrupt. I want money, kickback. But then there's the third one that's so complicated and that's often misunderstood. When you have a mixed motive, a motive in which you think you're doing good for the country, but you're also doing good for yourself. You're doing good for me, you're doing good for thee, you're doing good, and you all together put it in a bundle in which you're satisfied that you're doing absolutely the right thing. Let me give you a perfect example of that from the case. The argument has been made that the President of the United States only became interested in corruption when he learned that Joe Biden was running for a president. Let's assume, hypothetically, that the president was in his second term. And he said to himself, you know, Joe Biden's running for president. I really should now get concerned about whether his son is corrupt, because he's not only a candidate, and he's not running against me, I'm finished with my term, but he could be the president of the United States. And if he's the president of the United States and he has a corrupt son, the fact that he's announced his candidacy is a very good reason for upping the interest in his son. If he wasn't running for president, he's a has-been. He's the former vice president of the United States. Okay, big deal. But if he's running for president, that's an enormous big deal. So the difference the House managers would make is whether the president's in his first term or his second term, whether he's running for re-election or not running for re-election. I think they would have to concede that he was not running for re-election. This would not be a corrupt motive, or it would be a mixed motive, but leaning on the side of national interest. If he is running for re-election, suddenly that turns it into an impeachable offense.
Thank you, counsel. Oh, the senator from Minnesota.
Mr. Chief Justice, I submit a question to the desk directed to the House managers.
Thank you. The question is from Senator Klobuchar to the House managers. I was on the trial committee for the last impeachment trial in the Senate, which involved Judge Thomas Porteous, who was ultimately removed. During that time, the Senate Trial Committee heard from 26 witnesses, 17 of whom had not previously testified in the House. What possible reason could there be for allowing 26 witnesses in a judicial impeachment trial and hearing none for a president's trial?
Chief Justice, Senator, as you know, I'm quite familiar with the Porteous impeachment. Someone asked me the last time I tried a case. The answer is probably 30 years ago, except for the impeachment of Thomas Porteous, when I last spent some quality time with you. There is no difference in terms of the Constitution. I would say that the need for witnesses in the impeachment trial of a President of the United States is a far more compelling circumstance than the impeachment of a judge. Now, you might say, well, in the impeachment of a judge, how is it possible that the time of the Senate could be occupied by calling witnesses, that as precious as your time is, we would occupy your time calling dozens of witnesses, but in the impeachment of a president, it's not worth the time. It's too much of an imposition. Again, I would argue that the imperative of calling judges and having a fair trial when we are adjudicating the guilt of the President of the United States is paramount. Now, we've always argued that the trial should be fair to the President and the American people. And yes, it's a big deal to impeach a president and remove that president from office. It's also a big deal if you leave in place a president when the House has proven that president has committed impeachable misconduct and is likely to continue committing it. Because there's no doubt, I think from the record, that not only did the president solicit Russian interference in 2016, but solicited Ukraine's interference in the upcoming election, solicited China's interference, as my colleague just said, had Rudy Giuliani, his personal agent, in Ukraine doing the same kind of thing just last month. And Senator, in response to that question, isn't it dispositive that Giuliani, the personal agent of the president, is running this Biden operation rather than any department of government? Isn't that really dispositive of whether this was policy or politics? And I think the answer is yes. Giuliani's made it abundantly clear. I'm not here doing foreign policy. That's the president's own lawyer. I'm not here to do foreign policy. Now, Professor Dershowitz just made a rather astounding argument that an investigation of Joe Biden that is unwarranted, unmerited, suddenly becomes warranted if he runs for president. Now, he posited that in the president's second term. But it doesn't matter whether he's in his first term or his second term. An illegitimate investigation of Joe Biden doesn't somehow become legitimate because he's running for president unless you view your interests as synonymous with the nation's interests. I think it's the most profound conflict for a president of one party, whether he's running for re-election or not, to suggest that all of a sudden an investigation of a leading candidate in the opposite party is justified because now they're running for president. I mean, you really have to step aside from what's going on to imagine that anyone could make that argument, that running for office, running for president now, means that you are a more justified target of investigation than when you weren't. That cannot be. That cannot be. But that's essentially what's being argued here. To conclude, Senator, the case for witnesses in a presidential impeachment where either on the one side you remove a president or on the other side you leave in place a president who may pose a continuing risk to the country is far more compelling to take the time to hear from witnesses than a corrupt Louisiana judge who only impacts those who come before his court. All of us come before the court of the American people.
Thank you, Mr. Manager.
Mr. Chief Justice.
The senator from Montana.
I send a question to the desk on behalf of myself and Senators Langford and Senator Hawley.
Thank you. Excuse me. The question from Senator Daines, Langford, and Hawley is for counsel for the President. Over the past 244 years, 8 judges have been removed from office by the U.S. Senate, but never a president. The 8 judges have been removed for bribery, perjury, tax evasion, waging war against the United States, and other unlawful actions. How do the current impeachment articles differ from previous convictions and removals by the Senate?
There's an enormous difference between impeaching and removing a judge, even a justice, and impeaching and removing a president. No judge, not even the Chief Justice, is the judicial branch. You are the head of the judicial branch, but there is a judicial branch. The president is the executive branch. He is irreplaceable. There isn't always a vice president. Remember, we had a period of time when there was no vice president. We needed a constitutional amendment. So there's no comparison between impeaching a judge and impeaching a president. Moreover, there's a textual difference. The Constitution provides that judges serve during good behavior. That's the Congressman Schiff standard. And it's a great standard. We wish everybody served only during good behavior. But the Constitution doesn't say that the president shall serve during good behavior. The big difference is the president runs every 4 years. And the public gets to judge his good behavior. Judges don't run. And so there's only one judge of the good behavior, namely the impeachment process. And so to make a comparison is to make the same mistake that when people compare the British system to the American system. We've heard a lot of argument that we adopted the British system by adopting 5 words. and high crimes, other crimes, and misdemeanors. Yeah, those words may have been borrowed from Great Britain, but the whole concept of impeachment was not. First of all, impeachment no longer exists in Great Britain, but when it did, it only operated for low-level and middle-level people. All the impeachment trials that have been cited involve this guy in India, this guy in the commerce, this guy here, this guy there, utterly replaceable people. The British system, on the other hand, you can get rid of the head of state, the head of government, rather, by a simple vote of no confidence. That's what the framers rejected. The framers rejected that for a president. And so the notion that we borrowed the British system has it exactly backwards. We rejected the British system. We did not want the president to serve at the pleasure of the legislature. We wanted the president to serve at the pleasure of the voters. Judges don't serve at the pleasure of the voters, so there needs to be different criteria and broader criteria. And those criteria have been used in practice. For the most part, judges have been impeached for criminal and removed for criminal behavior. But take an example that was given. If a judge is completely drunk and incapacitated and cannot do his job, it's easy to imagine how a judge might have to be removed for that. But the president, there's an amendment to the Constitution, the 25th Amendment, specifically providing, because there was a gap in the Constitution. And please, members of the Senate, it's important to understand your role is not to fill gaps that the framers deliberately left open. Good arguments have been made why it's important to make sure people don't abuse their power, people don't commit maladministration. But the framers left those gaps. Your job is not to fill in the gaps. Your job is to apply the Constitution as the framers wrote it, and that doesn't include abuse of power and obstruction of Congress. Thank you.
Thank you, counsel.
Mr. Chief Justice,
The senator from Delaware.
I send a question to the desk for the President's counsel.
Thank you. The question from Senator Coons to the President's counsel is this. The President's brief states, quote, Congress has forbidden foreigners' involvement in American elections, end quote. However, in June 2019, President Trump said that if Russia or China offered information on his opponent, quote, there's nothing wrong with listening, end quote, and he might not alert the FBI because, quote, give me a break, life doesn't work that way, end quote. Does President Trump agree with your statement that foreigners' involvement in American elections is illegal?
Mr. Chief Justice, Senator, thank you for the question. I think Congress has specified specific ways in which foreigners cannot be involved in elections. Foreigners can't vote in elections. There are restrictions on foreign contributions to campaigns, things like that. When the whistleblower originally made a complaint about this July 25th call, and that was reviewed by the Inspector General for the intelligence community, he framed that whistleblower's complaint and wrote a cover letter framing it in terms of those laws. And he said that there might be an issue here related to soliciting foreign contribution to a campaign, a thing of value, foreign campaign interference. That was specifically reviewed by the Department of Justice. The Department of Justice concluded that there was no such violation here. So that is not something that is involved in this case. President Trump's, the interview with ABC that you cited, does not involve something that is a foreign campaign contribution, something that is addressed by the laws passed by Congress. He was referring to the possibility that information could come from a source. And I think he pointed out in that interview that he might contact the FBI, he might listen to something. But mere information is not something that would violate the campaign finance laws. And if there is credible information of wrongdoing by someone who is running for a public office, it's not campaign interference for credible information about wrongdoing to be brought to light, if it's credible information. So I think that the idea that any information that happens to come from overseas is necessarily campaign interference is a mistake. That's a non sequitur. Information that is credible, that potentially shows wrongdoing by someone who happens to be running for office, if it's credible information, is relevant information for the voters to know about, for people to be able to decide on who is the best candidate for an office. Thank you.
Thank you, counsel. The majority leader is recognized.
Mr. Chief Justice, I recommend we take a break until 10 p.m. and then finish up for the evening.
Without objection, so ordered. Okay.
All right, so they're in recess, but I don't want to keep streaming this anymore, so I'm gonna turn it off. There may or may not be another stream coming this evening here, about 15 minutes. If I turn that on, I'm just gonna leave it on all night. I don't care if it goes for 15 hours with a blank screen. It won't be 15 hours. You guys know what I mean. The whole time I'm sleeping. But see, it says postponed. I already went through all this, didn't I? I think I showed you guys all this. But they're not. See, it was supposed to happen at 9 a.m. today. And it says postponed. But on the House.gov homepage, it says 10 p.m. So if they do it at 10 p.m., I'm like, what are they trying to get away with? What are they trying to hide? So, I'm just going to end this stream here. I wanted to be able to catch the end of things today because I haven't caught the end of the hearings, the trials the past couple days, but honestly, like, I guess people are just kind of over it. Like, you know, Carolyn's coming in and giving me some pity views. I love you, Carolyn. You're wonderful. And I've had a few other people come in and, you know, chat for a little bit and everything. But otherwise, it's like, we all know what they're saying, right? So if there's any kind of big revelation with it, I'll let you guys know. But I don't know, honestly, if I'm going to even... I'll see what they're doing, like, tomorrow with the hearings, the trials. But if there's something more interesting, I'm just gonna stream something else because I'm sick of them. Oh my gosh. But thank you guys for watching and everything. I did want to be consistent with doing these trials. I didn't want you guys to think that, like, I was just streaming, you know, just the arguments against Mr. Trump and then didn't stream any of the arguments for him. So, I don't know. We'll see what comes next after this. Since they've had their back and forth, I guess next they're going to be voting on the final, you know, decision on if they're going to allow any more evidence or witnesses because they're still arguing about that back and forth. So, they'll probably do a vote on that, I'm assuming, and then after that they'll go further into the trials? I don't know. So we'll see. Thank you guys for watching so much. I hope you have a wonderful evening or day if it's daytime wherever you are. And make sure you're subscribed and hit the like button or the thumbs down button, whatever floats your goat. Check us out on Twitter and Instagram at growtheinfo, and our website, growtheinfo.com. You can find all kinds of good information. Thank you guys so much for watching, and have a wonderful evening. Let me put it on the end screen so you can see our stuff there. Okay, have a good evening, everybody.